reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause. And with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael Berg for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner also from the ATF.
All right, and to both parties, thank you. I appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge.
Just want to highlight one issue for the court because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript, that's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge.
You know, the state has received the proposed redactions and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right, well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right, does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence, except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles really at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102B3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law and that's conforms with 104B. That's our intention unless the court or counsel moves to close the hearing. So in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so. and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps: admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because I want, if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there's a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it. And let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
I just need some other tables besides 3 so we can try.
All right, if you all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on. And if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up because that could cause a delay. I just want to knock this out first. Yes. Where would that TV go?
Kind of along that back wall. We've done that in trial before.
If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view. And then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right. Yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
I need them to actually plug in their HDMI.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take a look here. I appreciate the parties' patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
We're working on it right now, Judge. Yes.
All right, and on the screen monitor here, it looks like something came up.
It's looking.
All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go.
You can get it if you want, or if you want to just use this.
Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed. And then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did,
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on the job training or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
my best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a FARO certified. It's a 3D FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I've been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about so as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant L. Scholes requesting that I travel to St. George.
Who is Sergeant L. Scholes? What agency is Sergeant L. Scholes with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant L. Scholes, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride, and myself, and the 2 pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI, as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device. And so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, following after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
You're just going to do the redacted version.
Thank you.
And that may happen a couple more times as we go through exhibits
I
because
understand.
of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, redaction of the video. And I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
That's correct. Yeah.
So we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Oh, that's probably right.
It's has no audio, so we would like to admit and publish it at this time.
All right. State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with that's like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famawina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning. And then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Falmina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, You have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell it was the St. George court office, courthouse there. They met and discussed briefly. I was going to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained.
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt? For the same
You may.
purpose.
All right.
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down.
It's actually just
Sorry, Judge, if I can just have a moment.
You may.
I apologize, Your Honor. I misspoke. It's not 14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, states Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
If I may approach.
You may. Thank you. All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up and fired. It still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Scholes, well, now it's Lieutenant L. Scholes, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview.
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first. And if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor.
Welcome to the live stream, everybody. I am your host, Colin, Project Constitution. So today is day 4 of our live stream. We have a couple other guest hosts joining us today. They are running a little bit late, so we're going to start off just me today. I guess the best thing to do would probably be to start off with yesterday. The key takeaways that we got from yesterday were, one, we got video of let me pull it up actually. That way I can show you guys. Share this tab here. Okay, so yesterday we got video from inside of the Washington County Jail where they allege that this is Tyler Robinson here. I'm going to keep the sound off because it's not important. But this is from inside the interrogation room of the Washington County Jail. Now they are claiming that this is Tyler Robinson. And I'm not necessarily saying it isn't. because, you know, he obviously, we know he turned himself in, and the family hadn't disputed that fact. But I just want to point out that even in this video, they don't have a clear picture of Tyler Robinson. Even in this video, when he goes into, you know, as he enters the room, his head's down towards the camera and he turns, so you still can't see a face. Even in this video here, you cannot see Tyler Robinson's face. So this state has zero video proof of him at campus or UVU. They have zero proof that it's his car. And now they have zero proof that he was even the one that turned himself in, for all we know. But check out this video real quick. Let's go. It's coming up. Should be any minute now. I don't know why it's taking so long. I didn't think it was this long a wait. Okay, here it comes. All right, so you see that? He's facing away from the camera, so you can't even see him. You cannot even see his face in this video. So once again, they still have zero evidence that this is, that, you know, they have zero evidence that this is Tyler Robinson. They have zero evidence that Tyler Robinson was ever on the scene of UVU whatsoever. And we contend he wasn't, by the way. He was not. His family says he wasn't, and we do not believe he was on the scene of UVU. Matter of fact, both those people, that stairwell video of the suspect in the stairwell or whatever, the one wearing the maroon shirt and the one wearing the black shirt, I actually think that they're two different people, and neither one of them are Tyler Robinson. And also of note that in the car, the Challenger that we do see that they're saying is his, but it doesn't look like his, there are actually 3 individuals in that car. So, and a bald guy driving. So Tyler Robinson's not bald, and who are the other individuals that were in the car? So we have that. And then we also got we have video today of Tyler Robinson being taken into the courtroom in an armored Bearcat or whatever. So this is video of Tyler Robinson arriving at the courthouse this morning. Okay, so we had that, and then we also know that Erica Kirk's attorney yesterday was opposed to the defense and the judge blocking the video testimony of Lance Twiggs from being shown to the public. She even had her attorney even stood up and made an argument of why it should be seen to the public. And I actually agree with that attorney. You know, we deserve to see all the evidence. And you know, and he made a good point. You know, if you, by not showing that, by hiding evidence from the public, what you're doing is you're creating a distrust with us in the legal system. The public will distrust what's going on in the judicial process, will distrust the courts. And that's 100% true. Also of note is yesterday, and we heard this from our courtroom insider, Billy Webb, which, by the way, unfortunately, we don't have her today. She wasn't able to make it in. They only let 14 people in at a time, and she was number 17. So she did not make the cut today to get into the courtroom, so we're not going to have her testimony. But we did have her testimony yesterday, and one of the big exclusives that she gave us afterwards is that Erica Kirk actually had an emotional breakdown in the courtroom with her fake crocodile tears towards the end. Because when her lawyer was making the argument to, for the Lance Twiggs testimony to be seen with the public, and it didn't look like it was going to go her way. It seemed like the judge was going to rule the other way and redact things. Then Erica Kirk then decided to start doing her boohoo crying routine, dabbing her eyes and shaking like she's crying. So she did all that crap in the courtroom, putting on a massive performance for the judge, basically, just in order to try to persuade him, or to to get his sympathy and get him to rule the way that she wanted. Once again, she got caught using emotional blackmail to try to manipulate and get what she wants from people. So I'll let you hear what Billy has to say real quick. What's up, Ryan? You want to hop on, bro? I'll send you the link. There's no sound. Hold on. I don't know why there's no sound. Let me figure out what's going on here. Sorry about that, guys. Let's try that again. Share audio. Yep. Yeah, I'll send you the link, Ryan, if you want to hop on with me. That'd be cool, bro. You don't have to stay all day. Just stay as long as you want. Okay, cool. I'm about to send it to you now. Yeah, that's cool, bro. just sent you the link to X, Ryan.
And me being in the third row, I only even caught a
Sorry
glimpse
about
of
that.
her face like
I
once
thought
or
I had it
twice,
on
and it
screen,
was
but I
in,
didn't.
in
I pulled a
between
bear and
recess or like in between sessions, like walking out for recess, walking back in after recess. But she did get pretty emotional towards the end. And I'm
oh
not
my
sure.
God, really?
She like how you
Did she have the tissue?
her, that is exactly like to the T. Like take her out of that bit, out of any sad video that you've seen of her, and put her in real life. That is exactly how
What's
she
up,
is.
brother?
Like, she looked like she was really
What up,
scared
brother?
towards the end. She was hugging the woman to her right, which I can only assume was maybe her sister. I did not. So Charlie's mom is to her left.
It wasn't
Charlie's mom-
Stacy Sheridan?
No, it wasn't Stacy Sheridan. Stacy Sheridan was sitting, I believe it was 3 people away from her. What made it weird to me was like the timing of the crying. And I was trying to kind of piece it together because I'm always trying to play devil's advocate. I don't want to be like, oh, she was crying, you know? I was literally just like, why? Like, okay, yes, obviously, like when you think about everything, there's reasons, but it was like really weird timing because it was the most boring. You guys watched it, right? You were there the whole time?
Yeah, towards the end, you're talking about she was crying when they were discussing about Lance Twig's testimony and whether to keep that part in or out or whatever.
Yes, that's like she started crying, and I don't mean like sniffling and like wiping a tear. I mean she was like I could see the back of her, and she was like shaking, and the woman who I believe to be her sister was like rubbing her, hugging her constantly. At one point, Charlie's mom came in from the other side and was also comforting her. Yeah, it
Oh
was just
my
like an
God.
interesting time for the crying, I guess, in my opinion. I don't
That
know.
woman is so performative, man. Yeah, they were trying to get their way, obviously, which, you know, I actually agree with what his lawyer was saying. You know, her lawyer, you know, it needs to all be public because otherwise it will create a distrust with the judicial system. So I agree with what her lawyer was saying, but I think the emotion, all those emotional crocodile tears, I think that was just try to get the judge to rule the way she wanted the judge to rule. Emotional. Once again, she's using emotional blackmail.
Yeah.
All right. Yeah. So that was from yesterday. That was Billy Webb, by the way. Make sure you're following her. She was inside the courtroom with us yesterday. Anyway, we got Ryan Matta joining with us, man. Ryan Matta.
What's
Be
up,
sure
brother?
to follow him on X. I love
Thanks for having
Ryan's
me.
work. Yeah, man. Thanks for joining me. Appreciate it.
And I just want to say you're doing such a great service, man, covering this. The amount of dedication and effort it takes, I want your audience just to hear this from me, to stay on one specific topic for this extended period of time. I mean, that takes serious, relentless dedication, bro. And you've been taking daggers from the TPUSA team. Like you came out of nowhere. And then all of a sudden, you're like TPUSA public enemy #1 because of your coverage of this trial. So God bless you, man. Thank you for staying on top of it, man. I'm excited to be here. Thanks for having me on.
Yeah, thanks. Yeah, I mean, as you saw, there was a lot of people in the beginning that were covering it, you know, just because it was new and fresh and, you know, of course, people making money of it and stuff. But, you know, the real ones are the ones like you and me and Candace and Barron and people like us that have been covering it through this whole time. You know, we haven't stopped. You know, I in particular have not covered anything else. This is all I've covered since, you know, Charlie was killed. And like I said, this is like my mission. You know, I don't know if you heard this, my story or not, but actually I was, after Charlie died, I had two vivid dreams where God came to me in my dream and basically led me to investigate this. He kept telling me something is not right. It's not what it seems, leading me to investigate this. And like, this is the first time in my life, honestly, that I really feel that connection to God, and I feel like this is my mission. That's why I don't care. They could send me as many cease and desist as they want. I don't give a shit. You can sue me. I don't give a shit. I'm not going to stop. You can demonetize me, which they've been trying to do relentlessly on here, attacking my channel with bots and everything. I don't care. I'm going to keep doing it regardless. You can even get my channel banned and I will just start a new one. And I don't care if I'm just talking to 3 people. I'm going to still be doing this. That's what it's about. This is, I will not stop until we get justice for Charlie, man. That's what it's all about.
Man, God bless you, bro. Yeah, like you said, this is all you do. And that's where I'm really going. Like, I report on a ton of different stuff, whether it's corruption, the war, Gaza. I mean, you name it, I'm all over the place. But you just laser focused on one specific topic every day. But you have to be. And you guys, like you, Candace, and Barron, and a few others. I mean, Sam Parker's pretty dialed in, and there's Ian Carroll and a few others. But you guys are like laser focused right over the target and just consistently beating that drum. And that's what's really continued to keep the support in the hearts and minds of the masses. Like, you guys didn't let this go. So when does this trial start, and how much longer do we got before we can start watching what's going on here?
Yeah, it was supposed to start at 11 here, so they're actually 9 minutes late. So it should be starting any minute. We're just waiting on them to get started here.
Awesome. I just didn't want to make sure we weren't yapping and gonna miss anything. So I'm pretty excited about this, man. This is the first day that I get to actually sit here and focus in and watch everything live as it's happening. So I'm excited to be part of this, man.
Yeah, hopefully it'll be better than yesterday. Yesterday, they were just basically arguing the whole time. We really didn't get anything new yesterday. Well, actually, that's a lie. We did get a couple things new. We got the video footage of allegedly Tyler Robinson turning himself into Washington County, where they showed a short video of him inside the interrogation room. But with that video, once again, and I'm not, like I said, I'm not saying that I don't think it's Tyler Robinson, because obviously we know he did turn himself in, and we know the family hasn't contested that he turned himself in. But my point is, even in that video that they showed of him in Washington County Sheriff's Office, we still don't have a clear picture of him. You can't see his face. His back is to the camera. So even in that, they have zero footage, absolutely zero footage to prove that Tyler was anywhere near UVU, had anything to do with this. They can't even prove that he was the one that turned himself in the Washington County Sheriff's Office. That's how wild this is.
I thought there was no video evidence of him turning himself in. Wasn't that like some big story when this first started to break? Like, they're like, oh yeah, we just happened to record over the videos 3 days later. And it's like, wait, don't you guys save the videos for like a year or something normally? And like, no, we just dispose of them, 24 hours after, one of the most famous assassins in all of American history just turns himself in, I guess.
Yeah, well, that is true. There's a difference though. They've said they've had, and what they showed yesterday was the video footage from the interrogation room, like the footage looking into the interrogation room. They had that footage the whole time, but they were refused to release that footage because they said it was part of the investigation. Now, the footage that they said that they deleted by accident or whatever, that was the surveillance footage of him walking in, because they said, okay, well, if you're saying that that's part of the investigation, just showing him walking in the courtroom is walking in the building, there's nothing in that footage that you could say needs to be withheld, so show that. And that's when they say, oh yeah, we deleted it, we don't have it anymore. And of course, the other thing is the body cam footage too of all the cops. It's not only is it Utah law, but it's also their policy. So it's their policy and Utah law that anytime one of the officers interacts with a member of the public, and not talking like, they don't even have to be a suspect, just anytime that they interact with a member of the public, and they have a body cam, they're supposed to turn their body cam on. So not one of them, because I personally set the FOIA request for all the body cam footage, of the officers in there that day to see if any of them caught, video of Tyler Robinson. And they said no requests, no video responsive to your request or whatever, meaning they don't have it. So you mean to tell me that all the officers in Washington County Sheriff's Office, all in unity, in unison, all together, just decided on the person turning himself in on the biggest, basically murder trial since JFK or whatever. They all in unison decided to break protocol, break their policy, and break the law, and not turn their body cameras on.
Yeah, not like the probability of that is probably 0.00001%. No way. Not even feasibly possible. And I can't believe that they don't just have to, like your body cam. Why isn't it just on 24/7? Unless you're going into the bathroom or you're going into a private area where you'd be expecting like, hey, yep, my body cam. Or at this point, like the technology is so advanced, there should just be a hook outside the bathroom. You leave your body cam stays on 24/7. You just just unclip it, clip it on the hook outside the bathroom, go into the bathroom, do your business, come back out, and it stays recording 24/7. I don't think they should ever be off. I mean, the battery technology we have on these things can last for 48 hours, probably even 72 hours now, and just the really tiny batteries. I don't understand, but man, you're making me jealous. Now I want a cigarette. I don't even smoke anymore, but damn, that looks good, man. I actually think they're not as bad for your health as we once thought they were, to be honest.
Yeah, they're not. Honestly, I think they're better than vapes, to be honest with you.
Oh, 1000%, bro.
Yeah, like vapes do all kind of weird shit with your lungs, man. Stuff we don't even know, honestly, yet.
I smoked for probably from the time I was 12 or 13 to the time I was probably, man, my son had to have been probably 6 by the time, like once my son started getting old enough and he could see that I was smoking, I felt really bad, that I'd sneak outside, and smell like cigarettes around him. So I switched to vaping. And in probably a year, like, you'd wake up in the morning and you cough up stuff, you kind of got that raspy voice in the morning when you wake up, that smoker's cough, if you will. But
yeah,
I switched to vaping, the smoker's cough went away. But I went from going to the gym and working out and I'd be like, ripping weights and go outside as soon as I was done at the gym and I'd smoke a cigarette, nothing of it. Right. When I started vaping, man, I got to the point where I would run up a flight of steps, like 1 or 2 flights of stairs, dude. And I'd be like, I don't know what the hell was in those vapes, man, but that shit is nasty, dude. It's so bad for you. So unhealthy. And it makes you depressed. And it made me like, I don't know how to explain it, man. But over a long period of time, I could feel that those vapes were doing so much damage to me. And that's when I started to do got the old Tucker Carlson Alps over here. I got one of those in right now. Got some of the old school Cougar. I think that's what this is. I don't really like the Grizzly, but I think that was like $2 or $3 a can. That's what I switched to. But I like the cigs, man. I'm not a hater on the cigs anymore.
Yeah, definitely. Yeah,
so what are we looking at here on this trial? Is it? Are you waiting for it to just go live? Is the stream going to switch, or how do we know when it's going to go live?
Oh, you know what? Oh shit, I had it paused.
I saw that. That's why I wanted to make sure.
Oh fuck. I was wondering why. Okay, well, it still hadn't started yet, so we're good.
Okay, cool.
Thanks for noticing that. I didn't catch that, but yeah.
Yep. I just wanted to make sure you guys weren't going to get I figured the live chat would keep us updated anyways, but.
Yeah, definitely.
Man, I saw you had what was it, like 7,000 people in here or something the other day or something crazy like that?
Not yesterday. Yesterday, honestly, yesterday I had the stream cut out in the middle, so I had to restart the stream, so it killed I had to start from scratch again. But the day before that, we had 88,000 live concurrent viewers in here at one time.
Damn, bro, that's awesome. Good for you, man. You deserve it, man. You absolutely do, man.
Third biggest excellent live stream that day. We beat out Turning Point and Andrew Colbert and Turning Point. We're both doing streams as well. We beat both of their streams out of the water.
Let's go, buddy. Good for you, man. And you cover this from start to finish, huh? As soon as the trial starts, you're staying the whole time, huh?
Oh yeah. And I'm kind of regretting. Now I was thinking about going in person to the preliminary, but I was like, nah, there's probably not going to be anything going on major. I'll wait till the trial. But I'm kind of regretting it now because we've had a lot of cool stuff come out in this preliminary. So I kind of wish I was there in person, but I'll definitely be there at the for the actual trial. I do plan on going there in person for that.
Are you
Here
going?
we are. We're getting started.
Are you going to
I think.
stream from there, from outside the trial?
Oh yeah, absolutely, absolutely.
And you probably got reporters on the ground there bringing you stuff. I saw the video from yesterday.
Yep. I got Billy. Well, Billy Webb was there on the ground. Although unfortunately she didn't make it in today because they only let 14 people in a day. That's it. So and you have to, in order to get a seat, the only reason to get it, the only way you can get in there is if you camp out there at night, basically. So she got there early this morning at like 4 a.m. and she still couldn't get in. They only let 14 people in and she was number 17, so she missed it by 3 people.
No way, dude.
Yep.
Damn, did she
So
stay and
that's,
hope somebody got sick, or did she just, once she saw that she was 17, she just left?
She just left. Yeah, once you're out, you're out. No, they allocate that number for the day and that's it. Nobody else is getting in.
Damn, that's
which
crazy,
sucks.
dude.
But yeah, so we had her the day before yesterday, which was good. Don't have her today, and then she's going to try again on Friday to get in there. So we'll see. Hopefully we'll have her on Friday as well. Jesse on Fire is supposed to come on and do the stream with us on Friday.
Sick, dude, sick.
Kelvia is here, by the way. I don't know if you met Kelvia or not, but Kelvia, welcome, Kelvia. She did the stream with me yesterday, because Convict and Conservative, he had something come up with his family. He couldn't do it yesterday. But she is actually a former Turning Point Action employee that was fired in the mass wave of firing. She's actually the only Turning Point Action employee that was fired in that mass wave of firings. She worked directly with Tyler Boyer.
Oh boy. Oh boy, this is gonna get good. I'm so excited. What was it like?
Yeah,
I'm excited. I'm excited. I thought it was Andrew Tate on the screen when I first opened this up. I said, "Is that
would be really
Andrew
badass.
Tate? Is that?" What'd you say?
I said that'd be badass if Andrew Tate was on one of Project Constitution streams. That'd be epic,
I
wouldn't
would
it?
laugh. Oh my gosh.
Hey, never know, man. One day.
Dude, you're on a
Project,
roll,
if you have
brother.
his number, you got to give that to me.
Yeah, I don't have his number yet.
Hey, he's on our side though. Did you know that?
I definitely think he is.
Definitely, absolutely.
Yeah, he's definitely on our
100%.
side.
Yeah, he's ride or die Team Candace for sure.
Oh,
Candace
yeah.
is one of the only people that completely went to bat for him when he got taken out there right in the beginning. So
Yes, she took the time to read through his case.
yep. So what did you do at TPUSA?
I was a field representative, so I basically just kind of represented the brand and the company. We're more the political arm, so it was a 501c4. So we actually got to endorse candidates and canvass and basically get people in office around Arizona.
Really? And then how'd that work out with Katie Hobbs? How the hell did they drop that ball?
I wasn't there then. I was only there the past 2 years. So, but they're big on Andy Biggs right now. That's their candidate. Go Biggs or go home. We're trying to get him in there for governor.
Yeah, JTT just tweeted out and he says, or asked a comment on YouTube. He says, "Do you guys see that Andrew is now asking questions about the case?" Smiley face emoji. I said, "Yeah, about time."
Yeah.
Right? We wish we would have had all these big
He
names
said
in the
that-
very beginning.
Andrew said that he straight up knows. Did you hear him in that one interview? He says, "I know who killed Charlie. I just have to be careful with what I say."
Yeah, he like paused. He's like smiled for a minute. He's like, It's like the pausing is me just trying to debate how to stay alive and answer this question.
Exactly. Yeah, these
That guy's
people
got a
aren't
big voice,
stupid.
man.
I agree. Yeah, they know what's going on, man. They just they're afraid to speak out. I think
Yeah, and when Andrew speaks, I mean, he's got a massive monumental following, right? And he knows, and they know where he sleeps, they know where he lives. He's got probably 5 to 10 children right now at this time, So the Andrew Tate 6 years ago, who probably only had, maybe 1 or 2 children, now he's got 10. I mean, that's, as a father, I'm a father, it changes the way you interact, and these threats, obviously, they blew Charlie Kirk's head off, you know, on national TV for a reason. They wanted to send a message that it doesn't matter who you are, how big you are. When we want to take you out, we're going to take you out, and we're going to do it publicly right in front of your wife and children, right? For the most part. So, you know, as much as people hate on the guy, I think, you know, I don't know if any of us would be doing anything different if we were in his shoes or not. It's hard to say.
Yeah, definitely.
No.
I think
he-
that person was referring to Andrew Colbert, though. I think that's who they're referring to, because I think
Oh.
last night he did a reaction video where he was basically, let me see if I can find it real quick, but he did a reaction video where he's basically you know, asking questions now.
Andrew Tate was kind of the equivalent to Charlie in some ways, just completely different messaging. But Charlie agreed with him. Charlie said, you know, is he lying though?
Yep. I've always been a fan of Andrew Tate, huge fan of his, actually. You know, that guy pretty much, he saved my life in many ways, you know, the mindset that I had, the way that he woke so many of us up and got our heads out of the matrix. And, you know, and we really are hurtling towards this world where, you know, America's turning into a third world country. In the aspect of what is a third world country by design, it's where there's no middle class, right? And that's what they're doing, is they're gutting our middle class. But let's check this out. Go ahead.
Whatever, anything except for Tyler.
Yeah, they want to have, you know, they want to get rid of the middle class. They want us to all be slaves, and then the super elites that rule us all. That's what they want. But all right, so yeah, this is what we were talking about, the Andrew Colbert video from last night.
I feel like I've been dealing with so many crazy accusations, either leveled at Erica or myself or the organization or whatever, anything except for Tyler Robinson in this process, that I haven't gotten a chance to articulate clearly what questions I still have outstanding that I want answers to. So here we go. Who knew what when? That's right. There is a lot of indication online that other people knew something was going to happen that day on September 10th. They posted on social media about it in really, really creepy ways. And none of those people have been held accountable. And I want to know why and what did they know and when? Another question I want to know the answer to is, was Lance Twiggs more involved than we currently know, right? We know that he's been given limited immunity for his testimony. It's going to be video testimony in the preliminary hearing. But how much did he know, and how much did he radicalize Tyler Robinson?
Then why have you been railroading Tyler Robinson this whole time, dude? They've been saying Tyler Robinson did it. He's a lone shooter. They've been saying that this whole time, that he's a lone shooter. He's a lone shooter. Tyler Robinson did it alone. And now they're going to try to just swap it up and say, oh, well, Lance Twiggs might have had something to do with it.
They know they have no choice now but to get on the bandwagon.
Yeah, honestly,
Because
I think
they
that's
know
what it
that,
is.
that mountain. Yeah, that mountain of evidence they claim that they had is just non-existent.
Oh, yeah, they see the writing on the wall. I think, honestly, I think that's why Blake Neff went in did that Spaces 2 nights ago where he got wrecked. You know, I think that part of that is because of that, too.
And I encourage everybody to go check it out. There's a Turkey Tom YouTube video where one of their friends that would hang out with them in their apartment seems to indicate that it was a really manic, disassociative, sort of morally corrupt, bankrupt environment that Tyler Robinson was living in. And Lance Twiggs seems to be the source for a lot of that. So did Tyler Robinson just do this crazy thing all on his own? Or did Lance Twiggs put him up to it? Was he a co-conspirator? I want to know that, because if it comes out that
Or did Tyler Robinson not do any of it at all, and Lance Twiggs set him up, and he's a patsy?
he was a co-conspirator,
Exactly.
I would love to see him held accountable for that and not be granted any immunity whatsoever. Another question I have is, where did Tyler Robinson go immediately after taking the shot, running off the rooftop and tossing the gun into the forest? Where did he go? We know that the state has evidence that he was back on campus that night into the wee hours of September 11th, but where did he go immediately after? That's a big question. One of the questions that is really tough for me is, why were those darn rooftops so accessible? First of all, why set up a building where you can just like go over a railing and get on a rooftop? That's one question. Why were there not cops planted out there? That's another question. And why were there not people spotting those rooftops? Now, you might say, well, gee, Andrew, Turning Point had its own security. Well, guess what? The way you work with campuses is you only get to have immediate vicinity jurisdiction around the person that you're protecting. So I don't know what the exact distance was, but it's essentially like, let's say 30 feet around Charlie's perimeter was what our personal private security was able to take care of. So we were relying on campus PD to monitor the ingress, egress to the area and the rooftops. I want to know, why were they so accessible? And I know that I take a bunch of crap for this, but I want to know more about the rounds, the ammunition, the 30-06 rounds. I know that the comments are going to be filled with, it was not a 30-06, blah, blah, blah. Well, the ATF report confirms that the medical examiner confirms that it was. So I know that won't be enough for anybody, or at least a lot of people, but bear with me. Let's assume it was a 30-06. That is a powerful round. How old were the rounds? Were they hollow tip? Were they full metal jacket? I want to know everything. The point is that they broke into a bunch of different pieces inside Charlie, and that's partly the explanation, but I would love to know more information about that myself. And finally, was there a larger network? We hear about, armed queers of SLC. They took down a bunch of their social media immediately after. I want to know, was there money? Was there outside sources? Were there more people that were involved in planning this? Still have a lot of questions. Thankfully, we're getting a lot of answers too in the preliminary hearing, and I hope more come out.
You know what it sounds like to me? It sounds like that the Tyler Robinson narrative is such fed slop, it's became so unbelievable that obviously Lance Twiggs was in on this entire time, right? So it almost seems like now they're like, well, maybe we can spin this. Maybe we can serve up Tyler and Lance together, and we can paint a narrative that's almost somewhat plausible and believable for the average, retard who's just going to sit over there and drink the MAGA Kool-Aid and the Fed slop. So maybe how do we spin this and make Lance Twiggs, basically guilty and involved in this? And can we make it believable? And then we're just going to Epstein both of them or let them both get away. I don't know.
That's what I think. Absolutely. By the way, just to remind everybody, hang on one second. Just to remind everybody, if you want to send us a super chat or buy me a call, I'm not monetized on YouTube, but you can send a buy me a coffee right there. Scan the QR code in the bottom right-hand corner of the screen. And leave any kind of donation amount you want. You can leave a comment, and we'll read your comment out live on air like a super chat during the breaks. So if you want to support the stream, you like what we do, I'd encourage you to do that.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Miss Erica Kirk. Sorry. Good morning, Miss Kirk. All right. As you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer, and I invite you to do the same. Every person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense. All right. As we begin this morning, I wish to, I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so. And I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process. And I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media believes the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. Maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we of course support that.
Thank you. All right.
Your Honor, the state would like to be heard on the briefing briefly,
For,
the briefing that was submitted last night.
all right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery, and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit. to that. Is that
I
correct?
do, and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record,
Okay.
and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Why'd they mute the microphone? What's going on here?
And a few people in the comment section were asking if you could raise the volume on the judge a little bit when you
Your
get a
Honor,
second.
And then. let's just
I
see
think
what
the
court
volume's all the
is
way up.
referring to.
Let me check, but I think it's all the
Well,
way up.
I'm asking, did
Yeah,
you
it's all the
receive a
way up.
copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the
Read the
audio. So I
Patsy.
brought that to the
Yep.
state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is what I'm going to next. Mr. Ballard?
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here in this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page based on what the court just said.
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second, we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
What clip are they talking about? Is
Your
that
Honor,
when
just
he
to make
actually
sure
took the
that
shot?
we've got that correct.
That's
The additional
the last
redactions would be
tweet's
27 minutes and
video
18
testimony
seconds
where he's being
to
where he's
27
being
minutes
coached
and
or being
25
led
seconds.
what to
Correct, for the
say.
first one.
Where the detective, they admitted that the detective is leading him, leading the witness,
And
leading him
then
what they
28
want
minutes
him
and
to
11
say.
seconds to 28 minutes and 18 seconds.
Yes.
It's going through the
And Your Honor,
the
while
text
we're talking about
messages and the
additional
Discord
redactions,
chat.
let me approach.
It's basically him just saying Tyler confessed or whatever.
When Your Honor made his ruling
reading out Tyler's
yesterday
confession.
afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based
Yep.
on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence. And I would like to be able to point the court to those. We've got two brief portions that we believe don't implicate those concerns and should not be redacted. Does Your Honor have the transcript?
I do.
In front of you? Okay.
It's all hearsay anyway. It shouldn't be allowed at all, but Utah, that's why they chose to kill him in Utah, because Utah has this hearsay rule. One of the many reasons.
What's the hearsay law?
They allow the hearsay testimony.
Well, first of all,
in court
at the
hearings.
very, very bottom of page 10, beginning with the
just say-
words, was he?
You don't have to have any evidence, just, based on what
And
somebody
then
else
over to
said.
page
Oh, well,
11,
somebody told me this.
down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant.
No, we
That's the
haven't
first
gotten
portion.
any of that yet, and
So
that's
going
what they're
back to page
arguing
10,
about how
I
much
don't
of that
see
we're going to
was
get
he
to
at the
see or not.
bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see. Right here. Okay, now I see what
And
you're
that's
saying.
the
I missed
point.
that. I was
That's
looking at
why
the
the
beginning of the
hearsay
line,
rule
but
comes into
I see your
place.
point.
They can just play this crap from
Okay.
Lance Twiggs, and the defense doesn't get to cross-examine him.
So
That's the whole reason.
Was he on page 10
That's where the hearsay rule
until
comes into place.
16, the timestamp 1646 on page 11.
Okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the fifth paragraph down, Mr. McBride stating, okay. And then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you. Yes, you may.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted redacted transcript, and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon. But from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript, which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
What pisses me off is the defense is trying so hard
Thank
to
you, Your
block
Honors.
the
Mr.
public
Novak
from seeing all the
recognized
evidence.
Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him. And then also it's very relevant to the enhancement that we have charged.
All right. Thank you.
If you guys haven't already, make sure you guys share this stream for Project
Anything further
Constitution and
before
hit
the
that
court
like
rules
button, guys.
on these two requests?
Thank you.
All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with was he, and ending at 1646 with the last word asking. After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. In right after 3255, where
All right.
Mr. McBride states, okay.
I see. Thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with okay, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at okay, until just before 3340, I'm sorry, up to 3340 may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well, that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note the defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case. And what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence. And Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions
too. Tyler
and
Robb,
then they immediately, it was the police that immediately released that
for the Lance
recording
Twiggs
to
video as well
the
that they're
press,
talking about
who
now.
then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate.
No, but you're leading the witness. You're leading him with what to say.
Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes
it wasn't Miranda.
continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors.
But what they
So
told
again,
us yesterday
it's hard to see
is
how Rideau has any
the
precedential
video
value.
of Lance Twiggs
And,
that they're talking about was
even if it
basically
did, the circumstances are completely different than the
making statements
from the
to Lance
types of
Twiggs and saying,
the types
or
of
asking him
statements
questions like,
that we're dealing with
did
here.
Tyler Robinson say such and such
The state
and
has
such
also
and such?
cited to several
And Lance
other
says
courts
yes.
that have easily distinguished
Tyler
Rideau
Robinson confessed to
and have
you?
made it
Yes.
clear
That's basically so
that
he's
there is no
he's leading the
blanket
witness.
ban
It should not
on
be allowed.
publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And the court, because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
at this time. Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kurtz's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kurtz's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kurtz's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But It was in the Skilling case, Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. Not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public, and the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on. And that is even more important to the victim representative's right to be able to be present and to observe these proceedings. Thank you.
All right, counsel.
Your Honor, if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like the transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleve below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stress what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that middle step is a meaningful one. And if the court were to decide that that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you were viewing. They want to see the evidence. And we understand you have to balance, but at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom.
Inquiring minds want to know.
For them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request, 16 point, well, so under the three factors or the three levels, admission to the court, publication to the gallery, and then publication beyond the gallery, what is the request for each of these exhibits?
We are asking,
They don't even know what they're asking for. What are we even arguing then?
It's such a joke, dude.
Your Honor, we are
real,
asking for admission. We are asking for publication within the courtroom, but not publication electronically on
That's bullshit.
to the electronic coverage in the courtroom or of these proceedings.
So they want to block the
we do want to
public
make
from seeing
clear
it again.
that once the exhibit is admitted, that the witness will be reading from portions of the exhibit. But again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Thank you. Just the court
Such a sham.
wants to-
Nothing says transparency like hiding all the evidence from the public.
Exactly.
Just for
And that's what they've been doing
clarification,
this whole case. That's
16.1
what
is the
it
text
makes me so
messages.
frustrated.
16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings?
And that's the thing, the stuff they're arguing over about
And this
trying
is
to
open
block
to all,
is
if you
stuff
wish
that
to
we've
weigh in.
already had released in
I
the
just want to
public
make sure that
already.
that's clear, because that wasn't
The
really
text
addressed in the
messages
briefing,
and the Discord
and it's a
messages,
factor. So I
that's
want
what
to
they're
make sure
arguing
that
over
that
hiding.
issue has been presented by the parties.
Yep, cat's out of the
If you
bag.
Public's
choose
already
to.
seen it. Yeah, exactly. The cat's already out of the bag.
Have they brought that up, Colin? That this has already been seen by the public?
They did yesterday. They haven't brought it up again today yet. The judge just mentioned that though. So hopefully, I mean, hopefully the judge gets that point.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears in that, in the information? Again, I'm just trying to create a record of what is out there from your perspective, so the court can consider that in its analysis.
They're way overcomplicating this.
It's like they're just playing by the seat of their pants. They don't even have a clue what they're actually doing. They're just like, how do we manipulate and spin this narrative? And it's just like they're just stumbling over their own words and stumbling over their own shit.
Yeah, they're just talking in
Yeah,
circles.
they can run the
honestly.
clock.
That's what they're doing.
Yeah, they can run the clock out, but I mean, we've got to face reality here soon.
Yeah, I think they
Yeah,
thought they were going to be
honestly-
able to drag this out for so long that the public could lose interest and it would just fizzle out and it would be kind of like just swept under the rug. I don't think they counted on people like Project Constitution and Candace and, you know, all the rest of them that were just like going to be relentless about this. And I think Project Constitution, I was saying this to the people in the live chat, I think on Friday, you should go grab and condense like the best 5 hours or 5 days of this, put it into a loop. Like if you have StreamYard, you can upload a video to StreamYard and you can run it as a live stream and then you can set it on a loop. Just let this trial play all weekend. So anytime anybody wants to get online, if you're not already streaming, it's extra footage. People will watch it. Your videos will get views. Your channel will help. It'll help your engagement. And then everybody that missed it, and if you can, cut out all the dead air like this. You know, if you download it and put it into Premiere Pro, you can have Premiere Pro cut out anything that's like silence over, 5 seconds or 10 seconds. It'll automatically go through and cut out all the silence parts. And then you can just upload just straight, trial. Just wanted to throw that out there for you.
Yeah, good idea. I'll probably do that. I mean, I've
Also,
kind of been
Colin,
doing that. Go ahead.
I said also, Colin, everything that they don't want to show, you and Candace and Barron should coordinate and just post. Say that too. This is exactly what they don't want to show, so we want to keep you all up to speed.
For sure.
Yeah,
For sure.
I agree. Yeah, we definitely, because people forgot. Like, we posted the Discord messages and the text messages early on, and a lot of people have forgot about that stuff early on. So we need to bring it back up again now and remind people this is what they're arguing about. This is what they're trying to hide from you. It's already out there. So why are they trying to hide it if it's already out in the public, But
And they
to my
really
other
shouldn't
point,
be
what I-
denying it under oath. They shouldn't be
No,
denying
exactly.
it under oath.
To my other point, though, what you said, Ryan, is I've been doing that basically already in the mornings because the stream doesn't start till like 11 o'clock Eastern time. But I've been starting to stream at like 8 o'clock in the morning and running, a recap of the trial from,
the recap of the previous day's
Your Honor,
trial.
State's
before we go
Exhibit
live.
16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything further from any party? To defense?
No, thank you.
To the prosecution?
No, Your Honor, thank you.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication. It's in the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing. And I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on state's request to publish exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana, Estes, and Skilling.
He doesn't even know what he's saying.
Any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rizzo and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rizzo because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rizzo, Estes, and Skilling. Unlike the broadcast interrogation in Rizzo, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures
It sounds
including
like they're
voir
going to
dire
show it.
and any other measures warranted before trial.
I'm just waiting for the
This ruling
but.
is limited to publication
Yeah, this
of the
judge is
exhibits
tricky.
during the
You got to be
preliminary
careful.
hearing and does not determine their admissibility at trial. And I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its
Yes.
entirety may
Yes.
be broadcast through electronic media.
Bingo.
That is the ruling of the
That's
court.
a win for us, big time.
Counsel, how would
Thank
we like
goodness.
to proceed?
So what document is that?
I can't
Project?
believe
Your Honor, just to clarify the record,
It's
the
the
state
text
has
messages
redacted that portion. We anticipated
where he supposedly
that
confessed
that
and the
needed to be
Discord
redacted in
messages where
16.1.
he
So we
supposedly
have
confessed.
redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming
Wait a
back
minute.
and playing.
He
Exhibit
just said
16.
no edited.
All right.
Why are we talking about edited?
Okay. All right. I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at 10:50. Court is in a brief recess.
All right.
I hope it's
Okay.
brief this time.
Yeah, hopefully. Just a reminder real quick again, if you want to support the stream, if you want to donate to us, you can send a super chat. Well, we don't really have super chat, but you can send a buy me a coffee, which is the same thing as a super chat. Scan the QR code on the right-hand side of the screen down there. Let me turn my camera on real quick. I don't know why my camera's off. Oops. So you can scan the QR code on the bottom right side of the screen there. If you want to support the stream, you can leave a comment. We'll read out your comment like a super chat on breaks. What's your guys' thoughts, man, so far?
I was thinking, are they doing like some type of reverse psychology thing? Like, initially how Erica's representation was pushing to show everything, we've waited 10 months. Are they doing that to push it? And then they know the judge is going to deny it, but they're like, but we fought for it. Like, we pushed for it. You know what I mean? But the judge said no.
Yeah, I'm interested to see, like, okay, so you're releasing text messages, and I don't get, like, how much of the entire thread are we going to get? Like weeks, days, months, years worth of Lance Twiggs and Tyler Robinson communications on Discord? Are we just going to get a cherry picked last 24 hours? How much of that are we actually going to get? And are they just giving us shit that we've already, like Cash Patel already put out the Discord messages? They've already put this shit out. It's already been out there. So it's like, now they're going to give us this one and be like, yeah, well, we wanted to give that one. And we're all over here like, yeah, it's a win for us, but really, is it? I'm curious on like the nitty gritty, like the real good shit. I mean, I guess the messages are great because of the work that Barron did, where he's like, yo, like, listen, Tyler was already in custody. How is it possible? And is that why we're not going to get the videos of him turning himself in? Is that why we're not going to get specific videos that are actually for us able to prove, because once that happens, once these messages come out and you prove that he wasn't even in there when they sent those messages, just one in front of a jury, I would say just one shred of evidence that goes, wait, you're saying that he's guilty because he admitted to it in these text messages, but these text messages were sent after he was already in custody. So if that's your nail in the coffin, does he even make it to trial, or they just dismiss this? And then what would happen? Like, let's just say the judge is just like, yep, there's not enough evidence. We're going to dismiss this. It's most likely going to result in a mistrial. What happens after that? Do we go back to, is it Israel? Are we starting to try to bring Netanyahu in for questioning to try to find out who it really was? Or do you think the FBI is going to go, oh, it was bullshit. We know it was Tyler, but we can't charge him. So how does this play out?
Well, I think that's what we see, that, that's why we see Turning Point, kind of shifting their narrative. Now they're trying to put the blame on other people as well. Oh, well, there's a broader conspiracy, a bigger conspiracy, because they see the writing on the wall. They see that there's no evidence to convict Tyler.
Yep.
So they're trying to set it up now to go after other people. But the problem is, when that happens, the suspicion is going to be on them, because 100%. They are the ones that have been covering this up the whole time. Even like the text messages where he was saying, where Charlie was telling people up to the day before he died that he felt that he was going to be killed by someone. Even that day, he said that he was going to be killed that day at UVU, like that specific. So,
yeah, and you think about this, like when you're like, as you're waking up and you're starting to put two and two together, you go from thinking like, and not Ben Shapiro, but probably Andrew, probably who was the other one that
Blake Neff.
Blake Neff, but the other one, the one that looks like a vampire. He
Tyler
writes
Boyer?
books. Not Tyler Boyer as well, but the
Oh.
other one. You know who I'm talking about. The one that looks like a vampire. The one that was threatening to sue Candace.
Hammer, Josh Hammer.
Josh Hammer, yes.
Yeah,
those
Josh
four.
Hammer, yeah.
So like you're surrounded by these four people. They're all in this group chat with you. They're part of the Hamptons. The whole thing's like great. So at some point in your life, Charlie probably was like, these are my ride or die homies. These are the people that are always around you. They're always giving you your advice. You're the one that's communicating them. They're riding with you to events. They're transporting you around. Like these are your these are your close homies, or at least you think that, right? And then imagine as you started to connect the dots, you started to go to campus after campus after campus, and you're sitting there and you're doing interviews with these students and they're asking you questions. They're kind of waking Charlie up like we all were, right? No matter what, like we all kind of had went through our own unique experience of waking up. So Charlie's waking up, but the people around him, it's their sole purpose to keep him asleep, right? And to keep him on the Israel gravy train, because they're all technically his handlers, right? So imagine like once you're fully awake and you go, holy shit, my wife's my handler, right? She never loved me. Like that interview where she's like, oh yeah, like our birthdays and the kids' birthdays. And Erica's like, Charlie's like, had to fill in her, like put the words in her mouth so she didn't look completely like I don't think Charlie wanted to blow her cover publicly yet. So I think he was like, August 18th. And she's like, August 18th. Yeah, it's hard to remember because we got 2 kids' birthdays, right? It's like, what parent forgets their kids' birthdays and their anniversary? Nobody ever. No girlfriend ever forget
Exactly.
it. Like I got girlfriends that I dated in high school that was like, when I was 13 and 14, and I still remember my girlfriend's birthday to this day, right? Like people don't forget important dates, right? Like I do. My 14-year-old girlfriend, it was May 20th. And I remember it because on a dartboard, 5 is next to the 20. So it's just like those things that you just come up with ways to make yourself remember things and you don't forget these things, right? So it's like, I wonder what it was like for him as he woke up and realized that he was surrounded by everybody that was setting him up. And then you have your wife telling you, oh, maybe you should wear a bulletproof vest. And you're like, well, my wife's never told me I should wear a bulletproof vest. And then Charlie's got a photographic memory, right? Like Candace said, the guy remembers everything. So if he went to a runway and he's seen an airplane, he'd be like, why is that random military Egyptian plane sitting on this runway? And why has it always been following us around? And Charlie's probably got like this, like imagine being able to remember everything. Like you're that smart. You're like a Kyle Seraphin, you're Charlie Kirk, one of these dudes that are just like, your brain is exceptionally well at retaining information. Candace probably has it too. So Charlie's probably waking up and realizing everybody around him. You do too? That's how you guys can piece all this shit together and you guys never forget anything. I don't have that. It's like a gift that you guys have. So I think Charlie was probably like looking around him going, and you just notice things. Why is my mic turned around, right? Why would they ever? Nobody ever makes that mistake. I got my mics right now. Like there is no way I'm going to take this piece and put the magnet. Like I would like, could you imagine me magneting
You wouldn't
my
put it
mic?
inside your shirt.
Ever in a million years, because like that's your necklace there. Charlie's big chain necklace. Could you imagine that big chain necklace swinging along? I can't even, I have problems with it when it's mic'd on the outside of my shirt, dude. And my necklace is under my shirt because it's still, so the way you have to do it is you have to get the mic separated like at a different angle from the actual thing. And I actually I had to get these necklace things, and I had to put my magnet in a necklace because I couldn't even mic it to my shirt, because if I had it connected to the shirt, it would still hit the mic. So you have to go and you have to get a necklace that keeps it separate, and then that sits on, and then it's still a little bit, but under your shirt, never, we're trying something new. We're going to try something that's so retarded that every like first day videographer that has ever bought a mic on Amazon would look at that idea and go, that's, what are you, retarded? And at the very least, if you're going to try something new, you're not going to kill all of your audio, right? So what you would do is you would have a secondary mic source. You'd have that clipped on the outside, guaranteeing perfective audio. And then you'd have your other one inside the shirt, or however you wanted to completely sabotage your audio, but you wouldn't do it that way. Nobody would do that. You'd only do that if you were specifically, I don't know, planning a exploding microphone on somebody, in my opinion. But sorry, I'll land it there.
Exactly.
And remember, they propped him up. They put him on like a little stage to prop him up above his table to be more
the
of an
kill
open
box.
target.
Yeah. They put him on a damn kill box. Absolutely. And not only that, but they also, I don't know if you guys noticed this, but they also propped the front legs of the tent up as well. You know, they put the front legs of the tent, they put on about 8 inches higher. They put them on blocks. So the front of the two front legs of the tent were about 8 inches higher than the back legs. And the only reason they would do that intentionally is to get that line of sight, to make sure they had that line of sight. Why else would you do that?
You know, and the fact that they dug up the soil, like everybody's like, oh, I thought they were just trying to get rid of the blood. I never thought, like the thought never crossed my mind of like some type of explosive material that when you detonate a bomb, it's like when you go through the airports and the dogs are smelling you, they're not necessarily smelling for the bomb in your bag. They're smelling for the residue on your hands. And that's when you go through TSA and they separate you. They take this little cloth and they're wiping your hands and they're feeding this cloth in the machine because of any of the residue that you were making with it. So when a bomb explodes or a mic explodes, that dust, that residue, whether we could see it or not, is going to settle down into the grass and dirt. And if you're able to take a large enough sample, I think it's like you have to take out like 8 inches or 12 inches of soil to guarantee you get rid of all of those contaminants. So they did 12 inches. And then they specifically didn't like, it wasn't like they ground it up and like mixed it up. They specifically removed all of it, 12 inches of soil they wanted to physically remove and then put brick paper down. Now, I would love to know, right? Remember that independent construction worker that removed that soil?
Mm-hmm.
Where did he take that? Does anybody know?
Oh, I have a tip on that, actually. I have a tip where we need to look into this. I haven't looked into it yet, but I have a tip. Someone sent it to me. Actually, this is the second time I've gotten it, but they said that here's the tip, right? It says, I'll bet the dirt from UVU went to USPCI, which is 10 miles east of Wendover. It's less than an hour from UVU. They store contaminated debris and keep meticulous records. Maybe we could FOIA the delivery footage, the entrance, the gate for 2 weeks after the UVU event. And that USPCI actually, I think is a good. I think we should look into that. That's something. Because let me look up real quick what let me see, make sure we're not missing. Okay, now we're not missing it. USPCI. Let me see what USPCI is real quick.
And would they? Oh, I see what you're saying. I say, so they're claiming that there is blood on the soil, so that they needed to purposely, specifically decompose of it in hazardous waste, and not as you would just take it to a landfill, or you just take it, oh, it's just dirt, I'm just going to take it over to the woods.
Exactly. They would not be able to take it just to a regular landfill, correct?
Well, think about it, because it was hasty and it was done last minute. It might have been sloppy too. They might have been sloppy in a good way.
Yeah, that'd be very interesting to see if they, I don't know. It just seems like, that construction worker seemed like he was pretty pissed about like having to do it. Like he was shocked. He didn't understand why he was He was speaking out about it. And I just wonder if like they probably would have put feds on him. Somebody would have been tailing that guy to make sure that he actually took the soil and dropped it off and disposed of it. Like, it would be really interesting. What if he was like, you know what? I'm just going to save a sample of this as a souvenir. As disgusting as that may be, like, man, if that guy saved a sample of that soil, he would be a fucking legend. You know that?
Yeah, I know.
I don't know if I would think
I
about it
agree.
if I was him in the first place to do so, or how like kind of messed
He
up that's
said
even
that. He said he wasn't thinking that way.
fucking
He
crazy.
just wasn't, his mind wasn't there. I would have grabbed a McDonald's bag or a Ziploc bag out of my car and just put some in there.
Yeah, you would have had. I don't know if I would have. Probably would have, man. I mean, we were pretty. Dude, it just sucks that none of us were thinking that like how valuable that soil was, because they were guarding it, but they weren't really guarding it, right? Like that dude with a doctor's uniform somehow snuck into there with a rifle. I don't think it would have been a big deal if somebody. I don't think it would have been hard for somebody to get over there and take a sample of that. But you would have had to get probably right where Charlie was actually standing, right? You know, you would have had to get probably within that 6-foot perimeter of right below him too. And then who knows, maybe that's why they had him on. Maybe that's why they had him propped up on this stage-like thing, right? So that way, as the dust settles, it settles onto their stage. Then they go and they clean up. Oh, it's just bloody, whatever. We got to dispose of this. And then when you're disposing of those hazardous materials, if I'm not mistaken, they're getting incinerated. That hazardous waste has to be taken to a specific site that has these like, they're giant like crematory things, and it puts it in. They have specific filter systems on them. That's what they were doing with all the waste from that train accident.
Here's what it says. USPCI is a hazardous waste landfill in Utah, and it's owned by Union Pacific. It is one of Utah's largest hazardous waste disposal companies. So it says it's a landfill.
How do they dispose of hazardous materials? Do they burn them, or are they putting them into an actual dump and letting it seep back into the soil?
I mean, it says it's a landfill, so that to me that doesn't sound incineration. That sounds like they bury it. It's a landfill. They just compact it and bury it.
Yeah, if it's just blood, they probably would be able to just bury it, huh?
But they would, regardless of whether it's destroyed or not, we would be able to have records. Yeah, we'd be able to see if it went there and who took it there, and that would be at least a lead we could track down. Maybe,
Oh yeah, because you're billing a company for disposing of hazardous materials versus just disposing of soil. I mean, those are two exponentially different costs. One, you just can dump it wherever. The other, so whoever that guy was that billed the school, or whoever he billed, would have had to have known that they specifically wanted disposing it of a certain way. It's wild.
Yeah, exactly.
Colin, you should reach out to that pavement guy.
Yeah, I thought about that. I'm going to try to find some contact information and maybe see if I can get him to come on.
Yeah. Sarah said you'd need a witness to see you collect it in a matter not to contaminate the sample, and then store it the whole time and take it into a lab with the chain of custody. Yeah, you definitely, if we were going by the book, for sure. But it would be just interesting, even if the guy said, "Hey, this is the soil I took," and all of a sudden, it just has PNT testing in it, or whatever what we think was the device. I would be like, yeah, fuck it. In the court of public opinion, that'd be enough for me to say, yeah. I mean, we got so much. They blew up the facility, right? They blew up I don't know. Was it a military testing site, military contractors where they actually made small explosive type devices? That got blown up.
Accurate Energy Systems. That was the plant that actually made the device in Tennessee, or we think made the device in Tennessee. But they're the ones that had a contract for that very miniaturized explosive device or whatever, and it was a patent. But yeah, they blew it up supposedly just to hide the evidence, killed all the people involved and everything. And we think it's involved because the jet, obviously the SAM 000s that we're back on
to come back into the courtroom.
Okay. Well, yeah, the SAM 000s that just happened to fly over the explosion. The plant flew over the plant at the time of the explosion. So you're telling me and it's Kash Patel's plane, by the way. Kash Patel's plane just happened to fly over the plant as it was exploding randomly.
When they killed what's his name, JFK. Allegedly, it was Jack, the guy, it was the driver in the car, turned around, and who was that guy that, William Cooper, right? William Cooper was like the original. He was out before Alex Jones. He was the one who was calling Alex Jones a fraud for stealing his work on 9/11. He's the one who was the first one to release the video that showed the full driver in the seat. You know, the video we saw of JFK was just to get his head blown off. They couldn't really see the driver in the passenger seat. And then the passenger seat, the guy turns around and he says that back then they used some type of like airsoft operated gun, where it was like, you know, basically like the mini air cartridges that were like hypercharged that were able to put the bullet. So that way there's no smoke coming out of the gun, right? And there's not as loud of a bang when it shoots the projectile. Like I'm not so wondering if there could have put some type of small, you know what I'm saying? Something in that versus having to actually explode the mic, because I don't get how you explode a glass mic into a million pieces, but yet not a shard goes through the shirt. So, or was that Freedom shirt a specific type of material or something that would prevent that? How did we not see if that was exploding mic? How do we not see any outside of right here? I did believe because that
it's white. The patent they used to explode it, it's actually a smokeless explosion. It's a smokeless explosion. It doesn't leave burn marks and stuff. So that's why there wasn't like, you know, we didn't see like a big boom or anything like that.
Well, Blake Bednar's did get the one video. That was the first 4K
I gotta
video.
step away for one. You guys talk among yourselves. My DoorDash just got here, so I gotta go grab it real quick.
Yeah, go ahead. Yeah. So Blake Bednar's was the first one that actually he went and bought or somehow acquired the video footage that was from the actual who was the school has their photography department or their videography department or their news department. He went and somehow tracked down that first 4K video camera that was pointing at Charlie. It was still a decent ways away. But when we zoomed in on that, you did see this like what looked like a white puff of cloud. People were trying to say at one point that it was like the shirt, just the blur of the shirt. But to me, it looked like a little white cloud of smoke that just kind of evaporated pretty quickly that was under the shirt. So I do think we definitely seen something went off under that shirt. I don't know what it was, how it happened, but I don't know if there wasn't like.
I said that from day one. Why it puffed up.
Yeah, something was in there. And Candace saying, like, I don't know if there wasn't something like, she's like, the first thing I thought was on the ground, right? Like maybe there was something on the ground because of the way his body reacted. And I'm saying like, okay, was this device that kind of exploded? Was that something that sent the projectile into him? Or was that just designed to make the sound effect for the microphone to make it sound like a gunshot? Because I still think when this explodes, it's right in there, like, and then that mic has speakers that broadcast it everywhere and amplify that sound while something was like in the, you know, that camera, that one main camera there. I'm just thinking like the angle of that camera, the boom arm on that, how easy it would have been to hide some type of airsoft projectile, which would have had a direct line of sight. The girl's sitting there behind the camera, basically lining it up. So I don't know. I don't know if we're ever going to figure out how they actually killed him, but.
Well, the gunshot sounded like it was in the distance.
Turning to the state.
We'll talk about it on the next
we were
break.
having computer technology issues, and we believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right. Well, how much time do you need?
Just as long as it takes to show the video. So maybe 10 minutes.
All right. Well, we'll go into, well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize that we were at this point. We'll be in recess for 10 more minutes. So by 11:05 approximately.
Wait, why are we going into recess?
As soon as we're done, if
I thought we just came back.
So ladies and gentlemen, I apologize. I thought we were ready to proceed.
They're not done editing the video, I
At the
think.
same time, keep this hearing moving forward. So court is in a brief recess.
The only
they're
plus
not
side
going to
to
get this done before Friday. You know, tomorrow is supposed to be the last day, and And not only does the prosecution still have a witness that they got to get through and all this, but the defense still has 2 witnesses they got to get through too. I have a feeling this is going to go through till next week, and they're going to have to continue it into next week as well.
And that's bad for them because the best thing you can do is end it on a Friday because a news cycle dies over a weekend, right? So if you're trying to kill a story or kill something, the last thing you want to do is carry it on to a Monday, which actually probably is going to play into our benefit. So maybe they do. But what you're seeing right here now is if they are literally really editing this video, which you can look at it 2 ways. Either they're not really, and they're just like Project said, just trying to draw this out so they can push it into next week, or they're literally trying to edit this in real time on the fly. And that means they're most likely scrambling, which also means that maybe they make a mistake because they're rushing and we might get a little something extra that we're not supposed to get. I don't know. What do you guys think?
Yeah, we can only hope on that. I agree. I mean, both of them.
It's just,
I mean, yeah.
to me, it's just delaying the inevitable. I don't know why, and the judge is acting like
definitely
he's bothered by even having to do this right now. So,
I agree.
So
what you were saying before about the. Now, do you know that Charlie? It wasn't the actual mic. It wasn't the microphone, the Rode microphone he was wearing that actually exploded, right? It was the transceiver that was on his belt. Which was directly in line with his neck. With the transceiver is the exact same size as the microphone. They share the exact same casing and housing, which you probably have the same mic, so you would know that. But the transceivers, that's basically the same exact thing. Has the same glass case, has the same white writing on it, has the same USB connection on it that they found. But yeah, it was the transceiver that was directly in line with his neck. And we know this because I was able to find a video, or not a video, but an image where you can see as they're carrying him away, you can see the burn mark from the explosion on his stomach underneath his shirt, because they had his shirt like kind of lifted up a little bit as they were carrying him. Right where that thing was on his belt, you see there's a like a bruise or a burn mark or whatever from the explosion.
Now, why was he, like when I'm filming like that, my receiver is on top of my cameras. Why would they ever put the receiver and the transmitter both onto him at the same time? Normally you have your receiver and then you have it connected to it. So like Sam was saying, that thing records internally directly to its own SD card, and they both do. Both the receiver and the transmitter are both recording independently, which is really cool. I didn't even know that they made shit like that, which is smart. I'm just curious on why was he wearing that receiver on his waist?
A lot of people do. That's actually a normal thing. A lot of people wear them, on their belt or whatever. That's why they make them with a belt clip.
I bet that probably Bluetooth right to his camera too.
Yeah, I don't know that. I know the reason they had the transceiver or whatever is because they were broadcasting to multiple things, so they wanted the microphone audio to go different places. So I think that's why they had the transceiver on them. Let me see if I could find my post on it real quick.
Hey, to what you were saying earlier when you were asking about shards on the Freedom shirt, that was something that Candace theorized. When they hopped towards behind the table to his aid, she said they were brushing that off and they were trying to get all that off in the SUV.
Oh, I have no doubt. I think that's why they didn't let the ambulance take him. Like none of that makes sense. It's also why they didn't let the paramedics were there. They were running side by side with him in the body. Remember, they had the paramedics in the bags that were kind of like right on the side, and then they threw him in the car. You would at least think like, hey, let's get a bag of medical supplies in here. They probably had IV. Everything that you needed was probably in that paramedic's bag. Oxygen, who knows?
Yeah, right here. You could see the mark on him right here. That's the mark as they're carrying him away. The bruise on his stomach right there, right where the receiver transceiver was on him. Yep. And you can see this picture right here. You can see where the arrow is. That's where it was, right on his belt right there. You could see it poking out there.
You're fucking Lord.
Wow.
And then you can see, obviously you see the puff of air coming out the sleeve and everything. That's how we know it was definitely an explosion underneath the shirt.
Oh my gosh, yeah, bro.
Whoa.
And then obviously then you see the black shards.
You know, I
which
fucking
you
love
can see if I
Candace,
can zoom
dude.
in.
Candace
Oh,
sat
man,
on
me
these
too, man.
photos
I'm ride
for
or die with
fucking
her, man.
6 months. What a fucking legend. Like, oh, hey, I got these cameras this footage that shows glass shards.
What happened?
Dude, they're everywhere.
Hold on, what did I do? Oh yeah, that's right.
That makes me sad.
Yeah,
Those
you
are
see
his
them all
cough
over the floor
drops.
there. Yeah, these are all the black shards all over the place, and they were even on Charlie's seat. Let me see if I can get back to that picture
Okay,
I was
so
at.
let's
before
pause it there for a
this.
second. Go back to those cough drops for a second. Because
Ooh, hold on. That's
Oh,
the
shit.
wrong receiver, by the way. Don't.
Yeah.
That's an older model. That's not the right one.
okay, but when you're
Where did
looking,
it go?
anybody
I'm trying
that's a
to find it.
guy
Give me a second.
that's ever wore jeans, right? When you got shit in your pockets and you're wearing those jeans, do you understand how physically hard it is to pull out? Like, those cough drops didn't randomly just trickle out of Charlie Kirk's tight jeans. The dude's a big dude. He wasn't like he was wearing baggy ass clothes. It looks like they emptied his pockets. It looks like they wanted to make
did.
sure that there was no shards of glass stuck to the inside of his pockets or something. So they specifically reached into his pockets and were emptying everything out of his pockets. That's what that makes me think right there. Because that's a lot of cough
exactly
drops,
what
right?
they did. Yeah, that's exactly what they did.
You'd have
They
to
shook out
turn-
his shirt. They shook out all his clothes and everything. Shook out his pockets because they wanted to make sure before they went in the hospital that there was no evidence of the explosion when they took him in there.
That's exactly what they did.
Ryan's
Oh,
right. You'd have
shit.
to turn the pocket inside out.
Yeah, I'm a guy and I don't wear baggy clothes. And it's like when I carry these, so this is the piece to my mics that connects to my phone. So it's literally like the size of a cough drop, right? And when this thing gets buried in my pockets, like I have to physically get up and like pull my pants down, like reach my hand in there just to get this little piece out. Cause and those cough drops would have been down at the very corner peak of your pocket. And it looks like they got every single cough drop out of his pocket. That's sketchy.
Yep. Exactly. There was
To what
something-
Ryan
there
was-
also there was also a couple there now there was, even though his mic exploded and we believe that's or not the mic but the transceiver exploded, we believe that's actually what killed Charlie. But there were actually multiple things happening at once. We know that there was definitely a gun fired. I don't think it was fired at Charlie. It may have been a bit of blank, but there was definitely a gun fired. And the reason for that was basically just to mask the sound of the explosion and to make everybody believe that it was an actual gunshot. And we know that it's not. And the other thing is we know that it's not the speakers, like you mentioned earlier, how it could have been maybe the speakers that played it. No, because if you go watch Zeb Boykin, he had an audio specialist on his program a couple months ago, like 2 months ago maybe, and this guy very thorough. He ran about 14 different tests on the audio from every single microphone that we have, like all of them, like all 12 or 15, however many versions we have of the video and microphone, angles or whatever. And what he was able to find is that he was able to pinpoint the side that it came from, obviously, which is the east side, which, by the way, is where they found that 228 round, that 228 caliber live round from that side by the Applied Engineering Building. That's where the sound came from, according to his audio. But also, with the audio, he was able, it's not the speakers because there's a supersonic signature, as he was explaining it. And the speakers are not capable of hitting that supersonic note. So we know for a fact that we had that supersonic signature and the speakers could not have matched that note.
Now, and then two, Hustle Bitch also recorded somebody on one of the buildings running 20 minutes before the assassination. Was that the same roof where they found the bullet? I know you had posted another video. That guy, that
Yeah,
one
I
right
just
there.
posted one today. Yeah, exactly.
Yeah, that was the one that Hustle Bitch
Shot.
broke like the day of the,
Yeah,
like the day after.
he might have been the original one to post it. I don't know. I got this from Black Scouts. I actually originally posted this way back on the 12th, I
Yeah,
think.
yep.
But I originally got it from Black Scout Survival. He may
Okay,
have
yeah,
got
maybe
it from
that's where Hustle Bitch got it. Yeah, maybe that's where Hustle Bitch got it from. Where?
Yeah, I don't know. I don't know where it came from originally, but yeah, this is definitely a guy. This is the oh shit, what's the name of the building again? This is the, let me look at it.
Sorensen?
This
No, Woodbury.
Woodbury. Yeah, this is the Woodbury building. This 20 minutes before, and you could definitely tell it's somebody. It's a person because it's moving and you see them pop their head up. So it's not like an object, and I'll play it real quick so you can see it.
And where was that
20
shell
minutes
casing found?
before the shot, ladies and gentlemen. Okay. One figure on the adjacent roof. Look, there it is there. It's moving, so it's not
You can
some
see
kind
the
of
head
fixed
pop
like
up.
air duct or something.
Down the bottom
The
right
thing
hand
is,
corner, you about to see the head
the
pop up.
shadow, the figure is moving.
Boom, there the head,
head
pops up.
pops
There, you
up.
see it?
You got your Snapchat
Why
thing
do we
over
have
it.
multiple? This was at 12:06, I believe.
There it is.
And you're going to see this is the Woodbury building. If we look on the map where the Woodbury building is, so why do we have all these people crawling around on the roofs of Uvu that day?
Let's go back to this map for a second. So yeah, we have video. Remember, we have video of somebody running, you know, that was taken inside of the Hall of Flags, where you see somebody running across the roof. Remember that video?
Mm-hmm.
And then we have the video that was taken beforehand of the, you know, of the two people that saw the guy in black in like laying in a prone position on the roof. That was, I believe, the Sparks Center. And then you have allegedly Tyler Robinson on the Losi building. So we have all these different roofs, and then a cop over here on the other roof, well, the walkway of the roof of the Hall of Flags. So you have you know, why was there somebody? Why was there people on all these roofs surrounding Charlie that day?
So let me ask you this. So you guys remember when Not So Tactical first came on the scene? You guys remember when that guy was first, and he was the first one to try to say that Charlie was wearing a bulletproof vest. He was the one who had me, you know, contacting me directly, telling me that Charlie had a vest on, and we could see like on his shirt, like right above his collarbone, right when that explosion went off, there was a little part of his shirt that turned like a tan color, like a brown color. And he was trying to say like that was the moment the bullet hit here. We seen the bullet, it ricocheted up into his throat. And then he went as far as like, well, you know what I'm going to do? I'm going to take my boys out and we're going to do this drone surveillance and we're going to map out the entire area. And then we're going to bring you back 3D renderings and we're going to show you every possible position of where somebody could have been. And it was like at that point, he changed, right? And I'm just curious, do you think he was in on it the entire time? Or do you think it's just because he has government contracts for his business and they came to him and were like, hey, here's what you're going to do, or you're going to lose every government contract. He's a soldier. He's probably used to taking orders. Do you think he just fell in line for a paycheck, or do you think he was really in on it from the very beginning?
That's a hard one, man. I don't know. I mean, I think he was. I think at first, you know, there was some genuineness to him. I mean, at least it seemed like it. And I don't think he's that good of an actor, so I don't think he can hide that fact. Like he was actually, he seemed like he was trying to, you know, because he was even saying that he didn't think it was a 30-06 and stuff in the beginning. So, you know, I don't know
think
what
he
changed
was
with him, but-
assigned.
Oh, hey,
He was
will you move
assigned that role either way.
Project, will you remove that tweet that you put up on screen because it's covering her face?
Do I have something on? Okay, hold on.
Oh, my bad.
Oh yeah, shit. Sorry about that.
Yeah, I love when you put them up there. It just stayed up there, and I thought you forgot about it. And it was covering up her stuff. So
Yeah, I did.
But yeah, I think not so Paramount, not so tactical was assigned that role either way. It's just a matter of was it before or after, because they seem to scrounge around and do a lot of stuff last minute.
that dude was a nobody. Nobody cared about what he had to say. Nobody knew who he was. And then we all opened our platforms to him with open arms and kind of were like, oh yeah, this guy's military expert, gun pro. Like, let's hear what he has to say. And then he's like, oh, I'm going to take my crew out there with drones. And I'm like,
Court is back in
yes.
session, noting the presence
we're
of the
back.
parties all being present. And where we left off is we were the state was looking to confer with defense to ensure that state's exhibits 16, 16.1, 16.2, and 16.3 were shared. Ms. Hunt.
We have reviewed Exhibit 16 with defense, and it comports with the court's order. At this point, we would like to put Agent Davis back on the stand and continue with displaying that, publishing that.
All right, Agent Davis, if you'd like to come forward, I remind you, you're still under oath. If you'd like to have a seat. There should be a water bottle to your left, and after your seat.
Hey, Project, I think your mic's open still, homie.
Adjusting that microphone and bringing it close to you so the record can pick up your testimony. Ms. Hunt, your witness.
And just for the record and the court's benefit, we have made the edits that the court has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected very clearly. So there are sometimes large gaps of just black, empty, silent space. When there are large gaps, we will fast forward. Some of those are short enough that we'll just let it play if the court is okay with that, with proceeding that way.
Thank you. I appreciate giving a heads up so all parties know what's going on. Thank you, Ms. Hunt.
So at this time, we would move to publish on the monitors State's Exhibit 16.
All right, and to the media, there is a monitor for your benefit right there next to you. For the camera, there is one for that direction as well as for the gallery.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. Understand that?
Why'd they take away his furry costume?
So in order to do that, I need to place you under
I know,
oath
right?
and also give you an admonition about false statements, okay? First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. You understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that?
Mm-hmm.
Okay. First, we're going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
And we described your relationship with Tyler
when you first met him anyway.
When I first met him, I didn't know him super well. He was just a new roommate. So I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on, your microphone? Okay. I'm going to repeat those admonitions just to make sure we got it recorded. Okay, so again, I placed you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on. They're saying that it's echoing, so
I think this one's mic is on.
Okay, sorry.
Okay, you're not on my mic, but that's fine.
Okay.
Okay, so we should be good. All right.
Who's that? His CIA handler?
Is that mic on?
Yes.
Okay.
Oh,
Great.
I'd love to know who that woman is.
All right. Okay. Sorry about that interruption. All right.
Yeah,
so
me
you said
too.
When you first met, you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates. Is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived when on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
That's exactly what Tyler was
I
doing.
think he was.
I think he
both
worked
working.
for Tyler's dad,
I
didn't he?
think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher like ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was his typical work day like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on like where the job was and how long it was for the day. And then on certain days of the week during school, like semesters, he would then later in the day, I think around 5 or 6, go to school. So yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Yeah, he did.
Okay, yeah, it's probably his attorney.
Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna have him spit out his gum just to make sure that.
I can do that.
Your
mind if I
tissue
do
right
that?
in front of your laptop.
Oh, here you go.
Thank you. Thank you.
All right, so what time did you get up on September 10th?
Probably like 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.
Yeah.
Automated message? What's he talking about? An automated message?
That's what I'm wondering.
I don't know.
And then now we can't hear any of the other shit. That's like they just scrubbed out like 20 minutes of the thing, no?
What about,
I thought the judge said we were, they
he
weren't
asked
supposed to
you,
do that.
remember how I was
Fuck.
engraving bullets?
I thought
Was
he ruled that
engraving
we were
bullets
getting
before
sealed
this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where our Dremel was and told him to make sure he doesn't set off a bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember because he'd been talking about the hunting/camping trip for a couple months, but I don't remember when he was specifically asking to engrave the bullets. So
are we talking like a year before?
Oh no, not that long. It would have been, I'd say at most a month before this was when he was asking.
Okay.
They're skipping down there.
Dude, I'm on Amazon right now. You go to Walmart, that Dremel's $9.99.
That he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note.
Okay, it could be
And this is Bates number 58.
fitness tracker app or something.
Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
Sure you did, bud.
Where is it?
I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
Right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And now I want to go to what's been titled 16.2. And do you recognize this series of messages here?
Yeah, that was the server of his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And who are members of this server? I don't want names, just generally. Who are these people?
This is his friend group. They played D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look at it. Or go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
Yes.
Yeah, DM means Dungeon Master. So these are most of them are names they're using in the game they're playing currently.
Got it.
Somebody should try to find that person on gaming sites.
I totally agree.
Yeah, it looks like the last text from Tyler, it looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because at least I think so, because I don't think on the 10th that he messaged anyone before me at like 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
So again, we're just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
To my knowledge, yes.
And that was sent, looks like between September 10th and September 12th. Looks like the last day on this is September 12th. Screen?
Yes.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting.
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
This is such a fucking joke, dude. Like, this is the biggest sham trial in the history of our fucking country.
Oh, absolutely. It's nothing but a show trial, man. 100%.
If anybody clip that video part, let me know. Put that in.
So he acted erratically.
Oh, here we go again.
Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it. And then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
Get the fuck out of here.
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left understanding he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless.
He will if it goes to
went
trial,
down.
right?
I don't know. I hope.
Are any lawyers in the live chat?
Before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat, but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images.
You know what this sounds like? It sounds like Lance is going to take his life. He's going to get Epsteined. And this is all that's going to get presented in court.
Okay, I'm on the FBI's website.
That's what I'm
you can
thinking,
see the
honestly.
URL there at the top. This is some press release about this event. And Here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This looks like him.
Yeah, his friends. Yeah, I don't know if I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
Played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some like shooting games together, but I didn't know him very well, so that was just when we had like a full friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
Yeah, so this is all we're getting of Lance. There's just this chopped up bullshit, half the screen's blacked out, and they're doing this so that the defense doesn't get to actually question him. Somebody just jumped in here and just joined us, XXKP. So this all we're getting is just this bullshit. Half the time the screen's blacked out. Like, we don't know if they're coaching him.
For a short time, yes.
Okay.
Exactly.
And I understand you're going by Luna at some point.
To some people, yeah, but not as an overall thing.
And if you guys are just joining us, do us a favor and share this stream. Let's try to get this thing packed for Project Constitution, man. The more likes, and if you guys get chime, go down and comment in the comments of this post. It'll also help boost it for sure.
Okay. Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything.
All the cutting in the video is very suspect. Absolutely. Why? What are they trying to hide, man? You know, I thought the judge ruled that we get to see it. So why are they still making cuts and edits and shit, and then not even showing the video at all?
I thought there was only 2 spots, and it was like a 10-second or 15-second window.
That you talked about.
Yeah, that's what I thought too.
Asked for
What
that,
happened?
is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
And so did you have a journal then?
Yeah.
Okay.
It was in our, like, our apartment, we had a section where we kept all our, like, random tools for household stuff, in our, like, lower basement level pantry. So, yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was, yeah.
Okay, I'm going to go ahead and end the recording for the 1102 purposes.
What the fuck does that mean? That Erica Kirk fake crying again?
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from the court-ordered redactions, did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
I want to know why,
Have you
how are
reviewed
they
all of
still
those items
using
as
the
part of the
Discord
investigation?
messages
Yes,
as
I have.
evidence
You're
in
familiar
the
with
probable cause when we've
All right,
already
I wanna put
proven
just on
that those
the
Discord
witness's
messages are
screen
fake.
what's
They were
been marked for
altered after
identification as
Tyler was
State's
already in
Exhibit
custody.
16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Sorry. These are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview, he refers to the large crack in the upper left screen. That so he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in States Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in States Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is States Exhibit 16.1 a fair and accurate representation of the text thread or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit States Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court, of course, is very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of States Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m. Will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize. Let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
We could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
We could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
It says, while they were spot, but I don't want to chance it while they were parked there. If they'd found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4, so just scroll down 1, please, Kimberly. And if you could read starting, sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up, that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. We'll
Sorry, now we're on page 6. Continue reading.
we'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud. Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if I had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8. And if you could start at the top.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
Let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15. And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly. We mentioned a Cellbrite extraction of Mr. Twiggs' phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th make sense? Or you're saying September 11th?
So September 11th was when he turned himself in. Would have
Okay.
been September 11th. Yeah.
Okay, thank you.
Yep.
All right, I'm going to show just for the witness States Exhibit 16.2.
Hey, Project, I've been on
Let me
for
know when
about
you
4
see
hours,
that.
brother. I got to run, homie. I appreciate you guys.
You
I'll
recognize
jump
this?
on with you guys tomorrow if I got time.
What is it?
This
All right,
is
man.
just more
All
photos
right,
of
cool. I
Lance.
appreciate you coming on. Thanks, man. Everybody
These
go
are-
follow
sorry,
Ryan
these are
Mata.
the-
Make sure you're
the,
following Ryan Mata on X. You got a YouTube too, don't you,
Sorry,
bro?
I had to blank. Sorry.
Yeah,
what was
but
your
X
question?
and Instagram are good. Ryan Matt on
I'm just
everything.
asking
God
what
bless
it
you
is.
guys.
So you said it's a photo of Lance's phone. Do you know if that's
Okay,
from the
yeah,
same
yeah.
time period
Follow
as
Ryan
the
Mata,
exhibit
guys.
we just looked
All right,
at?
later, bro.
Yes.
And what is it of?
These are the Discord messages of that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He identifies that in his first interview with the two FBI agents, and then he again confirms that in his second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Ikum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in States Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak.
Thank you, Your Honor. We've already lodged all of our objections on all three phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
That's bullshit, man. Why do they keep blocking this stuff from the public? This is not right, man. We deserve to see all of this.
Yeah. Do you really think those text messages just sound phony, honestly? Like, why would Tyler give him a blow by blow as it's happening?
It's completely phony. That's what I was saying yesterday honestly, it sounds like two cops wrote it, but even more so, it sounds like two cops in Israel wrote it, because it sounds like people that don't speak English properly, and they're like running, like they wrote out what they wanted to say, and they're running it through a translator, like a translation service, and then putting that in a chat GPT. That's what it sounds like.
Yeah, and it's specifically, I don't know, one, it sounds phony. Two, it's you're right, it's way too scripted, and it's like giving bouts of like thick information. You know what I mean? Like, I don't know, if you're in the act, if you just assassinated Charlie Kirk, you're not texting stuff like, oh crap, I'm gonna have to leave the gun in the bushes by the building. That's stupid.
No, especially if this guy, why would he go through all the trouble of leaving a note, but then saying, make sure that you destroy this note after reading it? Why would he go through the trouble of trying to flee the scene and not get caught? Why would he be, why would he give a record of everything he did blow by blow to this guy? If he was concerned about, I mean, obviously, clearly he wanted to, whoever it was, they wanted to get away, so it just makes no sense. They wouldn't leave a complete confession.
But do you understand, like, do you know what I mean? But like, they wrote the story out, like, that's too much information, in my opinion, for text.
Oh, that too,
Too
absolutely. That's not how people talk. It's specific. Like it's like they specifically hit all the talking points that they knew they would need to hit for a trial to convict him.
Exactly. And they're
shows that
basically
it's premeditated.
storytelling. It's not
Do you
normal
recognize this?
conversation.
I do.
What is this?
This is a handwritten note or letter from Tyler to Lance.
How do you know that?
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received.
Wait a minute, that
It
letter
states
was
from,
destroyed.
11 p.m. on September 10th.
How do they have that letter when it was
And so
destroyed?
at that point, Lance.
Wait, remember
finds
Lance
this
took a
is the letter he
picture of
finds
it.
under that keyboard.
Okay, so to
Yeah, a
clarify,
picture of it,
Mr.
but not
Twiggs
the
gets a
actual
text
letter.
from Mr. Robinson around 11 p.m. on September 10th, telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard.
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned, I just want to make sure the record's clear. You mentioned Celebrite a few times. What is Celebrite?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data, to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. That's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Celebrite phone extractions. Have you spoken to the law enforcement officers that performed the Celebrite extraction on Mr. Twiggs' phone in this case?
I don't believe I specifically talked to those individuals, the RCFL, that did that. But they, yeah, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I've spoken to, I have spoken with the SIAC analyst who particularly found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twiggs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense.
Stop blocking everything from the public.
Is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
The public is not getting to see anything. This is so ridiculous. Why do we even have? Yeah, why's the hearing even broadcast? Why are we even broadcasting the hearing then? This isn't transparency. Yeah, when they get to hide all this evidence from the public, that's not transparency. You know, and they want us to believe if they really want us to believe that they have the evidence to really convict this guy, why not show it to us? Why do they continue to hide it?
Not only that, they're cherry picking.
Exactly. Yeah,
That's
exactly. You're right.
worse.
Even the evidence they're doing, they're skipping through it and only picking certain points and stuff, you know?
Yeah.
It's disgusting. It pisses me off.
Well, I was trying to figure out earlier. The different parties' motives. Like, as far as the defense team, why do they want to redact and keep stuff out? And then the prosecution, they seem like they're pushing to release it all. And then, right? And then there's the media person who also wants it all released.
Yeah. I really don't get the defense's perspective on this.
I don't either.
Like I said, we are their best weapon. Why would they not want the public to see all this evidence.
That would really strengthen their case.
I do.
What is it?
These are the
Because they
images
don't
that the
have
FBI
anything
released
on
to the
Tyler
public.
Robinson,
That
and,
would have been on
the people
September
can see
11th
that.
when those were released. And this was, yeah, those were those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does States Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections, thank you.
All right, noting the standing objection by defense, overruling that objection, States Exhibit 16.4 is admitted into evidence and may be published in the courtroom.
And again, in the Discord,
Completely ridiculous. Makes absolutely no sense at all, man. It makes me, I'm so frustrated by this trial, honestly.
I mean, they're not even going through the motions. Like, they're clawing their way through this thing like it's difficult.
Yeah, they're
finding any reason to stop and pause.
Yeah, I mean, this is about the slowest preliminary hearing I've ever seen, man. They're just dragging their feet on everything, like you said. It's crazy. It's absolutely
Oh, they're not just
insane.
dragging, like the judge is digging his heels in.
Oh yeah, the judge, absolutely. The judge is like, honestly, the judge is like aggravated. Like he seems to have an attitude just because he has to do his job, and they want him to like make rulings on things, I don't understand why it's muted.
They're scared to death that someone's going to hear something in a hearing. It's the strangest thing. I don't understand. So if we were still able to hear the audio during Lance and that guy, the interview talking, was Lance showing things on the screen? Is that why they blacked it out?
I think they were showing pictures, like they were taking like copies. I think they were showing copies of like the text messages and stuff, showing him them, and we're like, is this the Discord? Is this what you were talking? Like, I think that's what they were talking about. But the thing is, like I said, all that stuff is already out in public. There is zero reason for them to have hidden any of it. Why? Why would they hide any of that? It's already been out in public. There's zero reason for them to hide anything from the public because it's already out there. The cat's already out of the bag,
Yeah, this is I mean, this just goes to show that you all have done more of a thorough investigation and you've been preparing this whole time, which is what these people should have been doing.
Yeah, 100%, absolutely.
They've had like 9 months to prepare for this.
Yeah. Actually 10. It's been like 10 now, hasn't it? I think it's been 10 months now. Well, real quick, while we're waiting on them to come back, let me go ahead and read some of these buy me a coffees. So we have, okay, well, we read Medusa's from yesterday for that one. Ryan Mata left the message there. What's up, my brother? Thank you very much. Thanks for having me on, G. Keep up the great work. Appreciate it, brother. Appreciate the support. Definitely, man. Absolutely. I love your work too. He's been doing a great job on this as well. So, you know, to have the respect of somebody like him definitely means a lot to me, for sure.
He's great.
Yeah, absolutely. I love Ryan. Then you have Gabe Connects here. Left us a buy me a coffee. Stop genocide everywhere. Gabriolo stands up. Absolutely, 100%. Genocide is, as in the words of Candace Owens or whatever, genocide is always wrong. And I 100% agree with that. And what's going on in Gaza is 100% genocide.
And she got persecuted for that.
Yeah, it's crazy. Saying genocide is always wrong. How is that anti-Semitic? I mean, that's crazy. That's insane. So he says, or she says, I'm sorry, or Gabe or Gabby, was it Gabe or Gabby? Gabriola. Okay, well, I saw in an interview with the man from Gaza, the host asked, what can we in the West do? Speak for us. Speak soon before we all suffer and die in silence, the man said. That's what a sign does. It speaks. Let's bring an end to the nonstop killing of innocent people. Amen to that. I agree 100%. We all should be speaking out. We all should be against what Israel has been doing, absolutely, and with the U.S.'s support. You know, they're doing it with our bombs, with our munitions. We're allowing that. We are just as culpable in it as well. We're allowing them to do that, and it's wrong. And I don't support it, and I think it's 100% wrong, and I think we need to stop it 100%.
I mean, we shouldn't have any foreign influence. People want to think that they're not a foreign country. They are.
Yeah, exactly. They are, you know, Israel's a foreign country. And that's the thing is, yeah, like they're the homeland, so they get special treatment. No, bullshit. Absolutely not. You know, they are a state or a country just like us, just like anybody else, and they have to be treated the same. They don't get excluded from the rules and can do whatever they want. Absolutely not. You know, especially when they're going out there and doing stuff like this, just egregiously evil, like going out there killing and slaughtering, you know, women and children and innocent people. You know, especially, I mean, that just, it's sickening. You know, I've seen all those videos from Gaza, and I would highly suggest. I mean, it's horrible to watch, but if you go on Telegram, there's a whole bunch of Telegram news channels.
I was going to ask
that
you.
Area.
I would like to see it personally because I want to see the truth.
Absolutely. There's a whole bunch of Telegram news channels where you know, you can actually see these raw videos coming out in Gaza where you know, like the you know, as the you know the aid workers or whatever, Israel guards are there with machine guns, you know, with the aid workers, and as the you know, Gaza, to feed the Gazans, the you know, that they've been starving the Gazans. So, you know, they're out there supposedly to give them aid. And as all these Gaza people are coming up to get the aid, they're just being gunned down arbitrarily by the Israelis.
And it's just in the name of Israel, I feel like, just because they're Israel.
Yeah, they want to completely destroy all of them. They do not like Muslims. They want to completely eradicate everybody in Gaza. They think it's their territory, and that's wrong.
And personally, you know, with the influence they've had, they're making it to where our men and women in the military you know, almost have no
originally
choice
admitted it,
but to participate in the
contingent on
genocide.
additional foundation being laid
Exactly.
through testimony or through evidence.
We'll finish the buy me a
courts,
coffees when we get done.
Notes
Again, if
that
you
such
wanna
foundation
if you
and
wanna send a
testimony
buy me a
has
coffee and
been
have it
laid,
read, scan
in
the
order for
QR code
foundation
on
to
the
be
bottom
laid
right
for
hand side of the screen
5.1 to be
there,
admitted into
and
evidence
we'll
for
read
full
your comment.
consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense that this is going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression, and that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant, how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and it's not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Thank you. Yes, we do. And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you.
I don't even know what we're looking at here.
I know.
Yeah, I can't even read it.
Utah County Attorney's
Yeah.
Office.
I see that. I think it's like some kind of statement or something, victim statement or something, but I can't, it's all whited out. It's hard to, you know, the screen's so bright, I can't read any of the actual writing. If any of you guys can make out what that says, any of this actual writing on it, let me know, because I can't. It looks like it's in white. It looks like white writing on white paper. You can't see anything.
I think they whited it out. Notary acknowledgement. Okay, one other acknowledgement.
Yeah, exactly. I said it looks like it looks like all white writing for some reason. Why would they even, like, you can't see what it is. And how is this graphic? It's a piece of paper. How is it graphic? It's a piece of paper.
I believe that should be sufficient.
Ridiculous.
It's not.
And
It's not sufficient. But
Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twiggs. Kimberly, if you could turn to page 17. And because this has already been admitted and, court, correct me if I'm wrong, published not only to the gallery, but to cameras at large, I'd ask that it be displayed in that fashion again.
All right. Any input from any other party on that request? All right, thank you. It may be published, and the media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with if any, if you could read that out loud.
Okay. This is Tyler. He says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there.
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail.
Yes,
And that you were the booking officer.
that's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's the individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel?
No objection.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness. Thank you. And I don't know if now would be a good time for lunch.
All right. We'll go ahead and break right now for lunch for 1 hour, well, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up with defense for cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Not the state.
No cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination. May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next witness. Court is now in recess.
All right.
Better psyops, better psyops.
Yeah, I demand better psyops too. Absolutely.
That needs to be our mantra.
Absolutely, man. And then this person said, these texts are damning. LOL. Yeah, they're very damning. Absolutely.
I'm telling you,
Damning.
this whole hearing thus far today has just been a big crock of nothing.
No, honestly, it has. There's been honestly, we haven't seen anything new. You know, all they did was they played Tyler. They argued a whole bunch about admitting stuff. They argued a whole bunch about admitting video of Tyler reading out the text, or not Tyler, but of Lance reading out the text messages and Discord that we've already seen in the public. So we argued about that. We saw a little snippet of that, and that's basically it. You know, that's all we've done all day. There hasn't really been anything else.
No, it's a nothing burger. Is Tyler going to get to talk today?
No, I don't think he's going to talk at all during this preliminary hearing. I don't know if he's going to, for the actual trial, I don't know whether they'll put him on the stand or not, but for the preliminary, I highly doubt he will be on the stand for the preliminary hearing. That's definitely not customary. All right, so we have an hour-long break. Let's go back to the buy me a coffee here. And again, like I said, hold on, let me go back to the street. So if you want to support the channel, we're not monetized on YouTube, so we don't have actual super chats, but what we do have is buy me a coffee. So if you want to support the channel, you can scan the QR code down the right bottom corner of the screen, and you can leave any amount donation, whether it be $1, $5, $100, whatever. And once you leave a donation, you can leave a comment, and we will read out your comment just like a super chat. You know, we'll read it on the breaks and stuff. And that's what we're going to do here. And I'll drop it in the. I'll go ahead and drop the link in the live chat as well for you guys one more time. Well, it's pinned in the live chat to YouTube already at the top of YouTube. So if you're on your phone and you can't scan the QR code with your camera because you're on your phone, all you do is you go to the top of the live chat and it's pinned to the live chat in YouTube. And I'm also, like I said, I'm about to drop it in the live chat for X as well. Give me 1 second. Come on now. Why are you still loading? There we go.
I'll be right back.
Okay. Okay, there you go. So I just dropped that in the live chat on X. I'm going to drop it in the live chat on YouTube as well here, and Rumble, because we're on Rumble as well. So I'll drop it there too. There you go. All right. So again, if you want to send a super chat, just scan the QR code, click the link in the chat, or that's in the chat now, and we'll read them out like a super chat comment. So let's go back and finish where we left off here on these. Okay, so the last comment we read was Gabe Connects here. So the next one up is Medusa USI again. Thanks for day 4. Appreciate your support again. You've been here every day with us as you know, you've been watching with us every day, and I definitely appreciate your support. You donated every day as well, so I appreciate that as well. Thank you for joining us. I'm glad you chose us as opposed to anybody else. And then we have Spokeswoman on X says the FBI made up the story as they went along. My BIL. Oh, brother-in-law. My brother-in-law was on the scene that day where they found the rifle on campus. There's a big rift between state cops and the FBI. Keep up the good work. Yeah, we actually heard a little bit about that. I remember there was a story early on where supposedly that there was of course Cash Patel tried to downplay and be like, oh no, there's nothing wrong, but there was a rift early on between local police and the FBI for sure. Specifically
Well, that's
about
the thing.
evidence sharing and everything.
I was expecting to hear more from Utah law enforcement.
Yeah, they haven't. Honestly, they haven't really brought any. Well, no, the first day they brought 2 local cops on the first day that testified. And then outside of that, we had Brian Davis, who's one of the state cops for the SBI, State Bureau of Investigations. And then there was another one, I forget his name, but there was another one also that testified. Was it yesterday, or might have been yesterday or the day before? but he also was from SBI as well. So there, yeah, we haven't really heard from many of the local cops as well.
Who was that annoying Australian guy or whatever?
Annoying Australian guy.
He kind of had like hair on top, slicked back, with glasses. You don't remember him?
I don't know. I don't know what you're talking about. He was a cop?
I think, yeah, he was there that day. I'm not sure. Maybe campus. I don't know. I'll have to show you.
Yeah, you'd have to show me. I don't really know. Oh, we got one more here too. Gabe Connects again sent us another one. Stop genocide. Start where you live. A lawn sign campaign has started on Gabriola Island. GabriolaStandUp.ca. One sign on your property. A visible public statement that you are not looking away. It can happen where you live too. Canada, what's it say? CanadaStandsUp.ca. Absolutely. If you wanna follow and support the campaign right there, you can go check that out. It's GabriolaStandsUp.ca. GabriolaStandSup.ca. Definitely go check them out for sure. And I agree, you know, we should all make our points very vocal about that, you know. Honestly, we should do it about anything that we feel strongly about, but especially something like that. Everybody should be speaking out and saying how wrong it is, and you know, making our voices heard, that we will not tolerate it. So thank you for the support, and thank you for watching the stream with us today. Absolutely. Let me get some of these comments here and see what you guys are saying in the chat. Okay, SBI David Hall with the Aussie accent. Okay, that's who you're talking about. All right, okay, yeah. Now I know who you're talking about. Yeah, that was a cop that testified. Yeah, he was lead investigator for SBI, I think. Yeah, okay.
He didn't do a good job.
Yeah. No, not at all.
And maybe he is a Brit.
Yeah, I think it's Aussie accent, to be honest with you. Yeah, I think you were right about that. Mr.
Yeah,
Snow said, wait a second. I think Twigs may have given DNA as to not be flagged by crime database. I'm not really sure what you mean by that. If he gave his DNA, any DNA they test would automatically go into the database, the crime database, I believe. So I don't think there's any way
it'd be a
get around
match.
that. Yeah, I mean, it would go into the database regardless. But as far
unless he
as
pops up as a fed.
As far as, you know, now, like I said yesterday with the DNA, is the prosecution specifically told the DNA technician to use Lance Twigs as to be able to exclude others from the DNA. So basically they said, we already know Lance Twiggs' DNA is going to be on the rifle, it's going to be on the screwdriver, it's going to be on the towel. So we don't need you to test that, so you can exclude him. You know, we just have to worry about these other people. And like I said, that's important because Tyler Robinson did not meet the minimum threshold on the DNA to be excluded as a possible contributor. According to what they were saying in the testimony, there's like a scale that they have to meet, and it was a score of 20 or greater. You have to score 20 or greater to be listed as a possible contributor to a DNA sample.
Colin.
If they're, hold on a second. What you say? What? You okay?
Are you asking me?
Yeah.
Yeah, we're good. Go ahead.
Okay, yeah. All right, yeah, just hang on a second. So you have to, so on the DNA, you have to score, if there are 2 or fewer possible contributors, you have to so yeah, 2 or more possible contributors, you have to, it's a hard line. You have to score 20 or higher to be listed as a possible contributor. Now, if there are 3 contributors or more to the DNA, then you can, it lowers that bar or whatever, and you can, include somebody that has a lesser sample. Like Tyler Robinson, I believe, was only like 12 or 14 is what his score was, not the 20 that's required. But the thing is, the only reason that they were allowed to admit Tyler Robinson as a potential contributor to that DNA is because of them using, or them excluding Lance Twiggs. But because they specifically made the woman switch from 3, I think I had it backwards. If it's 3 or more possible contributors, it has to be 20 or greater. 2 or under, then it can be less. So I had that backwards. Sorry about that. So because that woman, she initially said it was 3 contributors to the DNA, which means since Tyler Robinson scored less than 20, he would not be listed as a possible contributor, which means the only DNA that they could definitively say was on those items was Lance Twiggs. Tyler Robinson would not even hit the threshold to be listed at all whatsoever as a possible contributor. But because she made had a discussion with the prosecution, and the prosecution then told her to include Lance Twiggs in the DNA sample to get it above that threshold, because like I said, it's between 2 and 3. If it's 2 or less, he can't be admitted. But if it's 3 or more, he can be admitted as a possible contributor. So they specifically then, even though they first said that he was going to be the excluded, but since they then had a conversation and made him, then they included him as a possible contributor. And because they included him as a possible contributor, then that made it greater than 3, which means they could include Tyler's DNA or as a possible contributor, with him only scoring either 12 or 14 instead of the 20. So they're playing games is what they're doing. The state is playing games. They're fudging the numbers to try to claim that Tyler Robinson's DNA is on these items when it's not. The only DNA that they have for sure definitively on those items is Lance Twiggs.
Yep, and I was going to tell you, Brandon Tatum has been in the courtroom, and he made a point that he would be in there to prove all of us wrong. Well, he said yesterday that the reason why, Lance's DNA is dominant on those items. What is it? A towel, a screwdriver? What else is it?
Towel, screwdriver, and gun.
And the gun. Brandon said, you never know. Lance could have handled those items at their apartment or back at their place. That's why his DNA would be on them because he handled them at home. And I'm like, no, if Tyler Robinson actually used those objects the day of, it would predominantly be his DNA and it would be fresher.
Possibly, yeah. Not necessarily, but yeah. I mean, obviously his DNA would be the freshest and it would be the newest, but you still could get other DNA from it as well. But at the same time,
I mean, I just feel like if he handled those items the day of, his DNA should show up. Tyler Robinson.
Oh yeah, absolutely. He wouldn't be listed as just a possible contributor. That's right. Absolutely, 100%. You know, his would be the predominant DNA on there if he was the last one using it. Absolutely. Yeah, that you're absolutely 100% correct on that. Gotcha. Yeah, that's 100% correct. And you know, obviously Lance Twiggs handled the items, and I don't think he handled them at his house. I think he was the one that set them up. I think Lance Twiggs was actually the one that was on campus that day. One of the people.
I think he was
there were
roaming
multiple,
around.
but I think he's one of them. Yeah. And even the images that they showed, the person had long hair, and Tyler Robinson doesn't have long hair. Lance Twiggs is the one that has long hair.
Really? There's like in the video, like the stairwell and stuff. Where are you talking about seeing the long hair?
It was, I think it was the stairwell video. It might have been that.
I didn't
Let me
notice
go back
long
and
hair,
look
but if
again.
that's the case, if it shows
Yeah,
long
definitely.
hair, then they have nothing.
Here, let me go back and see if I can find it again. Is this the one? Oh no, that's not the one. That's the car.
Oh, this woman commented on my page, said she loves us both.
Oh, that's awesome.
I think she's been on here. Drea Racino.
Yeah, I saw. Yeah, I think she's been in the chat. I think I saw that name in there. Two different DNA. Nice Twigs DNA. Breaking DNA found. Video drops. Okay, yeah, this is the video I was looking for.
Proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here?
Are they back? Oh,
No.
you're going back.
25.
What
8:30 in the morning.
was it?
Okay, let's watch this guy.
It's the individual in the red T-shirt and the shorts and the shoes.
That's that Australian guy.
And do you believe you recognize who that
Yep.
person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
You know, they could easily
And
do a
where's he
side by
going now?
side of his gait.
Yeah, why haven't we seen gait analysis yet? You know, they did that in the pipe bomber, the DC pipe bomber, you know, that sent the pipe bombs to the RNC and DNC, and you know, with the January 20th pipe bomber. Why haven't we seen anything about gait analysis in this case? Probably because it doesn't
He
match.
heads out of the parking garage on foot into the campus, and actually goes to the quad area of the campus.
I think this is just one of the couple patsies.
He makes
Oh yeah, definitely, 100%.
contact with some representatives from TPUSA.
By quad area,
Sorry,
And by the way, that's important. You know, made contact with a couple representatives from TPUSA. That is important.
So
I
is
want
he
to know who those
saying-
people are.
Yeah, they should have been interviewed already and everything. So are the TPUSA representatives claiming that they came in contact with the patsy with the maroon and gray shorts, or did they give a description at all?
I don't know which one it is. They came in contact with one of them, but I'm not sure which one it was. And Blake Neff didn't clarify. He did verify that you know, yes, they did, you know, have contact with him or whatever, but they didn't clarify whether or not which one it was, what the person was wearing or whatever.
Well, that would have been useful.
Yeah, absolutely, I agree.
I like how people on Twitter are they're doing the height comparisons. Have you seen random people doing that?
Yeah, it's important. Absolutely.
Doing a walkthrough through the campus. Yeah, I mean, that's what these bozos should be doing.
You can see with that height analysis, you can see it's two different people for sure.
the amphitheater is what I previously referred it. To.
So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
Have they identified the
And where's this
vehicle?
parking structure located on campus?
No, they're trying to say it was Tyler Robinson's vehicle for sure, but it's not. It doesn't match. There's things about it that doesn't match. The wheels, there's no, like Baron Coleman, I forget exactly what it is, but Baron Coleman pointed out that there's things about the vehicle that do not match Tyler Robinson's actual vehicle. Also, it's too blurry to be able to get a license plate, so you can't tell for sure, you know, who it is because there's no license plate. I mean, there's a license plate.
Well,
but you
I was
can't
going to
read it.
say, you just answered my question. Like, what exactly are they connecting to this image? And this is really bad police work just to look at surveillance and just assume based off of, you know, nothing. It's blurred image. The car doesn't match. I mean, they don't.
Yeah, they're saying it's Tyler Robinson's vehicle because it's a gray Challenger. Tyler Robinson has a gray Challenger. And Tyler Robinson has the premium stock wheels, and this has premium stock wheels. And so they're saying, based on those 2 points, it's got to be him. They don't realize that there are literally probably 100,000 Challengers that are gray that have the premium stock wheels that are out there in the world. It could be any number of them. It's not a unique car. Even with the premium wheels, it's not a unique car because on a vehicle like that costs that much money, you know, people are only buying a Challenger like that for fun because they got excess money and stuff, you know. They're not going to get the regular steel wheels that come on it or whatever. They are going to get the premium you know, the premium alloy wheels for it. So almost every single almost every single one of these chargers that are on the road all have the premium wheels on them.
Well, I was going to tell you, you talked about like expenses. I mean, unless you have rich parents, college students don't normally drive stuff like that. Most college students have like a Toyota Camry.
Yeah, I agree. And his parents, to my
And
knowledge,
so-
are they were not well off before. I mean, I think they are now. And I would like to know who's giving them money, but to my knowledge, they weren't well off before. So I'd like to know how he can afford something like that.
Yeah, and I mean, unless that's the car was a project he had, and with his, what is it, remodeling, renovation, did he say shower? Is that their job?
Tyler allegedly did electrician work, but his father did tiling and remodeling.
Okay.
So for all I know, and I'm not 100% sure, but Lance may have worked for Tyler Robinson's father doing the tiling as well. I don't know.
Well,
It's
I
just
just,
off of-
that's expensive, and most college students do not have that.
Totally, absolutely.
Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
I want to see his actual charger.
I have a picture of it somewhere I've seen.
Now what do we see?
This is Mr. Robinson returning to the campus on foot.
This is the one that has the long hair, I think.
Neighborhood
Or it might have been the guy with the black. I can't tell.
to the northeast.
One of these
You
had
can
black
see he's
hair.
wearing the same
I
clothing
mean, long
as
I
in the
hair.
don't think
previous
he
video.
has the long hair.
And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with
Okay, yeah,
gray
no,
or
this
olive
one's not
colored
the long hair.
shorts and then
And if
Converse
he's in
shoes.
the Maroon Brigade, he's probably military.
And what time did he return to campus?
Just after
Absolutely.
10 a.m.
And by the way, these backpacks don't match. The person in black that goes up the stairwell that supposedly has a rifle in their pants, and then this guy, they have different backpacks, different color backpacks on too.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center,
And where is that in relation to the
upper back edge of the, then returned the railing at the exact time.
So you're telling me he got Chick-fil-A and then Dairy Queen?
Yeah, and that makes no sense. The guy, if he's just about to murder somebody, his nerves are not going to allow. He's not going to want to eat something, you know. That makes absolutely no sense at all. He would be nervous as a bat. He would not be able to eat a meal. And afterwards, yeah, he went to Dairy Queen and got a meal or a milkshake or something afterwards at Dairy Queen. Absolutely.
And wasn't that, did I hear somewhere that was 20 minutes after it happened, he was spotted at Dairy Queen?
I think it was around then. I forget exactly the time.
There's no way
remember
he
the
could have
exact
gotten
time.
off campus. No.
No, absolutely not, though.
I think it would be just to the north of the LDS Institute building, if I recall.
And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
So it's Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, we're able to track Mr. Robinson when he leaves this parking structure.
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive as you.
Robinson.
And by the way, you can see both legs bending in this too. He forgets what he forgets which leg he forgets which leg he's limping on.
When he leaves this parking structure.
Yes, we were able to.
Okay.
I was going to
So when
say,
he leaves the
I'd like
parking
them to
structure-
ask Tyler why exactly he was limping.
Well, it's not Tyler. That's the thing. It's not really Tyler.
Where does he go?
Well, yeah, but that's what I'm saying.
Well, he would just say it's not me.
He comes up around Campus
Yeah.
Drive, as you can see on the video here. There is a cut through there north of the Losi building, and that's Mr. Robinson coming up the side rear of the scene, moving under the no.
All right. Well, that's not important. I don't know why. Actually, it is important. There's something I want to show you with that real quick, actually. Give me a second here.
We should go back and watch that Lance Twig interview thing too.
Gotcha. There wasn't really anything of importance in that, though, honestly.
No.
Hold on. What was I looking for? Let me find it real quick. This is important. Yep. This is what I want to say. Oh, wait. No, that's not it. Hold on. Damn it. Ah, okay, this one. Okay, so check this out. There is, you see something, a person, it looks like sprinting or running on the top of the low-C roof. That's not Tyler, suggesting that there might actually been two people up there, two separate individuals up on that roof. So if you look at this, okay, so now this circle right here on the left-hand side, that is allegedly Tyler Robinson, or whoever it was that supposedly fired the shot, right?
Right.
So pay attention, because you're also going to see another person. You're going to see another circle pop up on the right-hand side, or actually it's going to be, you're going to see it right in the middle of the screen. Right at the edge of, the other, it looks like this thing on top the Losi building, whatever that little building thing is on top the Losi building. But you'll see another circle
Right.
appear there and run across to where like Tyler is. Pay attention to that. It's very faint, but you can pick it up. There, it looks like somebody else there.
Yeah.
All right, now look, watch. You see it? You see it looks like somebody running there?
Yeah.
What the hell was that?
Wow. Wow. It looks like that one down there to the left is wearing black, but
Yeah, for sure.
that is weird.
The other one looks like it's black. They're wearing black too, but you can't really make them out fully. It looks like they tried to like digitally alter it with AI to block that person out or something.
What, do you have the video? Do you remember the video where he's coming down off the roof? I think you're muted.
You could see the guy running across there as well.
I think you're muted again.
Yeah, I said I should put that out real quick. I meant to put it out earlier before we went live, but I was too busy setting everything up and got sidetracked. I'm gonna go ahead and put that out on my feed real quick, because that's important that people see this.
Do you have the video of him stepping off the roof or coming down off the roof?
Yeah. We just looked at it. Hold on.
That judge, man.
I agree. The judge is horrible.
He's the one slowing all this up.
Yep. All right, hold on a second. I'm almost done this. Like I said, I want to put this post out real quick because I think this is important for people to see this.
No, it's definitely good footage. Actually,
Okay. Right. Okay. Just now let's go ahead and post this. Okay, there's that. And make sure I give credit to this guy. Everybody, by the way, just so you guys know, if you send me anything in the future, that you want me to look at or put out or whatever, I always give people credit. I don't just steal their videos and put it out as my own. I always make sure to credit people and direct people. Let everybody know, hey, this video came from such and such. Go follow them. Make sure you go follow them.
You really are good about that. Most people aren't.
Exactly. I've always been one to want to try to help out the smaller creators and give them credit that are doing good work as well. Because we were all small at one point,
Yeah.
That's what it's about. It should be about a team effort. A lot of people aren't like that. A lot of people are just out for themselves and are real selfish like that. I've never been that way.
For sure.
Yeah.
But yeah, the smaller platforms aren't going to get near the credit that they should on this case.
No. All right, so new roof footage appears to show second person sprinting towards shooter's position on Losi building, on Losi roof. Okay, well, cool. So while that's loading there, let's see what time it is. 3:16. Do we remember what time they said they were coming back from lunch? I don't. Do you? I know
It
they
said
said it
an
was an hour and
hour.
5-minute break or whatever, but okay, it says recess till 1:30. So we have another 13 minutes to go.
What was that other thing that you were going to show? Do you have the video of him coming down off the roof accessible?
I just showed it. That's what I just showed.
Oh.
That's
I guess
literally
I
what I
missed
just
it.
showed you guys. I'm gonna see if I can find the text messages or the Discord messages that we can look through real quick.
Yeah, I'm interested
'Cause I
to
want to
see what
show
Tyler
people what they're trying
Robinson.
to hide.
I'm interested to see what Tyler Robinson has to say about that text thread.
I agree. Actually, yeah, here's a good one. We can just watch this clip from Candace. Let me share this tab here. This was on April 20th. Let me make sure I got it full screen. There we go. All right, here we go.
Is it supposed to be muted?
You can't hear it?
No.
Okay, I don't know what happened. Let me take it out and try it again. Should have been muted. Okay, let's try again. Here we go. Can you hear it? Oh, hold on.
We can assume include the text messages that they very early on released to the public, right? The ones that
Yeah.
Can you hear it now?
Yeah, I would just,
You
turn
hear
it
it,
up
right?
a little bit, but
Okay.
yeah, you can hear it now.
There's no way to turn it up. I think it's all the way up. Yeah, it's all the way up.
Yeah,
it actually
that's
gets
fine.
worse because the prosecution, we learn, is planning to present 35 exhibits at probable cause hearing. 35, let's call that pictures, if you will, which will, of course, we can assume include the text messages that they very early on released to the public, right? The ones that sounded like they fell out of a Jane Austen novel. My love, this, that, I did everything, he A to Z. Well, of course, we were first told that those were Discord messages, but now they are text messages. And you're about to hear Kathy Nestor assert, that's another person on Tyler Robinson's team, that they have not yet even been given access to Tyler Robinson's phone. Could you imagine going into a hearing and they're going to be like, look at these text messages. This proves he did it. And you didn't even get access to your client's phone? Because I'm assuming, obviously, they took his phone. Take a listen to her say that.
I also have not been able to get into my client's phone. The electronics that we have required an expert because they're so massive, we had to all get these huge hard drives shipped to us from our digital expert. I have not looked at my client's phone, and that concerns me, especially because the state's indicated they may call individuals uniquely connected to my client. I'm not going to say who because I don't want to commit you guys if you call them or not. But we've been given the names of some witnesses they may call, and what is on my client's phone I think is going to be really important.
Yeah, I think it's going to be really important too, because that's what everybody has been saying is the slam dunk proof. He confessed in all of these messages. Oh, we're going to bring up we're going to bring up Lance Twiggs to talk about these messages that he received, and the defense can't prepare any arguments because they have no forensic information regarding whether, I don't know, was Lance holding both phones at the same time and texting himself? Did it actually happen on Discord? Did it happen on the phone at all? Did they make up these text messages entirely? Did the feds make them up? Right? Because I could make up screenshots right now and claim that these were real messages, but only an expert, a forensic expert that's given access
I was
to
thinking
the
that
electronics to
today.
determine if they were real, where they were sent from, all of the data, the location.
Exactly. There's no way to tell if they're
The
even
meta.
real.
Everything is authentic.
Let's see the metadata.
Exactly. That the metadata is going to be very important in this. I also
Yeah,
want
I
to see
wasn't
if I
really
can find the
blind.
actual text messages. I want to show you guys what the actual text messages say, because it's I want you to hear just how absurd they sound. Hold on. Nope. Okay, well, let me ask Grok.
I want that blonde woman to come back. That attorney, I thought she was doing a good job.
Oh, she was horrible. You're being facetious, right?
The one with the blonde bun?
You mean the fatter one, Kathy Nestor?
Yeah. Yeah.
Tyler's. Oh, okay, yeah. I thought you were talking about the one, the prosecution yesterday. The little intern woman. It was horrible. She was out there playing lawyer, pretending to be a lawyer.
And she kept turning around and looking at them like, am I doing this right?
Mm-hmm. Damn it, that's not. I want to see. Let me go to YouTube. Hold on. There's got to be a way to find them. Tyler Robinson text messages. Come on. Okay, here we go.
Now, the following text message exchange then took place. Now, after reading the note, the roommate responded, "What?" Exclamation, question. "You're joking, right?" So the ruse begins. Robinson says, "I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but I gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I'm sorry to involve you. Okay, you weren't the one who did it, right? I am. I'm sorry. I thought they caught the person. No, they grabbed some crazy old dude, then interrogated someone in similar clothing.
Now, by the way, I just listened to this stuff. Who, number one, who talks like that? And secondly, who gives that much detail and basically gives a play-by-play of every guilty thing they've done, every criminal act? Who would write all that in text messages?
I had planned to grab my rifle from my drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
Who says vehicle? Who says my vehicle? Vehicle. People just say my car.
Lingering.
They don't say my vehicle. Yeah, and lingering, that too, absolutely.
Roommate says, why?
This is cop talk right here. This is how cops talk.
Why did I do it? Yeah, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence except this note, except this series of text messages. Now, the following text message exchange then took place. Now, after reading the note, the roommate responded, what? Exclamation, question.
Okay, so that was basically all we had of that short there.
What I was going to say is also to be admissible in court, in writing, it would have to be worded in such a way to be considered an admission. It would have to be worded in such a way. And the fact that he's like, oh, did you actually really do this? And he's like, yes, I did.
It seemed like they were definitely trying to set it up. They were like, oh, we need to frame this guy. So let's make sure, we put into text, make sure we pretend like he's saying everything that we need to hit, all the points we need to hit in order to make sure that these charges stick.
Yeah. Nope, they made sure they covered all bases to prosecute him, really.
Yeah. It's crazy, but it's not going to fly, though. We saw right through it. We saw right through the text messages. We saw right through the Discord messages. We saw right through the 30-odd sick Fed slop story. I mean, everything they're putting at us, we're just destroying it. There's no way that they're going to get a conviction on Tyler Robinson. There's no way.
No, I'm telling you, if they're using that surveillance and those text messages as solid evidence to convict him, there's going to be an uproar. I mean,
oh, absolutely.
They're saying we don't. They always say we
believe
don't
that they're fake.
Yeah. And yeah, we covered this a long time ago. I like how they're treating all this evidence as like fresh.
Yeah. By the way, this is the Turkey Tom, the Discord logs. It was first released. So Turkey Tom, the Charlie Kirk killer Discord logs. I highly suggest you guys go watch this. But this is basically everything about Lance Twiggs is in here. But we'll go through just a little bit of this while we're waiting still. AKA a federal agent, are the ones that leaked this stuff to Turkey Tom.
Are you gonna put it up?
What did you say?
Are you gonna put it up? Are you gonna share it?
It's not on the screen? Hold on. Oh, shit. My bad. I thought I was sharing that.
No, you're good.
Ken Klippenstein, which were then republished by every major news outlet. The other picture is a completely original photo of local police at Tyler Robinson and Lance Twiggs' place, taken from across the street. For the sake of verification, he later also provided me with archives of the 3 Discord servers they shared, which I'll eventually go over the relevant parts of. Once this person's identity was verified, he proceeded to tell me about the state of Tyler and Lance's living space. The apartment would drastically shift from clean to super dirty, depending on the state of Lance's mood. I don't have too many pictures of most of the mess, but basically, he'd start living in the living room and just start turning it into his nest. After the first roommate moved out, and right after Tyler moved in like 2 weeks later, Lance had a really big breakdown. The living room went from a place guests came over to something that had to be hid. People still came over, but everyone got weirded out by all the trash. He basically had layers of wires, random Temu trinkets, decorations, random art projects, clothes, and empty alcohol containers everywhere. And if anyone touched it, he would get livid. One friend got banned from the apartment for a while because he kept touching the Temu trinkets. I wish I still had pictures, but I felt sort of guilty and deleted them since I knew Lance wasn't in the right state of mind. For context, I've been playing games with Lance and Tyler for like 6 years. I count myself kind of close to them, but I was trying to separate them from myself because being around them wasn't good for me. I say them, but Tyler was always level-headed and easygoing. But Lance could be anywhere from too depressed to talk to manic, wide-eyes, crazy person. I'll take a brief moment here to comment on the fact that in my original video, this is more or less the impression that I had, judging exclusively from Lance's more significant and expressive online presence relative to Tyler's almost non-existent digital paper trail. From Lance's Reddit account and the things his family members had to say about him, he clearly was more outspoken and in some ways unstable. There were Reddit posts of his mentioning being at odds with his family to the point of being kicked out, and he had also discussed a lot of substance abuse issues, which are a far cry from the quiet, even if uneasy relationship that Tyler seemed to have with his family. What was completely unknown, and as far as I know, hasn't been published anywhere, is this combination of hoarding.
There's no way. That guy's mentally unstable.
All right, Sergeant, if you wouldn't mind.
Oh, big time. That's the whole thing. Is Lance is a completely schizophrenic. His family said he tried to kill one of the family members with a knife. I mean, he's a nutcase.
No, Tyler Robinson definitely seems like the level-headed one.
Without a doubt, 100%.
And Lance even admitted that he never talked about Charlie Kirk or LGBTQ stuff. He said that.
Exactly, you're right. He did.
Sergeant, if you'd like to come forward, you're still under oath from your previous testimony from the previous day. So if you'd just like to come up to the witness stand, be seated to your left. Behind the monitor should be a bottle of water. After you're situated, if you wouldn't mind just pulling that microphone toward you to ensure that the audio is picked up. Mr. McBride, your witness.
Sergeant Falmuina, good afternoon.
Good afternoon.
We briefly covered some of your involvement in this case the other day. I want to return back to your initial assignment to this case. When were you first assigned to go to the campus of Utah Valley University?
On September 10th of 2025.
What time did you get that assignment?
I believe it was approximately 1:30 p.m.
And where were you when you received that assignment?
I was at a headquarters office in Salt Lake.
And did you go directly down to the campus?
Yes, I did.
And will you describe what you're seeing as you arrived there?
Yes, when I arrived there, I actually arrived onto or near the south end of campus, and that's where I saw multiple police cars as well as multiple officers from various agencies. Then I was asked to respond to our command post, which was in the Fugal building there.
And the Fugal building, we've had some testimony about this, but is that just to the south of the courtyard?
Yes, that is.
And were you there while officers were securing campus?
Yes, I was.
And do you know generally how that was done?
I don't know the specifics, but I do know that officers were canvassing the area, trying to look for a suspect, but also trying to see if anyone else was injured, and then making sure that the scene was secure and that no unauthorized people were allowed in.
And I think you testified earlier. What was your primary assignment?
My primary assignment at the campus, as well as throughout the case, was to oversee the crime scenes as well as the physical evidence.
Before you could do your work on the crime scenes, did the campus have to become secure?
Yes, it did.
And did that involve making sure there was no active shooter on campus?
Yes.
And did that involve officers searching buildings and clearing buildings throughout campus?
Yes.
You mentioned that were there multiple areas that were processed by you and other crime scene analysts in this case?
Yes, there was. Would you like me to go over them?
Let me direct you to a few of them. Well, yes, please mention the scenes.
Yeah, so one scene was a courtyard area, or I guess what we could also refer to as the amphitheater where the event took place. The other scene would have been the Fulton Library, where there were 2 bus stops. And then another would have been the wooded area. And then the last one would have been the Lolosi Center building, as well as the ground below.
All right, let's start with the rooftop. What was who was assigned to process the rooftop area?
The team that was assigned to process that was the Utah Bureau of Forensic Services, or also known as our state crime lab.
And generally, what does processing an area involve?
Processing includes documentation, sketching, as well as taking photographs, marking, as well as labeling evidence, and then determining how to package them properly, as well as also just trying to ID anything probative.
On the rooftop was evidence found?
Yes.
What types of evidence were found on the rooftop?
One item of evidence that was found was a screwdriver. Another one would have been what we believe was the shooter's perch. That was determined that was easy to see at night. Using oblique lighting, we could see disturbances in the gravel on the rooftop. And then on the northeast edge, our team also found some swipes on the ledge of that rooftop that was also collected.
Okay, so northeast ledge. And is this the dropping off point?
Yes, it is.
You said swipes. What does that mean, swipes?
Swipes is, I would describe it as kind of hand marks or any type of marks that is left by something that causes some type of disturbance.
Okay. And where on the ledge were those located?
Those were located right on the edge of that right on the edge of that rooftop. And then right below, we also had some other swipes as well as some other impressions. And then below that was a glass window where we also located some latent prints.
Okay, I want to return to what you've referred to as the perch, the sniper position. Were measurements taken from that sniper position to the tent where Charlie Kirk was seated?
Yes.
Do you know the distance?
Yeah, so the distance from the perch area directly to the tent where Mr. Kirk was sitting was approximately 415 feet. If you break it down, so from the perch to the tent, you're looking at is basically like this. If this is the perch and this is the tent.
And now you're describing, I'm sorry, I have to make a record. You're describing an angle, a slope downward from the perch to the location of the tent. Is that accurate?
I am.
Okay,
Thank
go
you.
ahead.
Yeah, so the angle, so again, the distance, the perch to the tent was approximately 415 feet. If you think about it, or without taking into account the elevation drop, it was actually 410 feet, so just horizontal straight across. And then the elevation difference between that is approximately 68 feet.
Okay, 410 feet from the perch to the tent with a 68-foot vertical drop. Is that
Yes.
right? On the rooftop, were shoe impressions found on the rooftop?
Yes, there was.
Did those who processed that area of the crime scene collect the latent prints and the shoe impressions that you've talked about?
Yes, they did.
This is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that
Then why even
the area
mention
in the
them?
glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low C Center.
It should be exempt.
That's the area where we
If
see
it
in a
didn't
video
match
an individual
anybody
drop from
in the
roof.
case, why even mention it? We didn't
Wanna move
see
on to another area.
whoever dropped off the roof
courtyard.
touch any windows.
First, will you describe what that area of the crime
We
scene
have the video of him leaving, jumping off the roof and running away.
Yeah,
He
so
never
when I
touched any
arrived on
windows.
scene, you have different steps. I believe there were maybe like five or six covered in grass. When I was there, there were personal belongings spread throughout. There was a tent towards the west end of that courtyard area, as well as some banners and some barriers as well.
Was that area processed for evidence as well?
Yes, it was.
What was done to process that area?
Photography, as well as just examining the tent area to see if there's anything there.
And who is assigned to process the courtyard area?
The FBI.
I don't want to take you to another area, a wooded area. Was there a wooded area that was processed as well?
Yes, there was.
Will you describe, first off, where that area is?
Yes, so this area is located northeast of the Low C Center building, and it is across from Campus Drive.
Your Honor, could we publish Exhibit 35, please?
Yes.
And if I may approach the witness, I'll put up the hard copy of this exhibit as well.
All right.
Can we publish oh, thank you. All right, on the screen in front of you, will you take a look at Exhibit 35?
Yes.
Do you recognize that?
Yes, I do.
Will you take a moment to orient yourself on that map and tell me when you've found the relevant points that help you understand what this map is of?
Yes.
Do you see the courtyard on that map?
Yes, I do.
Kimberly, can you zoom in to the courtyard area, kind of the center of there's a pointer on the screen. Is that the courtyard?
Yes, that is.
All right, now the Low C Center, will you describe, well, let's jump to the wooded area. Where is the wooded area that you're talking about, seeing that was processed?
Yep, the wooded area, if you go from the courtyard and you go northeast, you're gonna come across this big parking lot. And then if you just go directly north to that.
Okay, this is, at this point, it might be easiest for you to actually indicate on the physical map. If you don't mind just standing up, give you a handheld mic here.
Yes, so the wooded area is approximately right here in this area.
Okay, so just to make a record of the area, on the northern, I guess I'll say, and north is up on this map, is that right?
Yes,
Do you know where Campus Drive is?
yes, Campus Drive is this road that winds right along here.
Okay, and so that's kind of the windy road that begins the upper left-hand corner of the exhibit and winds down through the center of the map and kind of exits to the middle right side of the map, is that right?
Yes.
And the wooded area, where is it in relation to the Campus Drive?
It is north of Campus Drive.
Okay, kind of in that, probably the center right of the map, is that right?
Yes, that's correct.
Will you describe, first off, what is on the south side across the street from the wooded area?
Yeah, so on the south side of the south side of the wooded area, we have the computer science building, which is to, I guess, east. And then we have a parking structure.
The computer science building, by the way, is where the 223 live round was found on the roof.
Center building, and then right onto the southwest of the parking lot area is going to be the Veloci Center building.
Okay, now you referred to the area across the street from the wooded area as a parking structure. That's a parking lot, right?
I'm sorry.
And there is a parking structure on campus, correct?
Yes, there is.
But that's different than the parking lot you just mentioned.
Yes.
Okay. All right. Back to the wooded area. What was found? Was anything found in the wooded area of evidentiary value? You can sit down. Thank you. You can take that.
May you repeat your question?
Was anything of evidentiary value found in the wooded area?
Yes, in the wooded area, a rifle that was wrapped in a dark colored towel was found there.
And how did you learn about that?
I found that out because just a little bit before 6 p.m. that day, I received a call from Utah County Sheriff's Office, who was tasked with searching that area.
Do you know why they searched that area in the first place?
Yeah, so they searched that area because I received a video that was from the UVU security footage. This was received by our command post on scene, and it showed who we believe was the shooter on the rooftop run from the southwest corner all the way to the northeast corner, jump down, and then continue to the northeast side of that campus and then cross the street to Campus Drive, and then the suspect was out of camera's view after that.
Okay, so he ran basically toward and into that wooded area.
Yes.
All right. What were you told from the sheriff's office?
I was told that they found a gun, and from there I asked them to hold the scene, and that myself and FBI ERT team, the lead, Special Agent Kamak, would be en route.
Okay. FBI ERT, FBI Evidence Response Team, right?
Yes.
All right. Did you go to that area?
Yes, I did.
Did you observe the weapon?
Yes.
Will you describe what you saw?
Yeah, what I saw was a rifle that was, or at the time before even having removed it, we found, or in the bushes, we found all you could really see was just a dark towel there. So pictures were taken of that, and then eventually the gun or the towel was removed. And then once we removed the towel from the bushes is when we uncovered that the towel was actually used to wrap the gun in.
Have you reviewed State's Exhibits 10, 10.1, 10.2, and 10.3? Do you remember reviewing these?
Yes.
And are they accurate photographs of the weapon when it was recovered and shortly thereafter?
Yes.
I move the admission of State's Exhibits 10, 10.1, 10.2, and 10.3.
Defense?
No additional objections.
All right, and as it relates to publication, if any?
Yes, I would ask that these be published at all 3 levels.
All right, any input, Mr. Burt? All right, I'll note the standing objections from defense. Those are overruled. And 10.10, 10.1, 10.2, 10.3 are admitted into evidence and may be published both in the courtroom and through the use of the camera.
If we can please publish number 10, thank you. You have in front of you on the screen Plaintiff's Exhibit 10. Will you describe what we're looking at here?
Yes, what we are looking at here is actually the bushes where the dark colored towel and the gun were found. You can kind of see the dark colored towel towards the right-hand side of the screen in the middle, right middle.
Kimberly, can you zoom into that area, please? All right, is this a better view of the towel?
Yes, it is.
If we can go to Exhibit 10.1. Will you describe what we're looking at in Exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel that was used, or of the towel and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak removed it from the bushes. We then placed it on a cardboard box, took pictures of it, and then we removed the towel, packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is the dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
You described making the rifle safe. Will you describe what that is?
Yeah, so what that is that we ensure that there isn't anything in the chamber and that there's no other cartridges in the gun that would have it go off. So to do that, because it is a bolt action gun, we would have to manipulate the bolt or the lever back, and then from there see if anything was in the chamber, and then I'll say carefully
Okay, this
remove
is
anything that
important
was in the
because this
chamber
is the
and blow it.
actual gun. Remember, I was
what
talking
is
about how the
difference between
safety on the
a
gun.
bolt action and an
If
auto
it's a
ejecting,
military original
gun.
safety,
Yep. A bolt
it would
action is
not
one
be
where
able
the
to
user
fire
actually has to
because the
manipulate the
scope would
bolt.
get in the
So
way.
they would actually have to turn, or they would actually
We'll have to blow
pull it
that
back,
picture up and look and see exactly what
forward
safety they
to,
had on
whether
it
it be to
during the next
load
break.
it, lock it, as well as extract anything
For sure.
that's in it. Unlike a semi-auto gun, that is one, every single time you pull the trigger, a bullet will be fired, and then from there, a casing will be extracted out, as well as a new cartridge will then be automatically fed into the chamber.
So if you shoot a bolt action rifle, does that spent shell casing automatically exit the gun?
No, it does not. It will stay in there until the person that is handling the gun actually removes the bolt, or actually pulls the bolt back, and then the casing will be extracted out.
Were you present when this weapon was made safe?
Yes, I was.
Will you describe what was found when that happened?
Yeah, so when we rendered the gun safe, we found in it, when we removed the bolt back, we found one 30-06 cartridge case, or say a fired cartridge case, and we also found 3 unfired cartridges, all with engravings on them.
Okay, I want to make sure we understand the language you're using. When you say cartridge case and you say cartridge, what do you mean?
Yeah, so a cartridge is basically the round itself, right? The whole round. And the round consists of the cartridge case, and then the powder, and then the bullet on top. So the cartridge case, the term is used for something that has been fired already. A cartridge is an unfired round.
Okay, cartridge is the unfired round that still has the bullet, the powder, and all that.
Yes.
Cartridge case is the fired is a round that has been fired and it's just the empty brass casing, is that right?
Yes.
Okay. Was there any, so there was, I just want to make sure I understand, a fired cartridge case and 3 unfired cartridges.
Yes.
Was there anything distinctive about these items?
All 4 of them had engravings on them.
Did you observe those engravings?
Yes, I did.
Did you observe them right there on scene?
Yes, I did.
And what was done with, let's talk about each of those things. First, the towel. What was done with the towel?
The towel was packaged and then it was eventually provided to the FBI.
What was done with the firearm?
The firearm was also packaged and then provided to the FBI as well.
Did the firearm go to the FBI or the ATF?
Oh, sorry, correction. It went to the FBI and then to be in their custody, and then it was then sent to the ATF lab.
Okay. And the rounds, the cartridge and cartridge cases. The cartridge case.
Yes. All those were packaged, originally provided to the FBI, then was sent to the ATF lab.
Right. And were each of those items tested?
Yes, they were.
And in the testing, were they photographed?
Yes.
Have you reviewed the photo, and were they photographed by the ATF when they were tested?
Yes, they were.
Have you reviewed their photographs?
Yes.
And were you previously shown States Exhibits 19, 20, 21, and 22?
Yes.
And are those photographs that the ATF, or that you received back from the ATF, of those cartridges and the cartridge case?
Yes.
Did they have the same appearance and etchings that you saw when you observed them removed from the gun?
Yes.
And did those photographs accurately capture those etchings?
Yes.
I move to admit States Exhibits 19 through 22.
Mr. Byrd. All right, I'll note the standing objections. Those objections overruled, and 19, 20, 21, and 22 are admitted. And as to publication, Mr. McBride.
I would move to publish these exhibits at all 3 levels.
All right, any further objection from? Thank you. Again, I note the standing objections as are overruled. They may be published both in the courtroom and captured by the media camera.
Let us start with Exhibit 19, please. What are we looking at here in Exhibit 19?
This is the cartridge case that was recovered from the gun.
And what position was this in the gun?
This was this is what was in the chamber.
Okay. In the chamber, meaning that's where a cartridge is before or when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notices bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's?
And to page 3?
This.
And question mark, correct?
Yes, question mark.
All right, if we go to States Exhibit 20. Is this a photograph of one of the cartridges that was found in the gun?
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit 20?
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber than a .223 round?
Yes, it is.
Will you look at page 2 of Exhibit 20? Will you read the markings here?
A fascist.
And page 3?
Catch.
And page 4?
Up arrow, right arrow, down arrow, down arrow, down arrow.
All right, let's go to Exhibit 21. And was this another round that was found in the gun?
Yes.
Will you read the inscription here?
Oh, Bella Chow,
Page 2.
Chow Chow.
All right, let's go to Exhibit 22. Another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read,
Page 2.
this comma your, or correction, this comma you are
Page 3
gay.
and page 4.
LMAO.
All right, after processing the scenes there at Utah Valley University in Orem, did you go to St. George?
Yes, I did.
And what was your role in St. George?
My role was overseeing the execution of the search warrants at both Mr. Robinson's residence as well as his parents' residence.
And we've had testimony that Mr. Robinson was arrested there. Was he fingerprinted and his DNA taken?
They were actually taken at the Utah County Sheriff's Office jail.
After he was transported to
Yes.
Utah County? Okay, you said that there was, were items of evidence collected from him after he was arrested?
Yes, there was.
From his person. What were those things?
They were his clothing that he was wearing at the time of his arrest, to include shirts, pants, underwear, as well as shoes and anything that were in his pockets.
Do you remember what tops he had on?
I believe it was a maroon top.
And was there any other top layer that was collected that you recall?
I don't recall.
Okay. Let's go to, you said there were a couple of homes that were searched there, is that right?
Yes.
Whose homes was that?
One of them was where Mr. Robinson and Mr. Twiggs resided, and the other was Robinson's parents' residence.
I want to ask you about the defendant's home. What items will you describe some of the items that were collected from that home?
Yep. Some items collected in that home were a Dremel tool and its bits container, as well as two Remington boxes of 30-06 ammunition, as well as some 30-06 cartridge cases, and a handful of long guns or rifles, a revolver, as well as a burned paper.
All right, I want to ask you about clothing as well. Was any clothing collected from the townhome?
Yes, there was.
How about shoes?
Yes.
What kind of shoes?
Two shoes were collected from the home. One was a Converse shoes, gray in color with white laces, I believe a size 10.5. And then another Converse shoes that were also gray, but had gray laces instead, but were of a different size that I can't remember.
I think you said that you collected boxes of ammunition. Do you remember what caliber that ammunition was?
Yes, there are a handful, but the one that I recall was 30-06.
And you also said you found some cartridge cases. Do you remember what caliber those cartridge cases were?
Yes, those were also 30-06.
If we can display just to the witness Exhibit 23. Do you recognize Plaintiff's Exhibit 23?
Yes, I do.
And is that an accurate photograph of the cartridge casings and some of the bullets that you found?
Yes.
I would move the admission of Plaintiff's Exhibit 23.
Mr. Burke?
No further objections, Your Honor.
I'll note the standing objections by defense. overrule those objections and admit into evidence State's Exhibit 23 as to publication. Mr. McBride.
I would move to publish at all 3 levels.
All right. It is published to the courtroom as well as maybe broadcast via the camera.
As that's coming up, where did you find these?
I found these in what we would consider the spare bedroom, right next to Tyler's bedroom, on top of a safe.
How do you know which bedroom was Tyler's bedroom?
We determined that based off of some documents we found in what we believe was Tyler's bedroom, such as mail that was addressed to him, as well as some school documents as well.
And again, in relation to, will you describe the layout of the house in that area?
Yep, so this was on the second floor. As you're coming up the stairs, if you turn the left up the stairs, you're gonna run into 2 bedrooms, and that is on the south end of that residence. The southeast bedroom would be Tyler's, and then the southwest would be the spare bedroom. Again, if you go back to the stairs and you make a right-hand turn, that is where you're now on the north end of that residence, and that is now Twig's bedroom.
And where were these items here in 23 found?
These were found on the southwest, or in the southwest bedroom, the one right next to Tyler's bedroom.
And you said on top of the safe?
Yes.
Okay. All right. Will you describe what we're looking at in Exhibit 23?
Exhibit 23 are the 5 cartridge casings we found on top of the safe, all with .30-06 Springfield caliber, and one of them had an engraving that said "test shot" on it.
That's weird.
You've talked about Springfield, Remington. Are these these 30-06s? Are they the same type of round as was found in the gun?
Yes.
All right. Did you find any 30-06 weapons in that house?
No, we did not.
All right. Did you search the closet on the first floor?
Yes, I did.
What did you find in the closet?
In the closet, we found on the ground some shooting targets with perforations in it, as well as on the shelf, we found a Dremel tool with bits container.
All right, a Dremel tool with bits. What is a Dremel tool?
It's basically like a handheld device where you can make etchings or engravings on things.
What are bits?
Bits would be I guess like a sharp edge or something that that would actually cause the etchings that you would put into the tool.
Is this kind of like a drill bit?
Yes.
And what did you do with the Dremel and the bits?
We photographed them in place, took additional pictures, packaged them, then sent them for testing to the ATF.
All right, you also mentioned targets. Were those targets photographed?
Yes, they were.
I want to show you on your end. Have you reviewed Plaintiff's Exhibit 25 before?
Yes.
And is that an accurate photograph of those targets that you found?
Yes.
I move the admission of State's Exhibit 25.
Mr. Burt?
No further objections?
All right, I note the standing objection, and those objections are overruled.
And
Stacey,
excuse me, sorry.
oh, well, did you want to, in regards to publication?
Yes, I'm so used to admission before publishing. I would move to publish those at all 3 levels.
Any further comment, Mr. Burt?
No further objections.
Again, all right, noting the standing objections, those are overruled. State's Exhibit 25 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Will you describe what we're looking at here?
Yes, so these were shooting targets we found in the closet, and each of them have have perforations in them.
You say perforations, what do you mean?
Holes in them.
Those holes consistent with?
Objection, foundation on this opinion.
Mr. McBride, do you want to weigh in upon that objection?
No, I'll submit it. I'll lay the
Again,
foundation
it's
if,
important
the
to
objection's
to
sustained.
point out
I'll
that
sustain the
Twiggs
objection.
and Tyler
All right,
Robinson both live
holes,
together.
Have you ever seen, have you ever shot a
And
gun
by the
before?
way, Tyler
Yes, I have.
Robinson's family said
When you
he's
hit a
not a
target,
gun
what
guy.
happens to the
He
target
doesn't
when
shoot
it's
guns.
hit
He's
with
not.
a bullet?
A hit with a bullet.
Yeah, he's not a gun
there's
guy.
holes in there, what we call
So, and
perforations,
Lance
'cause
Twiggs
there's
was a gun guy.
entrance
So
as
if
well
there's
as
any
exit.
kind of shots,
Looking at
And
State's Exhibit
testified,
25, I'm going to ask the question.
most likely it was Lance
You
Twiggs
said there's perforations in
who was
those
engraving these
consistent with
rounds. Lance Twiggs who was firing these test shots.
And I would ask you to describe where those perforations.
If you're
are
profiling and brought in an FBI
on
profiler,
there's 3 targets here, right?
who do you think you're gonna
Let's look
fits
at
this
the-
crime more? I mean, this is stupid.
Let's look at the far right target first.
Exactly. Anybody with
Where are
common
the
sense can
perforations
see that
in
Lance
relation
Twiggs is the
to the
one that
bullseye?
it fits better than Tyler.
They're all probably within the.
I think we should have an
7,
FBI
6, and 8
profiler
range.
testify.
Is there a perforation up at the upper
I
left-hand
agree.
corner of that rightmost target?
Yes, there is.
Do any of those hit the bullseye?
No.
Okay, looking at the center target, will you describe where the perforations are in relation to the bullseye there?
It is closer, but still not it. Most of them are to the left of the bullseye in rings, let's say 9 and 8.
All right, and then the leftmost target, will you describe where the perforations are there?
Yeah. The perforations are actually closer to the bullseye as well. Actually, one being in it.
All right, you described also collecting a burnt note. We can take down 25. Thank you. Will you describe where that note was found and what it looked like to you?
Yeah. The burnt note was found in the trash can located in the kitchen. The way it looked like to me, it looked like
exactly, it was
say,
burned.
a
Like I said, it
campfire
was
and someone burns
burned.
paper.
What was done with that?
That was also collected and that was sent to the FBI for analysis.
Was it photographed?
Yes, it was.
And have you reviewed State's Exhibit 24?
Yes.
Is that a photograph of the note?
Yes.
I move the admission of Plaintiff's Exhibit 24.
Mr. Burt?
No further objections.
All right, and to publication?
I move to publish at all 3 levels.
All right, I'm going to note the standing objection by defense, overrule those objections. And State's Exhibit 24 is admitted into evidence and may be published in the courtroom and may be captured by the media camera.
Do you see here on the screen Plaintiff's Exhibit 24?
Yes, I do.
It looks like as to the evidence tag, it's actually upside down. Is that right?
Yes.
Is there any, does it look like there's any writings on that note, on that burnt paper?
Yes.
Will you point that out for the judge where the writing is?
Yep.
And describe what you're pointing at, kind of the general location on the image?
Yeah. So the part that I'm pointing out is the paper that you can still see the lines in them, and as well as some handwriting.
There's
as
no
well to
way
the
they could try to
left
tell me
edge
that
of
that for
piece of
sure
paper.
is Tyler Robinson wrote that by reading the burns. We were able to
Have you
reconstruct the
also
burnt
observed
pieces, and that's
the-
how we know it's definitively Tyler Robinson.
The image of a note that was recovered from Lance Twiggs' phone?
Yes.
That looks like a note that I burned,
I'd like
like
to show you
my homework that I
side by
burned
side,
to show
Exhibit
the teacher.
24.
Yeah, exactly.
And there on the left, you see exhibit, well, that's good. There on the left, we see exhibit 24. Do you see that?
Yeah, I know, right?
Yes,
We
I
have
do.
no way to know
On
whether
the
it's
right,
authentic
you
or not.
see- Excuse me, on the right is 24, on the left
How
is 16.
convenient.
Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?
Let's take that down.
All right.
Exhibit 24, thank you, Your Honor. Excuse me, exhibit 16.3. I would move to publish exhibit 16.3 and 24 side by side. I think they're currently on the council monitors.
So 16.3 has already been admitted.
And I don't remember the court's order if this was to be captured by electronic media or not.
No, it was not.
Okay.
Is that does that comport with defense's memory as well?
It does.
All right. So 16.3 was published to the courtroom, but not to be captured by the media. So as it's, and what is your request?
To comply with court's order.
All right, so 16.3 and Exhibit 24 may be published side by side only to the courtroom itself and not on to be captured by the camera.
Again, with hiding stuff from the public.
That's all they got.
It's ridiculous.
His face.
But yeah,
man.
if they think, if they really think they're going to try to, you know, with that note, if they're going to try to say that, oh, well, we were able to reconstruct the note and prove that it's Tyler Robinson, I call total bullshit on that. You know, that thing was completely burnt, and you know, there's no way. There's no way. And someone in the chat, like I said, they point out a good point too, is there's no way to authenticate. Supposedly Lance Twiggs took a picture of the message before he burnt it. There's no way to authenticate whether it's really the note or not, or whether it's made up or anything, you know?
No, none of this is solid. They're intentionally they're intentionally using bad evidence and then redacting the good stuff. They're wasting their time. This could not hold up in court.
No, not at all. And honestly, I'm really afraid. I mean, because they can see the writing on the wall. They can see that Tyler Robinson, they don't have any evidence to really point to Tyler Robinson doing this. They have nothing. And I think they see the writing on the wall and they're getting scared and they're getting antsy. And I really am afraid that they're going to try to kill Tyler Robinson before he goes to trial, and maybe even kill Lance Twiggs to make sure he can't, you know, further talk.
His parents need to hire a security guard or something to watch him 24 hours.
In on this evidence, solely admitting it.
You talking about Twiggs or Robinson?
Well, it's already been admitted, but as it relates to the testimony.
Yeah, well, he's in jail, unfortunately, so he's kind of screwed, you know?
Objection and allow the testimony to be given.
They can have somebody, you know, stab him or you know, or kill him in jail and say that he Epsteined himself, you know, try to say he committed suicide.
Probable cause.
Thank you. Do you see any consistencies that you're able to?
What the hell? Why'd they mute it again? Well, this would be a good time to point out again, if you like the stream, you'll want to support us, you can scan the QR code at the bottom of the screen on the right-hand side. That's the Buy Me a Coffee link. Or it's a couple bucks into the Buy Me a Coffee link to support us. Remember, we're out here doing these 10-hour streams, and I'm not monetized on YouTube, so every little bit helps. If you're on your phone, you know, so you can't scan the QR code because you're on your phone, the link is pinned in the top of the YouTube chat. And it's also, I've dropped it a couple times in the X chat.
Did you
so
also
you can
collect?
Find it in there as well if you want. And we'll read out your comments. If you donate, we'll read out your comments live on the
That was
break,
collected
like a
at the
super
Robinson's
chat.
parents' home.
And will you describe that vehicle?
Yep, that vehicle is a gray colored Dodge Challenger.
All right. You've mentioned that you sent several items.
Exactly, just like they did with
DHS and
Epstein.
the FBI for testing. And did you receive reports back from both of those entities with results of their testing?
Yes, I did.
I'd like to show you on the witnesses screen only right now, or council's screens, Exhibit 30.
All right, while
Black
you're doing that,
boxes
Mr.
in the
McBride,
chat.
and also, could we go ahead
I
and
have
take
no idea what
State's
you're
Exhibit
what you're talking
35?
about.
I know it's just in the background, but just to
You talking about in the X chat?
consistent on displaying of exhibits. All right, thank you.
Yeah, the Gray Dodge
You may
Challenger is who they're saying is Tyler Robinson's car, but we were able to find that there were actually 3 passengers and a bald guy driving it.
Do you know what this is?
Yes, this is the ATF report that I received regarding the DNA testing.
Blake Neff
on
driving the
gun
3
and
patsies.
cartridge casings. Or sorry.
Honestly,
correction,
basically,
cartridge case and
Blake Neff's
cartridges.
bald, you know?
Thank you. And is this in the same condition as it was when you received it?
Yes.
Your Honor, I'd move the admission of Exhibit 30.
This is a circus, absolutely.
Mr.
No further objection, Your Honor.
All right, I note the standing objections, and as to publication, Mr. McBride.
Yes, Your Honor. This exhibit deals with DNA testing on the rifle and the cartridges. We would move to have it published at all 3 levels.
All right, so noting the standing objection by defense, I'm going to overrule that objection pursuant to Utah Rule of Evidence 1102. State's exhibits, and this is 30?
30.
State's Exhibit 30 is admitted into evidence and may be published on screen in the courtroom and for the media camera.
I want to ask you a little bit about the format because it may be helpful to understand here. But on page 1 under the exhibits, we have here a list of items that were sent in for testing and comparison. Is that right?
Yes.
And throughout the report refers to the items compared by the lab number. Is that right?
Yes.
So if we can scroll down just to the bottom of this first page, and here in the DNA analysis section, again, we see that the report or the author refers to the items by their exhibits numbers, right?
Yes.
Okay. And if we can go to page 2. And same question here, the exhibit number on the left, if we want to know what exhibit number that is, we have to refer back to page 1 for the description, right?
Yes.
Okay. And let's keep going to page 3. If we can just scroll through page 3, 4, and land on page 5. Actually, pause right there if you will. This is page 4. There's a description section here as well. And that description talks about where the swabbing that's used to compare what was swabbed for the comparison. Is that right?
Yes.
Okay, let's go to page 5. So as we look at this first paragraph here under statistical analysis, let's see if you have this notated or no. Exhibits 1.1 and 1.4. Do you know what that is referring to?
Yep, they're referring to 1.1 is swabs of the stock and grips of the rifle, and then 1.4 is swabs of the bolt of the rifle with possible ridge detail and or smudging.
Okay. Will you read paragraph D?
Yes. The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson, Exhibit 7.1, as a contributor to the major components and 3 unrelated unknown individuals than if they originated from 4 unrelated unknown individuals.
And again, that's swabs of the grips and the bolt. Stock and grips and bolt, is that right?
Unrelated, unknown individuals.
Number
Who are
2,
these 3
calculation
or
number
4
2.
unrelated,
Where is this
unknown
swab taken
individuals? That's what I would like to
Exhibit
know. Why are they
1.2 would be
unrelated and
swabs of the
unknown?
butt plate of the rifle.
Who would they
And will
be?
you read paragraph D here?
The DNA profile is at least 1 trillion times
just
more
now
likely
hearing
if it
about it.
originated from Tyler Robinson as a major component and 4 unrelated unknown individuals than if it originated from 5 unrelated unknown individuals.
Looking at calculation number 3, exhibit 1.3, what areas were swabbed for this comparison?
1.3 is swabs of the trigger and trigger guard of the rifle with possible ridge detail and or smudging.
We read paragraph D.
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
If we can go to page 6. Calculation number 4, exhibits 1.5 and 5.1. What are those?
1.5 are swabs of the fore end of the rifle, and 5.1 is swabs of one 30-06 cartridge
And again, that cartridge came from where?
from the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
All right, let's look at calculation number 5.
Like I said, they should not have included Tyler Robinson
1.6 is
as a
swabs
possible
of the
contributor.
barrel of the rifle with possible ridge detail and or smudging, and 3.1 is swabs of one 30-06 cartridge
And that 30-06 cartridge came from where?
from the firearm.
We read paragraph D.
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as a contributor to the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
Okay, statistical analysis calculation number 6, exhibit 1.9, where is that from?
1.9 is the swabs of possible ridge detail and or smudging on the optical accessory of the rifle.
Is that a scope?
Yes.
Will you read paragraph D?
The DNA profile is 6.28 billion times more likely if it originated from Tyler Robinson as a contributor to the major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
Okay. On number 7, I'm not going to read that. I think we've gone through this enough. That's the last one in this report. Is that correct?
Yes.
All right. We can go to exhibit 32. 31 was previously received. And just display this on the screen of the witness, please. I think it might display on the gallery video. Okay. All right, thank you. Can you see exhibit 32 on your screen, Agent Feldman?
Yes.
What is this?
This is an ATF report that I received in relation to the gun as well as cartridge case and cartridges.
And is this report in the same condition as it was when you received it?
Yes.
I move the admission of State's Exhibit 32.
So question for you, was this the report that was previously disclosed in one of the early motions?
Yes.
All right. All right. To Mr. Burtz.
No further objections, Your Honor.
All right. And for publication level?
All 3 levels.
All right. As it relates to State's Exhibit 32, is accepted into evidence, may be published in the gallery as well as electronic. The media camera can capture it. And I note that this has been previously disclosed publicly from an earlier filing, I believe from either late last year or early this year. So for those reasons, it's accepted into evidence and may be published at all levels.
Your Honor, it's 2:30. I probably have 10 more minutes. Would you like to take a recess now or? after I finish.
Let's just do the 10 minutes.
All right, Exhibit 32 is in front of you. And what was being analyzed in this test?
What was being analyzed would have been the cartridge case as well as the bullet fragment and the lead fragments that were recovered from Mr. Kirk at autopsy.
Right. Same question on structure of the exhibit. The lab numbers and agency numbers are listed here on the first page, right?
Yes.
And if you want to know what the report is talking about, you have to refer back to there, right?
Yes.
All right. I want to have you read, if you can scroll down to the bottom of page 1. Thank you. I would ask you to read the second line under results of examination.
Yes. The Exhibit 1 rifle was test fired and found to be in operable condition. The test fires were designated as Exhibit 1.11.
And again, Exhibit 1 rifle is what?
Is the one that we found on campus.
Okay. Exhibit 2, if you'll look at the next, skip the next line and then go to the Exhibit 2 cartridge case. Will you read that sentence?
Yes. The Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle.
Okay, now I want to jump back up to the top where it lists the exhibits. 2 through 5, will you explain what those are and where they came from?
Yes. That would be the items we found in the gun on scene. And this was the gun that was found in the wooded area.
And so the cartridge case is the round that had been, is the case that had been fired.
Yes.
Okay, so that's number 2. All right. I can't remember. Did we already read that line? Exhibit 2 cartridge case?
Yes.
Okay, thank you. Will you also look at or read the last paragraph on this page?
Yes. The Exhibit 2 cartridge case and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge case and Exhibit 3 cartridges, in parentheses, scribe marks, that are consistent with being produced by engravings and or rotary cutting tips commonly found.
Let's scroll down, please, Kimberly.
Installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison if a suspect tool is located.
Okay, I'd ask to scroll back up to show the exhibit list. Number 6, what is Exhibit 6?
Exhibit 6 is the bullet fragment, or sorry, the bullet jacket fragment, as well as some other fragments that were recovered from Mr. Kirk at the time of autopsy.
Thank you. Going back to page 2, will you read the first full paragraph there beginning with Exhibit 6?
Yes. Exhibit 6 consists of 1 30 caliber class deformed damaged bullet jacket fragment and 4 lead fragments.
Will you read the next paragraph as well?
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
And if you'll look at the line starting with the Exhibit 6B through 6E, will you read that sentence as well?
The Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison.
Thank you. We can take Exhibit 32 down. Exhibit 33, if we can show that just to the witness, please. You recognize Exhibit 33?
Yes.
What is that?
This is an ATF biology report on the Dremel tool as well as the cartridge cases that were found on top of the safe in Tyler's home.
Did you receive this from the ATF in response to your request for testing?
Yes, I did.
I move the admission of State's Exhibit 33.
No further objections, Your Honor.
Thank you, Mr. Burt. Noting the standing objections by defense and level of publication, Mr. McBride.
All three levels.
Court overrules the standing objections and State's Exhibit 33 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
What was being tested here?
The Dremel tool, the bits container, as well as the cartridges and cartridge casings we found in Tyler's home.
And up in the top right, it says forensic biology. Is this DNA testing?
Yes, it is.
Okay, format of this is the same as the other report that we already looked at, right?
Yes.
Let's jump to page 4. Calculation number 1. It mentions here Exhibit 15.1. Do you know where that swab is from?
Yep, it is swabs of the buttons of the Dremel tool.
And will you read paragraph D?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a contributor to the major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
We also read paragraph E.
The probability of an unrelated individual in the population who has not contributed DNA to this sample yielding this level of support is less than 1 in 1 trillion.
Thank you. I'm not going to ask you to read those paragraphs for the rest of the statistical calculations, but I will ask you to go through and identify where the swabbing came from. Exhibit 15.3, which is calculation number 2, where's that swab from?
As swabs of the cord of the Dremel tool.
Exhibit 15.5.
That would be swabs of the longest metal bit of the tool.
Going on to page 5. Calculation number 4, exhibit 15.6.
15.6 is swabs of the shortest metal bit.
And calculation number 5, 18.1.
This is swabs of 1 etched 30-06 cartridge case.
What is that? Where did that come from?
That come from on top of the safe.
Okay. Is that the one that had the etching test shot?
Yes.
Will you read the paragraph D as it relates to the test shot swab?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
Thank you. We can take exhibit 33 down. The final report is 34, if we can publish that just to the witness. What is State's Exhibit 34?
This is an ATF report I received that was comparing tool marks.
And is this, I move the admission of Plaintiff's Exhibit 34 and publication at all 3 levels.
Mr. Burt.
No further objections.
All right. And all right, so State's Exhibit 34 is admitted. The objections, the standing objections by defense are overruled. They may be published in the courtroom and captured by the media camera.
Okay, looking at the exhibits, might have to go back and forth here, but let's go to page 2. And will you read the paragraph that starts with Exhibit 18 consists?
Yes. Exhibit 18 consists of 5 30-06 Springfield caliber fired cartridge cases designated Exhibits 18A through 18E and 15 45 auto caliber unfired cartridges designated Exhibits 18F through 18T.
Okay. 18A, do you know what 18A is?
Yes, this would have been the 30-06 cartridge case with the engravings test shot on it.
Okay. Will you read the paragraph beginning with the Exhibit 18A?
The Exhibit 18A cartridge case was examined for the presence of comparable tool marks. Numerous sets of tool marks were located on the exterior of the Exhibit 18A cartridge case that are consistent with being produced by engravings and/or rotary cutting tips commonly found installed in handheld rotary tools such as a Dremel tool. These tool marks contain marks of value for comparison.
Okay. The next paragraph I asked you to read is the one that starts with Exhibit 16. But first I want to ask you, do you know what Exhibit 16 is?
I do not, off the top of my head.
Okay. 18, it also says Exhibit 18A through 18E. Do you know what those are?
18A through 18E would be the cartridge cases that were found on top of the safe.
If you'll read paragraph, or that paragraph.
Which one again? Sorry.
The one starting at Exhibit 16 and.
Yes, the Exhibit 16 and Exhibit 18A through 18E cartridge cases were identified as having been fired in the Exhibit 1 rifle.
Okay, let's now jump to the paragraph beginning the test tool marks. Kimberly, if you could scroll down. Will you please, well, first off, 15A and 15B, do you know what those are?
Yes, those would be the longest metal bit and then the shortest metal bit.
Okay, if you would read, okay, and then also Exhibits 2, the Exhibit 2 cartridge case, what is that?
This would have been the cartridge case that was found in the gun.
And Exhibits 3, 4, and 5 cartridges?
They were the ones also found in the gun.
And Exhibit 18A?
Is the one that was found on the safe.
Okay, if you'll read the first bullet point there, the Exhibit 15A.
Yes, the Exhibit 15A engraving cutter was identified as having made tool marks located on the Exhibit 2 cartridge case, Exhibit 3 through 5 cartridges, and Exhibit 18A cartridge case.
And will you, okay. We can go ahead and take that down. Your Honor, I want to, before I ask to enter my final line of questioning, I would like to show the witness Exhibit 12.1. And this is the video, the UVU surveillance video. Let's see, I think it's 12.4 was the surveillance video actually that was approved for publication.
That's correct. That's the unmarked, non-zoomed version, correct?
Is that correct? Yes.
Yes, that's the one that, yes.
And just for now, let's do this on the witness's screen. .4, and I'll ask you to jump to the 804 mark. Okay. I'd move to publish. We intend to play about 10 seconds of this video. I'd move to publish.
If you're watching this stream, please repost it, get
levels.
it out to more people. Do me a
Mr.
favor, help
Birch.
me out. Repost it. Thank you.
I'm not sure what the relevance is at this point, so it's hard to object or not. Would ask for a proffer as to what it's showing because
Prof.
it's not apparent from the exhibit.
Understood. Proffer is, there's been testimony about about prints being found on the glass window of this building. This exhibit demonstrates the suspect's behavior in that area.
All right. Anything further?
With that, I don't have any further objections.
All right. So
There was no
that-
suspect
that,
behavior in that area. He
it
never
may be
touched
published,
the
this was
glass.
already admitted, and it may be published.
They
at all
said they don't
levels.
have any DNA or prints that came up that they could tell, and we never saw him touch any glass. He jumped down and ran.
Okay, before you pause, before you hit play here, Sergeant Falmuina, do you see what's on the screen in front of you?
Yes, I do.
Can you see the suspect in this image?
Yes.
Will you describe where that suspect is?
He's on the rooftop, let's say on the gravel part, and this would have been close to the northeast side of that building.
Timestamp is 12:23:47 p.m. Is that right?
Yes.
And that portion of the image that we see there, the video, is the top portion of the image slightly to the left of center. Is that right?
Yes.
Okay, we're at 8:01. Kimberly, will you please hit play there? Let's go ahead and pause it. Pausing it at 8:20. Were you able to determine if the suspect touched the glass when he dropped from the roof?
Not at the time when we first saw the video, no.
Okay. Were you later able to make any determination on that?
Yes, because the video we had was pretty grainy at the time on at the command post, and it wasn't until we're actually able to get the footage directly from UVU.
And when you actually got that footage, could you zoom in and get a better picture?
Yes.
And were you able to determine at that time whether the suspect touched the window?
Yes.
What was your determination?
We determined that he was not, or he did not touch it.
No shit, I could have told you that. It was
Alright.
plain. It was plain as day.
Let's go to a break. To defense.
So that's what
I
all that
realize
means.
You began talking about your concerns. You
My
have
goodness,
witness that
these
needs
people
to
are
leave
retarded.
today. 10, 15 minutes. What's your request? I want to.
No wonder our country's in the state it's in. Look who's running
As
it.
well as cross if you choose to.
Just 10 minutes would be fine.
All right, let's break for 10 minutes and then come back and cross-examination. Court is in recess.
All right, so yet another break.
What do they need this break for?
I have no clue.
I think they just about
I think they're getting. I think they're getting ready to take
They
this
almost-
break to get ready for the second witness. The defense has a witness they want to bring up that has to leave today. They can't, like they're flying back from wherever they came from tonight. So today's the last day they can testify. So I think that's why they're breaking. That way they can make sure they get the witness, set the witness up to come in. Or whatnot,
Well, they about fried their brain on that last segment.
Yeah. Yeah, days like this are grueling, man. It's hard to follow. It's hard to, very boring because it's just, one thing after the other.
Well, believe it or not, we're
A lot
getting
of
more out of this one
arguing.
than yesterday.
Actually, I agree. At least we got new footage, new video, stuff coming out today. Yesterday was basically nothing but arguing. I mean, we're still getting a fair amount of arguing today, but at least we are actually getting some alleged evidence out, even though it's garbage evidence. At least it's some there, Ooh, where you
Yeah.
at? There you go. Denny the Mark, welcome. Good to see you. Thanks for joining us. That's another one that does good work. She's a good investigative journalist, researcher, or whatever.
Well,
Come on, cat. Why are you going to walk on my screen, damn it? I swear, these cats have no respect.
Has anybody been convinced or completely turned away from Candace yet?
I think he paused it too, didn't he? No, he didn't pause. Well, oh, he paused me. That's what he did. Oh my goodness, cat. Yeah, exactly. The video with Bigfoot, you know, that's what it looked like. And
Yeah.
that footage of showing somebody jumping off the roof, it looked like Bigfoot. To be honest with you, you couldn't make out who it was. There's no telling, you know. You couldn't even tell whether they were white or black or purple or brown or who they were, honestly. Absolutely no way to tell that it was Tyler Robinson for sure.
No. I doubt we've
Exactly,
lost
yep.
anybody yet.
Okay, 1 second. Let me mute that. Okay. I guess. Let's read what Candace has to say so far for today.
Yeah, she's been posting a lot.
Yep. Okay, so Andrew Colbert said, here are images of the text messages exchanged between Tyler Robinson and Lance Twiggs, which includes his alleged confession, which, like I said, it sounds to me more like it's written by a bunch of cops, you know, that just got together and used AI to write it, used ChatGPT, and then translated it, you know, from Israeli to English. Come on, cat, go. Man, these cats think they own the place, man. All right, so this says, man, I do need Jesus. Oh my God. If this is Lance Twiggs' phone, there's something wrong with this kid, man. Get a new phone, dude. Look at this phone.
Busted.
It looks like he's been like chewing on it or something. What is going on here? I swear, doesn't it look like he's been chewing on the corner of that phone?
It's definitely taken abuse.
My God, son, get a new phone. They're not expensive anymore. You can go down to Walmart and get just a smartphone. You know, you don't have to get like the Galaxy 800 or whatever it is. You can go to Walmart and just get, you know, a newer model smartphone, and it's only like $50, $60. My goodness, anything would be
Really?
better than this hunk of crap he's got here, for real, man. Oh my God. I mean, look, the screen's even messed up. It's got a green line all the way down it. You know, where the screen's not even reading all the way. That's crazy. Anyway, besides that, it says, 2 p.m. That still work for you? Yup. I love you. Love you too. I hope work's going well. I love you, Mama. I love you, Morsies. Mama. Drop what you. Oh my God! Can you imagine? Really now? Can you imagine Tyler and Lance talking like that to each other? Can you imagine anybody talking like that? Can you imagine any adults talking like that to each other? Period.
No. No.
even when I was in love and engaged, you know, you didn't hear me like talking like that to my fiance. No way. I mean, that's like, that's so cringe.
Yeah, even if they were in a gay relationship, that's pretty cringe. And you can use kiss emojis. The moi moi,
Yeah.
I haven't heard a couple talk like that, really.
No, honestly, it sounds like, you know, a bunch of transphobic cops, you know, they're like, hey, this is what gay people would sound like if they were in love with each other. You know, honestly, to me, that's what it sounds like.
So
they're
true.
like, oh yeah, these gay guys, they'd be like, mwah, 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 you know. I could totally picture like a transphobic cop, you know, like in their head, that's what they think's going on, and writing it out like that.
I'm gonna run these messages by my gay friends.
Yeah, for sure. This is wild. There's no way, man. But anyway, so it says, love you too. Hope work's going well. I love you. Mwah, mwah. I love you, morezies. And it's not even more, it's morezies. I love you, morezies. Mwah, mwah,
But did you notice?
mwah.
Did you notice how Lance regarded Tyler? Like, he didn't talk about him like someone he dated. It was just very matter of fact, like, that's my roommate.
Like,
yeah, he
dude,
existed.
Yeah, dude was my roommate. I didn't know him before then. You know, yeah, exactly.
It doesn't sound like lovers.
It doesn't sound like somebody madly. Exactly. It doesn't sound like someone madly in love with him. That's for sure. Anyway, so drop what you were doing. Look under my keyboard. What? Question mark, question mark, question mark. You're joking, right? Fuck, I tried to delete that. And then
no.
We go to,
if that was supposed to be a secret note, why would you, you know, validate it over text?
It makes no sense. It makes zero sense at all.
And you're right.
Anyway,
I mean, his
once
presentation just. I'll go ahead.
No, go ahead.
I was saying his demeanor just doesn't match that tone and language, but people will argue, well, maybe they were different behind closed doors. Maybe, you know, that's a private relationship. Maybe that's how they talk to each other.
Yeah, well, good luck convincing a jury of that.
Exactly. Gosh, the jury's
anyway
gonna have to be what saves us.
Yeah, I know. And then you got the let me make sure we're not back yet. No. Okay. And of course you still got the green line down it, so it's definitely, you know, that's the phone broken, the screen's messed up, and that's why you got that stupid green line down it. Because this is the second page and it's still there. Anyway. So it says, I am still okay, my love. And who says my love? You would just say, yeah, babe, I'm still okay. Or yeah, I'm all right.
Maybe
hey, hon.
His
babe.
grandma.
You wouldn't say, you wouldn't say my love. I am still okay, my love, but am stuck in Orem for a while longer yet. And who says yet? I am stuck in Orem for a little while longer yet. When you just say, yeah, man, I got caught up. I'm gonna be a little bit late, or I got stuck here. You wouldn't say, I'm stuck a little while longer yet. Shouldn't be long until I can. Exactly. Shouldn't be long until I can come home, but I gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance supposedly says, you weren't the one that did it, right? I'm sorry. Then Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude, then interrupted someone. Hold on. No, they grabbed some crazy old dude, then interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. The lingering is very weird, like you pointed out before.
Hey, someone's arguing. Someone's arguing with me on X, and he said there's been 3 confessions. Is he talking about the text?
No. There's a text message, which is alleged confession. There's a Discord message, which is alleged confession. And then they're trying to say that Tyler confessed to his parents and to the friend or whatever, which is complete bullshit. Tyler has not confessed to anybody. So that's the 3 confessions? Yeah, he's trying to say, if he's saying 3 confessions, he's probably trying to include, the fact that the media reported wrongly, by the way, that the media reported that Tyler confessed, to the family friend or whatever, confessed to his parents and the family friend, which is a lie.
So so it's the alleged text message, and then the family friend. Did they say he confessed to a family friend or his parents or both?
I think the family friend and the parents both. I think they were all both there at the same time.
Well, I mean, wouldn't they like stand up or reinforce that, or I don't know. This is so dumb.
They have privately told people at one of, like Billy, she was able to talk to them at one of the prior hearings, and they said it's all bullshit. Tyler didn't confess. But publicly, no, they have not spoken out publicly at all. They said they're afraid that the media, and they're right, the media will construe it the wrong way. Anything they say.
Manager of the whole operation, right?
That's a good way to put it, yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
Your agency, if I'm correct, wrote a massive report, 229 pages long.
Yes.
You've read that? You're familiar with it?
With most of them, yes.
Okay. And it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you performed in this case?
Yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does
There are
that sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes.
Discord is the third one, Kelby.
And there were various
Discord.
crime scenes.
You got text
that you
messages,
described on direct
Discord,
examination,
and supposedly the confession
One
to
of
the
them
family
was
friend
the,
/ parents.
Fulton Library.
Yes.
Gotcha.
Why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they were also trying to see, right, the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area. And so to them, they thought it was suspicious.
And were certain items seized And what were they?
Yes, you had a backpack, a jacket, as well as some gloves. And there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing?
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Well,
Was the
actually,
decision at
no.
some
They
time
could
made,
be
and you
referring
were
to the
requesting that
alleged
both
note
DNA and other type
that
of
they are just
analysis
talking
get done?
about, that the
Yes.
note that was burnt
At some
off or
point, did
whatever
you
that,
decide to pull the
Lance took a
plug on that?
picture of on his phone. They
At the
might
time
be
when it was
referring to
already
that note
sent,
as well.
we didn't have more information as far as whether or not the evidence that were collected there were probative.
But eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay. I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see, that you wrote was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents that NIBIN request for firearms.
Yes, so that was the request to conduct. What that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the ATF, and that is where we test or we input test fires or cartridge casings, the head stamps and whatnot, into a machine that is then run through the ATF to see if there's any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now going back for a minute to the crime scenes, you talked about the wooded area and you used the phrase, "we seized the towel." Who is we? Who are you referring to when you say we seized the towel?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead, Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say we seized the towel, what you really mean is she seized the towel and you observed her seize it.
Yes.
And when she sees a towel, can you describe a little bit more detail of how that process took place?
As far as when it was found or when she removed it?
Yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all we got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then I guess put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes. It
So-
wasn't over it. It was still wrapped around the gun.
Okay, but as I understood your testimony, the towel was seized by the FBI agent and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun was wrapped in the towel. So when Special Agent Kamak reached in, she grabbed not only the towel, but also the gun. And it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier. Once we documented that, and then the towel was removed from the gun.
You also mentioned as to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yep, I was involved in coordinating all that and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items? Or are we talking about something else?
Talking about something else.
And what is that something
So
else?
after the teams would have packaged all the items, sealed them properly, created an evidence log, they will then bring it back to the command post. And from there, we would compile everything. And then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof?
Correct.
And who were the people who were actually conducting that part of the crime scene processing?
That would have been our state crime lab, those two people are part of our state crime lab's crime scene response team.
When did you review the video of the suspect running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been the day on September 10th.
You saw that on September 10th.
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lists were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one report dated September 24th, documenting the forensic analysis as of September 24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was again about the crime scene progress of the forensic testing, right?
Yes.
Right. And then you have a report here which documents a firearm trace and a firearm seized at River Street.
Yes.
Nothing of value came of that, correct?
Correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, or it's not SBI, it's actually the state crime lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed.
Yes.
Right. You have a report documenting the transfer of evidence from the FBI to your department.
Yes.
And then the last one that I have that you personally wrote has to do with again, summarizing forensic reports.
Yes.
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some of this documents in that large report indicates that your agency has also, up to the present time, been monitoring Mr. Robinson's mail and communications at the jail. Correct?
Correct.
And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Thank you, Mr. Byrd. Redirect. All right, may this witness be excused? All right, Sergeant, thank you.
Thank you.
Turning to the state.
Your Honor, I just want to confirm with the clerk.
Yeah, let's make sure. Thank you, Mr. Gernander, creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm wrong. I have State's Exhibit 1, 2, 3, 3.1, 3.2, 4, 5, 5.16, 6.17, 7.18, 8.19, 10, 10.1, 10.2, 10.3, 11, 12.1, 12.2, 12.3, and I believe 12.4, 13, 14, 15, 16, 16.1, 16.2, 16.3, 16.4, 17 and 18 are blank, so no.
That is correct.
19 All right.
We're
19
not offering 17 and 18.
All right. 19, 20, 21, 22, 23, 24, 25. The following are blank, 26, 27, 28, 29.
That's accurate. We're not offering on those numbers.
I have 30, 31, 32, 33, 34, and 35, which have been admitted into evidence.
That is all that I have record of.
All right.
Can I
Does that comport?
Yes, can we also go over numbers?
I mean, we certainly can. Yes, would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right.
Can I have just a moment?
Yes.
Your Honor, the state rests its case in chief.
Thank you. Turning to defense. Approach the bench, please.
All right. So, well, the state has, that's all the evidence that the state is going to put forward at this time before trial. So we've got some new evidence that we didn't have before, which is good, but basically everything they've given us has actually done them more damage than it helped them. You know, it's actually
Agreed.
made Lance look more guilty and Tyler look less guilty.
Yeah, and I don't even think they were in cahoots. I think Lance acted alone and Tyler got thrown into the mix.
Yeah, I think that Tyler set him up to be a patsy. I honestly do. You know, I don't know. I mean, I think Tyler knew something was going to happen, or he knew he was involved. I don't know if he knew something was going to happen, but he knew he was definitely involved in something. Like he was in Provo that day because he did go to the Dairy Queen.
Just waiting for counsel to get situated.
But
all right, counsel, your request.
I don't think
Your
he
Honor,
knew
as
that
the
Charlie
court
was
knows,
going to
the family has
die.
asked that
I don't
all
think he knew the
exhibits admitted
plan.
into evidence be shown here in open court.
And I don't.
We're grateful to the court.
I don't think he was a willing participant
for allowing
sure.
the family to view many or most of the exhibits today.
No.
That were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that we asked the court that since the court's considering it, the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Gernander. To defense, Mr. Burt.
My apologies, that's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justices said in the Estes case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that. But at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her
I love
attorney.
he's calling her out.
She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of informing the world or Ms. Kirk or anybody else, that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Burt.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in the spot where we need to be. I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family has not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a complete
If she asked for access to it from the state would give her access
and this
to
is
it.
about educating anybody about anything.
The defense made
This
a
is about
good
allowing
point.
the family to see the evidence that's been gathered
she's the
after
victim.
a 10-month
They would
investigation
show her the victim.
in which
they would show
a
her the
father,
evidence if she
a
asked
husband
for it.
was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed, in order to
Quit trying
allow
to make her the
family to
victim. She's
process.
not really the victim. She was
Thank you.
very involved in his murder,
Anything
in my
further before
opinion.
the court issues its ruling and we go from there?
Not from the state.
All right, defense. All right. All right, so I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights, and as has been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember,
then get on with it.
The parties can remind me and we can revisit this tomorrow. So again, I'm
Exactly.
not saying yes.
I thought
I'm not
time
saying
was
no.
of
I'm
essence.
simply saying we need to get to this witness, and I'm happy
Yep.
to readdress this tomorrow. Okay? All right. Mr. Burt. All right. Samantha Carner is being requested. If you can go ahead and retrieve her. Bring her
Yes.
into the
Someone
courtroom.
is doing that.
Who is Samantha Carner? I would like to know who she is.
Somebody grabbing her.
Yes.
Okay. Thank you, Mr. Burt. I just couldn't tell and
What's she going to
wanted
testify
make
to? I
sure.
want.
Yeah, this will be interesting. That judge needs to take a Valium or something.
I know.
He acts nervous though, so
And Ms.
maybe that's
Carner,
a
if you
good
wouldn't
thing.
mind coming forward right by our bailiff to be sworn in.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carner.
And Ms. Carner, what do you do for a living?
I am a firearm and tool mark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the firearm and tool mark unit, so I receive items of evidence related to firearms, tools, tool marks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think.
All
approved
right,
for
let's go ahead and
publication.
put it on all screens because this was admitted and published previously.
So she's testifying to, I think, the
You
ATF
recognize,
report on the
plaintiff
bullet
exhibit number
analysis, I
32?
believe.
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges. And then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes.
Is this the ATS, is this a language referred to in your report?
It is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm toolmark discipline pattern examination.
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
All right, and what level of publication are you requesting, Mr. Burt?
Both public and admittance into evidence.
To the state?
No objection.
All right, Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that. Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm toolmark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm.
Mhm.
But that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says an examiner shall not assert that examinations conducted in the forensic firearms toolmark discipline are infallible. You're not asserting that?
I am not, no.
You're not asserting that, it says the examiner shall not assert that there is a zero error rate. You're not
Correct.
making that assertion,
No.
okay? Says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. you didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says, an examiner shall not cite the number of examinations conducted in the forensic firearm tool mark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided. You didn't do that, and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Carner 6? Case file. Yes. Do you see what's displayed there?
I do, yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence.
To the state.
Is this the 47-page document?
Yes.
I object. I don't see the relevance to the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burt?
Yes, Your Honor. This is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right. Anything further?
No.
Yes, just that without testimony about what the meaning of the notes is and so forth.
I
it is,
agree.
More confusing than it is.
Yeah, he made a really good
under a
point.
403 analysis, I don't think it's admissible nor helpful to the state, to the court.
All right. Mr. Burt?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and through the media.
Thank you. Ms. Carner, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the
7
evidence,
fragments, huh?
it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay.
She's talking about
Could you
fragments from the
display
neck.
Page 41 of 47.
Yeah,
That
she's
is
saying
it?
there's 4. There were 7 fragments that were collected, but only 4 of them made it to the lab. Somehow, 3 of them
I'm sorry,
disappeared
page 14.
out of evidence. That's what she's saying. That's what the defense is saying. Somewhere along the line, they lost 3 of the bullet fragments somewhere.
And tell us what's depicted here.
That's not
This
good.
is a picture of the as received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom 2 photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay. And after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is 2 pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics?
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on and looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
The range of the diameter for the 6A bullet jacket fragment was 0.286 to 0.301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width, correct?
The land impression width, yes.
And these are all general characteristics or class characteristics, right?
Correct.
Okay. Now, once you had that this, and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning.
6 right, yes.
Yeah. And that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle. So it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all inclusive. It is just used as an investigative tool.
Sure. Could you go to page 47, please?
You're telling me his neck
Could you tell us
did
what we're
that to
looking
the
at here?
bullet, that
This
damage?
is the results of that general rifling characteristic or the GRC search.
All right. And
Yeah, I
what
don't
did
think it
you
was
determine in
actually
terms of
fragments of the bullet. I
just
think
based
it
on the
was
class
fragments from the
characteristics,
microphone. I think they're
what
bullshit.
weapons could have fired the 6A bullet?
There were several different 30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or?
Correct.
And what is RB?
Bolt action.
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet.
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics.
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present. And they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have a certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes?
Yes, please.
My subclass assessment that's on page 13 of my report states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The striae observed are not coarse. I think I understand that. And vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths? Yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and tool mark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic. Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further
Okay,
characterize
so
what that
dust in the
was?
barrel means it was
Debris,
not fired anytime
I think
recently.
it says dust, so I would say dust.
dust.
That
What can
that
cause
proves
dust
that
to
it
get
wasn't
inside the
fired.
barrel?
A plethora of things. I'm not.
They knew that
sure
by the
why something is
canines.
ever
The
in the barrel.
canines couldn't detect it.
Exactly.
So you determined here, you ruled out subclass characteristics, correct?
Yes.
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
Yes,
And what did you conclude in that regard?
that there were microscopic marks of value worthy of comparison, or yes, individual characteristics in the landing groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if a item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are at times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on 2 separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired. And when you start comparing them, you will see differences between each bullet.
There's a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
Again, if you
That
like
is the
what we
theory
do and want to
stating how
support
an
this
examiner is
stream,
able to come to a conclusion
you
when
can throw us a
examining 2
couple
or
bucks
more
in
sets
our
of tool marks. And yes, that is how
Buy Me a
I go
Coffee
through my
fund
examination
by
and
scanning
how
the
I come up
QR
with my
code down the
conclusion.
bottom right-hand
Okay.
side of the screen there.
What is
Or it's
AFTE?
pinned in the top of
AFTE
the
is the
chat to the
Association of
YouTube.
Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary
Also,
goal,
like the
primary
stream
goal
and
is to
share it
further
out, please.
research
Help us out,
and
get it out to
continue
more
to show
people.
information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
peer review published journal. Can I join AFTI?
You can, most of the firearms community, or excuse me, members are firearm and tool mark examiners. There are also technical advisors and associate members. Those members are not usually firearm and tool mark examiners, but they still have a livelihood in firearm and tool mark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
You just have to pay the fee. Okay. Could you display to the witness exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTI theory of identification, yes.
Right, I move that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
to the state?
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right, sure. Let's go ahead and do so, Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
It sounds like she came unprepared, is what that sounds like.
Yeah, exactly.
Does
If
this
she wrote
document
it, she should be able to
accurately state what the
testify to
theory
it.
is?
May I take a moment to read
Yeah,
through it?
sure.
Oh, thank you so much. We appreciate your support. Thank you.
I believe something, I think the first statement is different than what I can recall, but overall it is what the AFTI theory states.
Okay. And your ATF protocol refers specifically to the AFTI theory of identification, does it not?
It does, yes.
Okay.
Yeah, like I said,
So,
dust in the barrel,
is there
that
any
shows the
difference
gun was
between
not
what's in
fired.
27
So that's
and what's
not
in
the
your
murder weapon.
manual?
Again, I don't remember
Nope, we
without
can
looking
rule
at them
that
side
out.
by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions. Page 1 of 3. I don't have a Bates on it. Toward the end. It's document FT 10. No, that's not it. Could I put you with insurance?
You may.
Page 1 of 3 of your protocol. I think it was.
I recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFT theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
Mr. Burke.
Goes to weight, not admissibility. He'd be free to question her about any differences, but I think she's laid a foundation that the theory is the same. So,
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you. I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Carner 27
yes.
is admitted and may be
Thank you.
published.
Looking at the language of this, the second part of it, according to AFT, says, currently the interpretation of individualization identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is a subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't. May I be heard?
If you're objecting, I will hear the objection.
It's just speaking objection.
What the hell just happened? Where'd our live feed go?
I don't know. What are they doing?
Live stream offline. I don't know, they just killed the live stream. Let me see if I can find it somewhere else.
same questions were asked. We had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay.
I don't know what happened to the KSL's
this
version of the live stream that we've been watching
this,
for the last couple days.
Examiner authored.
It just
trying to-
died there. It got cut out.
On what the limitations
Luckily, I was able to find
opinions
another
expressed
outlet
in the
that
report
was
that
in
the
there
state
as broadcasting as well for us, though.
relevant to the reliability.
Yeah, that was quick.
That was
the
weird.
Opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Well, in regards to whether objections have been waived or not, the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it to the probable cause. I'm not
What a
trying
dig.
to your theories or such, but I need to hold to probable
He's
cause.
been so harsh on the
a quarter of
defense
a
this
mile.
whole
This is my last
trial.
question. I'm going to move to another.
He's basically ruled in favor of the prosecution on everything.
I don't remember it verbatim, but it does sound
Been
accurate.
adversarial towards the defense this whole time, with the exception of blocking everything from the courtroom. He's also, that's the only thing he's ruled in favor of them, is with blocking the public from seeing stuff.
Yep.
Can I approach again?
You may.
But any one of their objections of actual merit that matter in the case, the judges ruled against them every single time.
I see where you were reading from, yes.
Do you see?
Yes,
Did I accurately read it?
I believe so, yes.
The judge does need to be removed. He's corrupt. He's biased. He's proved he's biased.
Now let's return to the report, the People's or State 32. And if you would go to the second page, please. You concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The result of the comparison was inconclusive.
Yes.
That was your ultimate conclusion, right?
Yes.
And on the next page, if you would go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you, because I'm unclear on what inconclusive mean. You say reasons for an
No, as far as I
inconclusive
know, this guy is going to be the
include
trial
the
judge.
presence of microscopic similarity that is insufficient to form the conclusion.
And he is
source
part of the, yeah,
identification.
as Denny the Mark said, he is
A
part of
lack
the
any
Mormon
observed
community.
Microscopic similarity
100%.
or microscopic
And he
similarity.
was just, yeah, he
that
was
is
just the point of this is
insufficient
the
to
very
form the
first
conclusion of
high
source
profile case he's ever been
Could
on.
you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There's a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times
So
that
she
I saw
refuses
agreement
to
in
answer the
striations
question.
in the landing group impressions, also seeing disagreement.
Sounds like
There
it.
was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I have met before today, correct?
Yes.
Where we
Oh,
talked about
absolutely. 100%.
that term inconclusive meant, correct?
Yes.
And I think, and correct me if I'm wrong, but did I read to you from
Well, welcome to the club. Welcome to the show. We'll be here all week. Hope you come back tomorrow.
do you recall me asking
Yeah.
you whether you agreed with this statement that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay, so I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is the 47-page document. There we go. What's the tab? 6. Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go
Absolutely. That's what it's about, justice for Charlie. That's what we want. We're going max for Charlie. We will not stop until we actually get accountability for the ones that betrayed him and, you know, true justice for him.
100%.
Is the top photo depicting one test fire on the left and another test fire from the same gun on the right?
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion, using this subjective theory of identification, show us what you're looking at.
Is it touchscreen?
Probably.
No, it's not.
No.
I'm sorry.
But we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right. So that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going. There you go. You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these 2 bullets, right?
Yes, and the
Okay.
purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are
Yeah,
reproducing.
agreed.
All right, so go to the photo on the bottom of that page. This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean? Blue index, GIMP?
So that will be the first number there is the case number, the laboratory case number. Then next 1.11B is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for groove impression. So I'm looking at a groove impression in this photo. Blue index means I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at. And then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those 2 highlighted lines near the top, there's a lot of damage that is observed and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks. Even
Yeah,
to do a
honestly, he
comparison.
shouldn't
It's
be
almost like
because
missing
there's
data.
so much evidence that
Missing
supports
is not the
that,
same thing as
you know, they have
disagreement,
nothing.
right?
It just
But
means there's
at the
nothing
same
there to
time,
call
they're so
agreement
corrupt.
or disagreement.
So do you see areas of disagreement?
I agree. I think it's, you know,
On the
he's going to,
striations
they're
that are
going to
available
find
to me on
probable
this groove
cause and go to
impression, I see
trial.
areas of agreement and specifically talking about those 2 highlighted lines at the top on the right.
Okay. Go to the next page, please. Top photo on the next page. Speak 38. You see areas of disagreement in this photo.
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those 2 highlighted lines near the top. And then if you look down, you can almost see that damage a little bit better. And there's none of those striated lines that you see on the test fire, which you would expect to see in a lander groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right. How about the bottom photo? And again, the question, areas of disagreement.
The possibility of an area of disagreement may be in the middle. There on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this photo, it does not look like it does, though.
Okay. And could you go to the next photo, please? Same question here, areas of disagreement.
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over,
Yeah,
there
me
might be some
too.
agreement that could be
I want to hear
observed,
the
but
other
the
one,
way
the first
photograph
one they
is
interviewed
now,
him.
You don't see
That's
the
what I really
line on
wanna
the
hear.
right going all the way over, but again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement.
There is an area of agreement at the very bottom of the photo.
Okay,
Correct, yes.
next photo, please. How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30X to 40X and just highlighting one specific area, and this is showing you agreement.
Next photo.
Oh, big time, because he's guilty of sin.
The fact that they're missing fragments, that should be thrown out. That should.
So again, this area that is highlighted, the bottom portion that's in focus, is showing an
I
area of
agree.
agreement.
I want to know where they
As you
went.
go up,
How do
the
you
lines
lose
are a little
evidence
bit
in the
blurred
biggest
on the
murder
6A
trial in
bullet
history?
jacket fragment, so it's hard to say if that area was in
There were
agreement or
7,
disagreement.
and
That's not
she
what
only
my
got
photo was
4.
focusing
3
on.
of them went missing.
All right.
Where's the other
Next
3?
one.
So again, this is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines that not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this
Sure.
moment.
Now this, you can take that down, please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticisms have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource, the National Resource Council,
The National Academy of Science?
National Academy of Science,
Yes,
is that a pretty preeminent scientific organization in this country?
yes.
Did they conclude in 2009 that, quote, a fundamental problem with tool mark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of 2 sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTE document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection,
there's.
objection. We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing beyond the scope of the PC hearing, as I previously objected.
I think it goes directly to reliability. That a group scientific group studied this exact process that she used in this case and reached that conclusion.
If you would, so again, I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009. And so we're in 2026. And again, I don't want to have to dive deep into areas trying to determine, because I feel that we are exiting the orbit of probable cause. If I'm having to make that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that. But
Sure. The only thing I wanted to do was establish that this was the foundation criticism in 2009. And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the take home here, is that this is not some past criticism that has been set aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you, because what I have is what's before me. I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree. And I was offering that to the court as a proffer in terms of where this line of questioning is going, so the court can understand the context.
Okay.
It isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but I will limit you to this question. We're going to more and more and more. I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burke.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016.
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question and then we're moving on, because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
And I apologize if I wasn't clear on that. So maybe it was my error not communicating. I've accepted that coming in. I've overruled the objection, but I said we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one?
On this line of question, that's correct.
Okay.
Thank you,
All right.
Mr. Burke.
And I think I've made the proffer in terms of the relevancy of it.
And I accept that. So thank you, Mr. Burke.
All right. Then the last area is in the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2020?
Says he's never even had any like
I don't remember
continuing
the exact
training
year,
or
but that sounds
anything.
correct, yes.
Right. And is it true that that proficiency
We have an
test
amateur doing this.
involved a test where
That's what it sounds like.
you had
Yeah.
question bullets, and then you
Wow.
had two sets of bullets.
He's probably
one
a
was
new
fired from
hire
one
right
gun,
after
but
he
not
died.
the suspect gun, and then a second gun that was fired from another gun.
I don't remember the exact final ground truth answers.
That's his good
that were
name for him,
there.
Judge
No,
Pissy.
I'm sorry, I don't remember.
Judge Pissy, that's his
I
nickname,
think
Judge
when you and I
Pissy.
talked about this,
He
you said
really
you were aware of
is.
a controversy about that particular test.
Oh, yeah.
correct?
I was aware, yes, of the results of the proficiency test. Yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However,
Yeah,
my
probably.
answers were satisfactory, along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive.
She said she doesn't
right?
recall
Correct.
what year she
Even
took it.
though the
Girl,
correct answer
that should be
was
on your
that
resume.
the bullets did not come from the question. The 2 did not match.
Yep.
The known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have
Agreed.
bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by 2 separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26.
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
This is my last question. So
All right, Mr. Burt. Thank you, Mr. McBride. I appreciate the heads up.
in your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure, is this?
It has not been admitted, and
Okay.
I'm asking this question, and as a foundation for admitting it.
Okay, that's fine. So I just,
Yeah.
it was on another screen. I wanted clarification. So it's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Watch, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28. Page 28. Exhibit 19, page 28. Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all 3 of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
All right. Mr. McBride.
Good afternoon.
Good afternoon.
Those last 3 photos that you were shown, had you seen those before?
I had looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Some sort?
Yes. It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No.
You actually have the item in front of you, correct?
That is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison. Is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation.
Why
of
are they
each one
not
of those, looking
why
for
are they
areas
not
of
objecting?
agreement
Because
and
he's leading the
disagreement before
witness.
rendering
You know,
a
he's
conclusion.
basically
Would it be
telling them what
responsible for
to
you
say.
reach
He's
a conclusion based on a
leading
single
her what to
photograph
say.
for a very limited area of 2 bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How
And the
long have
defense
you-
should object
first of
to
all, where do
that.
you work?
I work at the Forensic Science Laboratory in Washington. for the
Exactly.
Bureau
That's
of
an
Alcohol,
objectable,
Tobacco, Firearms, and
you know,
Explosives.
thing they could
How long have
object,
you been
something
there?
they could
A
object
little over
to.
6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices. And I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University, and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes. So part of becoming a firearm and tool mark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. And phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms using a comparison microscope, comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that, that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTI's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTI. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTI especially takes those recommendations very seriously. If the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a lab?
Should be, absolutely.
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are there principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Well, that's pulling up. And this has been published, this has been approved for publication at all 3 levels already, so we can put that on the screens. Well, that's pulling up. Thank you. I want to ask you first about an entry here. The second sentence under results of examination. Exhibit 1 is rifle was test fired and found to be in operable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibered for. In this place, it was 30-06 Springfield. Load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why do you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
In the evidence rounds that you, or in the
So
bullets
it's
that you
less
often
work?
receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damage to bullets, yes.
In this circumstance, Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case, let's see here. If you'll turn to page 2, and we've already read this line, I think defense counsel read this line to you, the Exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that this round, I'll leave it at that actually. There's been some discussion about the 6A bullet jacket fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that with you?
Yes.
Yes, please go ahead.
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
Is there a potential that the testing you do can destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled. If that's,
Yes, I think if anything, that lends to a better comparison process. It is a very well-known practice amongst firearm and tool mark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. In reaching the conclusions that you did in this case, did you follow the protocols and practices that are required by your position?
I did, yes.
Nothing else.
Mr. Bird.
You said a couple of things of interest to me. One was that your work is peer reviewed, right? There's a peer reviewer, a second reviewer?
It is a verification process.
Verification process. And you know, in this case, we requested to produce the case file from your reviewers so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an authored verification chart.
Well, you wrote a memo
That makes
to
no
Mr.
sense.
McBride dated May 19th, did you not? In which you said in answer to our request for the reviewers' work product that ATF laboratories do not release materials concerning technical reviewers or verifiers. And you went on to state, did you not, that we don't even release the CVs of who the reviewers are.
So that is not authored by me. That is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Objection, argumentative.
Counsel.
It goes to the issue that was raised on cross-examination, which is my work was peer reviewed. So how do we evaluate the strength of that assertion when they refuse to hand over to us the work product of the reviewers, or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative because we can look at the question, working in secret.
Let me rephrase.
Okay, so I am going to sustain the objection because of the phrasing. It is inherently argumentative. It wouldn't be a question that would be able to proceed into prelim.
Do you have an opinion on whether it is scientifically defensible to rely on a peer reviewer and not reveal that peer reviewer's work product?
I believe I understand what you're asking. However, in this case, the verifier does not have any work product to show. If you'd like to see their CV, I cannot testify to anything about the procedures of giving their information out. All I can say is that they are employed at my laboratory, are under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
Okay. They don't have any work product to show, but your protocol calls for, does it not, documentation of whatever it is they did?
And that is included in my case file.
Right, but not the reviewer's work product.
The reviewer's work product is a verification sheet. If you'd like, I can refer to my case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said two things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually, I think their recommendation was one more black box study to show the foundational validity of firearm and tool mark examination. And since 2016, several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to measure validity, and estimate reliability. The scientific criteria for foundational validity requires more than one such study to demonstrate reproducibility. Isn't that what they found?
That is what their finding was, correct.
Okay. And then after that report was published in 2017, they came out with a second report because people said, oh, the literature already exists. You missed it. And they said, no, that's not true. Isn't that right?
They
Objection,
concluded,
relevance to preliminary hearing. We're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Thank you. On cross-examination, that door was opened by the state, and so I will.
She's
allow any
definitely the worst
question
expert that has spoken.
on recross or redirect, however we want to label this. So you may proceed. The
Thank you.
objection is overruled.
Muted?
In 2017.
I can't, your
they filed
sound's
this
off.
Second report responding to assertions by people. in
My
your
headset completely
profession
took a
and
poop
others
on me
that
for some reason.
They had missed or the studies had already been
Dang.
done. Isn't that true?
yes.
Probably 'cause we're
PCAST did a
going on 10
2017
hours again
addendum
already.
to their 2016 report, reiterating that they believe that the only way to properly empirically test a science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
And in response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes.
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
Which webinar are you referring to?
You attended a webinar, I believe, in 2023, treatment of inconclusive results and error rates of firearm studies. Webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021.
Correct, I did.
According to, and that group has published a number of studies right up to 2026. For instance, their study in 2024 called Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons, in which they concluded that the field still was not reliable despite the studies that you reference. Isn't that true?
That is the author's opinion, correct?
Right. And they're not the only ones. There have been other groups of statisticians who have published articles right up to 2026 saying that the studies that you referenced are unreliable. That their methodology of those studies is flawed and cannot be relied upon to support the science of tool mark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that, or it was brought out that you have training and experience, right?
Correct, yes.
Do you agree with the conclusion stated in the section of the report, the PCAP report, that neither experience nor professional practices can substitute for foundational validity? Do you agree with that?
I do, yes.
You agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as the percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of the sample. To be considered reliable, the false positive rate should certainly be less than 5%. It may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity. Proficiency.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAS said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damaged samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
But you would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Okay, thank you.
Thank you. Anything further for this witness? And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you opened the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
Mm-mm.
Not at all.
No, it's not, John.
Thank you, Mr. Burt. Thank you, Mr. McBride. Thank you for being here. You are excused. All right, that brings us to a close. Do either party wish the benefit of the record before we adjourn for the night?
Give us about 5 minutes and then I think we can
Yes, you may have that, and we'll stay in court for these 5 minutes just because it would take longer to let everyone go and then come back in.
Do what? What did anybody hear what that girl said? I couldn't hear what she said. Something about staying something for 5 minutes, and he's like, "Well, we'll stay in the court for 5 minutes because it would take longer to leave and come back or something."
I guess is that a break?
I think it's over with, but I mean, he didn't know. Actually, we're not done because he didn't say, we're adjourning. He didn't adjourn the case. He said, well, we'll be back in 5 minutes or something. He said, well, I don't know what the hell is going on. If anybody heard what that woman said, let me know. I couldn't make out what she said. Somebody was screaming in the back of the courtroom, and I couldn't hear what she said. Yeah, it was supposedly a 5-minute break, but I couldn't hear why. I couldn't hear what the woman screaming was saying. Taking a break
Can we
to
run it
worship
back?
Baal again. Absolutely. Yeah, we can do that. Let's see if we can figure out what this woman's saying. Give me a second here.
18.2% for
I believe
and to
20 minutes to some point. So I will do is you're open the door. You need to come to a close.
Of course, across the country,
Yes.
and studies across.
May this witness be excused. Thank you, Mr. Mr. Burt. Thank you, Mr. McBride. And thank you for being here. You are excused. All right, that brings us to a close. Do either party wish the benefit of the record before we adjourn for the night?
Can you just give us about 5 minutes and then I think he's going to chat.
Yes, you may have that. And
She said, Your Honor, can you give us about 5 minutes and then I think we can make an announcement and something that was inaudible. And he's like, yes, we can give you 5 minutes.
we'll stay in court for these 5 minutes just because it would take longer to let everyone go and then come back in.
We'll stay in court for these
What do
5
you-
minutes because it would take longer for everybody to go and then come back in for, I don't know what the hell's going on, but apparently, yeah, we're not over with yet. Apparently we're taking a 5-minute break. I don't know why though, because I think we're done. I think he was getting ready to end it for the day until this woman screamed that she needs 5 minutes to make an announcement. I don't know who this
Yeah,
woman is that was screaming.
I don't know what he's got to go do that's so important, but
Your Honor,
it
we
seems like
have
he has.
short.
All right. Turning to the state.
I like her.
Obviously,
Hold on, wait a
I'm not
minute.
holding you to your answer
Wait a
today,
minute.
but just for guidance. Obviously,
Oh
I'm
shit, she's back. This is her. They're back again, I think. Hold on.
We're live. So court is back.
Okay, yeah, okay, we're back now. All right, let's see here. Let's finish up the day. Let's see what they're talking about.
We're live. So court is back in session. All the parties are present, except for maybe one.
Let me just say one more thing. We saw Catherine Nestor's making an appearance again, the blonde chick you like. I don't like her. She was searched in Israel, by the way, but and she's also one of the ones big time pushing to hide everything from the public. She's actually his lead defense counsel. The other ones are just working for her. But I didn't see her all day. But now all of a sudden she's in here for the last 5 minutes. That's weird.
That is weird, admittedly.
Yeah. Well, let's see what she's got to say though.
Our attorney, Mr. Grunender, should we wait for counsel?
Take maybe 30 seconds to wait for Mr. McBride.
All right, we'll wait for Mr. McBride. I just want to ensure all the attorneys are present. All right, I note the presence of all attorneys. Turning to Ms. Nestor.
Thank you, Your Honor.
Your Honor, we have just one more witness who would be a fairly short witness, not super long. So I anticipate we will be done tomorrow, probably by lunch, I would think. So maybe if we could plan that we'll be finished. We probably will not need the entire day tomorrow, is my suggestion.
All right. Turning to the state, obviously I'm not holding you to your answer today, but just for guidance, does the state anticipate and rebuttal witnesses?
Judge, we don't anticipate any rebuttal evidence that needs to be presented to this.
Hold on, I was texting. Sorry, I missed what she said. What did she say? What did Catherine Nestor say?
She said they have a very short witness to show, and she said she presumes they're going to be finished by lunch tomorrow with this.
Oh, okay. Well, interesting. If they think they can get it all done by tomorrow, great. I don't see how, but we'll see. More power to
Yeah, that's
them.
what she thinks.
Yeah.
Hearing. So I think the question would be are we going to argue the bind over tomorrow? and the state would be prepared to argue bind over tomorrow.
All right. Well, I appreciate that in regards to trying to budget time here. How much time does the state anticipate? Obviously, there's one more witness, so I'm not going to.
If it's a short witness, Judge, I don't think it should take us the entire morning. But we would be prepared to argue tomorrow morning at the close of evidence or first thing in the afternoon.
And how much time do you anticipate that argument being? Again, a rough estimate. I'm not holding you to the exact number. I'm just trying to see how close are we to the 5 o'clock, because I'm going to ask the defense the same question as well.
It wouldn't come close to the 5 o'clock hour, Judge.
For just you or for both?
For argument?
Yes.
Both of us.
Okay. All right. Well, I'll turn it. Thank you, Mr.
If we have to argue 2 hours apiece for bind over, there's a problem.
All right. Thank you.
I would say
Mr.
that.
Granander.
Thank you.
To the defense, I'm just getting an estimate. I'm not holding you. I'm not going to time you to this, but just trying to see as it relates to 5 o'clock and for argument for bind over tomorrow afternoon.
Understood, Your Honor. Our request, the defense request, is that we be allowed to submit briefing. There are some legal issues that we would like to brief for the court prior to the decision on the bind over. We're open to briefing, page limits, time limits, all of that, but we would like that opportunity because there are some legal complexities involved here.
All right. And if, and I'm going to ask the state, but if the state, well, I'm not going to assume anything. Thank you. So
I believe the state is going to object to that, Your Honor.
So what I hear you saying is you wish to, well, I don't want to assume, what it seems like you're saying, I want to be clear, is you're waiving oral argument and just doing briefing.
So generally, Your Honor, in cases with multiple counts that are pretty complex issues of law, I have asked for briefing and the opportunity for an argument. We can set time limits on that as well prior to bind over. I've done this in multiple other cases before courts in Utah. And that is my preference, to make sure we get the law right.
And so how much time, if you're asking for argument, that in addition to briefing, I'm trying to get the total universe of what's in front of me.
So I anticipate that I agree with Mr. Grunander that I don't think an argument would take more than a half day. Should take less than that, particularly if we're briefing issues beforehand. So I don't know, 2 hours for argument total.
All right. Thank you, Ms. Visser. Turning back to the states, what is, you've heard from the defense.
Again, Judge, the state would prefer to argue tomorrow. We think the court has all the evidence before it and could make a bind over decision after oral argument tomorrow. If the court decides that briefing is necessary, I believe the court reporter could have a transcript available as early as Monday of next week at an expedited, on an expedited request. With that said, each side would need, 2 weeks to, we're the moving party. We would prepare a motion in support of bind over. There would be a response and then a reply. So we're probably 6 weeks out before we can actually argue before bind over. We would rather not wait 6 weeks to argue bind over. That's why we would like to do it tomorrow. But that's the timeline we're probably looking at, is about 6 weeks and then 2 to 3 hours of argument.
So are you requesting to move forward with oral argument tomorrow and in addition to briefing, or again,
No.
I'm just trying to see the whole universe that's before me.
Good question, Judge. If the court wants briefing, I don't believe we would argue tomorrow. We would save that argument until the briefing is finished.
All right. Thank you. And to defense, would you agree on the time frame for briefing has been proposed by Mr. Grunander to allow each side the appropriate time, taking into consideration a transcript which may or may not be needed by the parties?
We are also okay with simultaneous briefing on this if the state prefers that. That wouldn't take 6 weeks if that's the concern, but we have no objection to the 6 weeks.
All right. And does your client waive any speedy trial rights that may result as this request? I just want to make sure I'm addressing constitutional rights Also going to be addressing from the victim representative. This goes squarely into the victim's rights to speedy disposition. So again, I'm just trying to take it, and I know we're late. I just want to cover all these bases.
Yes, our client will waive his right, his speedy trial rights, so that we can properly brief the preliminary hearing issues.
See, I don't know what we'd have to have a
the court wants
lawyer
briefing, we would
to
not
talk
like to do
what there's,
simultaneous
I don't know what they're
briefing.
talking
We
about
would
here
like
with
to start
bind
it out
over.
as
I
the
don't
moving
know what
party.
that means. We'd have to,
Defense would then respond. We would then have. the
matter of fact, let me
opportunity
ask
to
ChatGPT,
oral
or
argument.
let me ask Grok if he knows what bind
I'll
over means.
invite Ms. Kirk's attorney if you wish to be heard. This goes squarely into the victim's rights as recognized in the Utah Constitution as well as the Utah statute as it's what's before us.
Your Honor, obviously we want swift justice for Charlie here. I think we obviously know the court needs to make sure they're balancing all interests here, but I think as soon as the matter could be bound over and this matter could be set for trial, that's what the Kirk family would like.
But do you want to weigh in regards to briefing? Because it sounds like it's.
Your Honor, I'm hesitant to weigh in on briefing. I feel as if that is a decision which the court should decide whether or not it's necessary. And we're going to take no position on briefing. We asked for speed. This has been 10 months coming. We've heard a lot of evidence. To me, it seems rather overwhelming, but that's my opinion. Obviously, it doesn't matter. But so we just asked for it to move quickly.
Thank you. All right. Right, having heard from the parties, I will go ahead and allow, well, I'm granting the request for briefing as it relates to probable cause to allow both parties to file the briefs. With defense, as you are the moving party requesting briefing, when would you like to submit your brief? Or to the state?
Judge, because we have the burden, I believe it's appropriate for us to initiate the briefing.
Okay.
Because we're moving for the bind over, and then we would have an opportunity to reply.
And that's okay. So let's start. Mr. Grunander, when can you have your brief filed?
Just a moment, Judge.
Thank you. And in going to defense, well, I'll follow up with you as well.
Thank you.
Okay, so I just looked it up on Grok. It says, in a preliminary hearing, the judge's job is to decide if there's enough evidence, probable cause to send the case to trial. This is called binding the case over. So when the defense is saying that they want bind over, oral arguments, and a briefing, it means that the judge is not going to make a decision on probable cause right away, even after all the evidence is presented. Instead, the judge will hear both sides, the judge will allow both sides, prosecution and defense, to submit written arguments, briefs explaining why the case should or should not be bound over. They may also schedule or argue arguments where the lawyers argue in court on the issue. So in other words, we won't get a ruling tomorrow on whether they have probable cause to move to the trial stage. Instead, it'll be
We need 2 weeks after that. So
pushed back for
August
2 weeks or
11th,
3
I
weeks or
believe, is
whatever
2 weeks.
before we get a decision.
All right. And to the state, if you wish to file a reply, when
It would be 7 days after that, Judge.
It's another
So the 18th.
August 18th. All right. And for oral argument,
this
what
is
has been said is
basically it's another
first in the
stall
morning.
tactic by the defense
Let me take a
to
quick glance
give
at
them
that.
more time before it goes to trial,
Trying to keep that
which is
close in
fine
time
because they
to
should have
inform
more
us on
time,
the oral
honestly.
reasons previously stated.
You know, Erica Kirk's not going to like that
And
though.
we can
She's going to throw a
start at
hissy fit.
10 a.m.
Yeah.
10 a.m. on September 1st. How does that look for the parties?
That works for the state.
Your Honor, I'm going to be in trial that week, and I'd really like to be here for this argument. Is there any way we could just do it the next week?
The problem is, I'm happy to look, but it is getting it would be very tricky. This is a fortunate opening.
Got it. All right.
Otherwise,
We'll take it then.
Okay. I appreciate you accommodating the court schedule. September 1st, in person? I see the defense nodding yes.
Yes.
Yes,
State.
please.
All right. September 1st at 10 a.m. And it sounds like up to 2 hours per side. And can take it from there. Mr. Grunander.
Judge, page limits. We spoke as a team, and our preference would be to limit at least the initial briefs on both sides to 30 pages, no longer than 30.
Defense stipulates to that?
I'd like to counter with 40.
Okay, well, this is not an auction, but any final?
Then why did you ask? Why did he even ask what the defense wants if he's going to admonish them for saying 40?
For the final reply.
We will set it at 35 pages, and then we will go half of that.
Exactly.
He can never rule in favor of the defense, even on something as trivial as this.
17 pages
You know,
for the reply.
he can't even grant 40. They want 40. The state wants 30. He has to go in the middle at 35. He can't even give the defense a win on that little thing.
So 35 pages for the initial filing.
Honestly, they should file to have this judge recuse himself.
And September 1st at 10 a.m. Anything further for?
He really, yeah, he does.
Yes, Judge, I believe the Kirk family.
He's
there's a
crooked.
ruling that was reserved by the court with respect to publication of an exhibit that probably needs to be addressed.
Yes, and now my understanding is what's being requested is the portion that had been altered, which I believe is about 1 minute.
Your Honor, I believe it was enhanced, in that it was like zooming in and circles that were put on it. We would ask for the entirety of that exhibit to be displayed in court. So I believe it was about 8 minutes, if I'm not mistaken. Don't hold me on the time.
All right. Any final input on that? Thank you for reminding me from defense. Any final inputs? All right. What we can do is at the conclusion of defense's presentation of whatever witnesses they're going to do, we can address that. So the concern I heard was that the victim representative wanted to see what the court would consider before bind over decision is made, and that allots for that. So whether it happens right now, which the hour is late, or by right after the conclusion of evidence, that's going to help well before I consider bind over. So in the interest of justice and balancing that, I don't want to take away time. It sounds like we're going to be okay, but I always want to be cautious, but I will grant that request, and that will be played in open court, and we will watch the totality of, I believe it is State's Exhibit 12.1, which is 8, give or take 2 minutes.
Your Honor, and just to clarify, it will not be televised, correct? It's only for people in the courtroom.
That is correct. Because the request was made by the victim representative who is present in court,
right?
I will grant that request, and it will be played in the courtroom for all present to see, but not to be broadcast on TV.
And we just would like a continuing objection for all the reasons we raised before, Your Honor.
Thank you. I appreciate you making that record. I note the standing objection. That objection as it relates to this request is overruled, and that will be played at the conclusion of defense's presentation of evidence and before the state, if they do have a rebuttal witness.
Absolutely. They absolutely. They can ask for a bail review hearing at any point.
Hesitant to ask this.
I don't know if it would be granted. It probably wouldn't be granted at this point because this judge is biased, but they could ask for one.
That concludes court. We are in recess till 9 o'clock tomorrow morning.
Yeah, he's absolutely ridiculous.
I agree.
Hey, small project. I'm gonna take a picture of us. Did I get it? Yeah. Because we dominated today.
Yes, we did. Absolutely. Matter of fact, let me go ahead and I'll show that real quick. Actually, that post I made for Andrew Colvett.
Viewership domination.
Come on, cat. Stop walking on my keyboard, damn it. Anyway, yeah, so I made Andrew Colvett made this post here and I replied underneath of him. Let me make sure you guys can see this. I think you can. Let me make sure. Okay, yeah. So I made this post underneath of him. I said, I whooped your ass again today, Andrew Colvett, both you and TPUSA. Turning Point 2.0 is DOA. 2 days in a row. Hold on. I had sound going in my ear for some reason. 2 days in a row, I cooked you. You guys have tanked Charlie's legacy and the public has turned on you. Pretty sad when I get more views than both you and the official TPUSA account combined. And today's views, obviously, right here, and we actually have a little bit more than that now. But at the time I did this, it was 56,000 views. Andrew had 30,000 views and Turning Point only had 20,000 views. So together they only had 50,000 views and we had 56. So together our stream got more views than Turning Point and Andrew Colvett's streams both combined.
Woo!
That's right. Yeah, baby. And then the one yesterday, we would have done the same thing yesterday, except that my computer crashed and I had to restart the stream, which obviously killed all my views and I had to start over halfway through. But had it not been for that, we would have cooked them yesterday too. But the day before that, we cooked them again also. This is the numbers for the day before that. We did 80,000 live viewers that day, and we beat both Andrew and Turning Point as well. Turning Point had more views that day at 58. Andrew had like 30 something. So we cooked them both that day too.
Wow.
So the public has spoken, man. They are done with Turning Point. You know, they have ruined Charlie's legacy. Everybody who was a Charlie's fan has basically turned on them and left them for greener pastures.
Well, I think some of their viewership is fake too.
Oh yeah, like especially for the special events, they buy botted views for all their special events and stuff too. Especially like their Turning Point Super Bowl halftime show or whatever. That was heavily botted. There's no way that was the most watched, more views in the Super Bowl and halftime show ever and stuff. Yeah, right. No, it was faked. Very, very heavily faked.
That is
what
awesome.
a low life. This is funny. Look, this is their trolls here. You're an idiot. What a low life, LOL. On a day like this, you care about that with all your bots. You realize they have it streaming from multiple sources, right? All of them together more than yours. Yeah, okay, sure. Yeah, I guarantee you Turning Point, what do they get, like 5,000 views on their YouTube streams? No, I don't think so. So, yep.
It doesn't matter. X is the main one.
Exactly. And once again,
That's
like I
the one
said,
everybody cares about.
Yep. But right here, we are the #2 biggest live stream on X right now. Alex Jones is beating us, 130,000 live views, and we are second. We're the second biggest live stream with 60.5 thousand views. So that's awesome. So thank you all for coming and watching us today, being here with us. It was a great stream. And let's see, total for the day actually is pretty cool too. So far we've had, I mean, right now we have 80,000 watching us total, but for the entire day so far, we've had 334 people watch the stream throughout the whole day so far. 330,000.
Yeah.
So that's right. That's awesome.
Domination.
Oh yeah. So let me read.
Did you read Not a
let me-
Cat Lady? Did you see what Not a Cat Lady said?
Oh no, let me check real quick. He's sending it to you're definitely Utah definitely has its own mob-like players. Is that what you're talking about, or what are you talking about?
No, she said, can they reevaluate whether or not he should stay in jail? I guess Tyler Robinson.
Oh, yeah. I read that. Yeah, absolutely. Like I said, they can. The judge is corrupt, so I doubt he would grant it. But at any point in time, they don't have to wait till a probable cause hearing or whatever. At any point in time, they could ask, to have a bail review hearing and reevaluate whether Tyler can get out on bail or not, whether he has to sit in jail or not. So 100%.
He should be able to.
I agree.
He should, after this preliminary hearing, he should be able to.
Well, I honestly, I don't think so. I think they're going to hold him over for a trial because the judge is corrupt. But he should be let out because they have no evidence against him for sure, So I'm about to read out the last of the buy me a coffee. So if anybody wants to get in your comment one last time before we read them and get off air, go ahead. You can do it now. Scan the QR code in the bottom right-hand corner of the screen. Or if you are on, as I said before, if you're on your phone and you can't use your camera to scan it, then I will drop it in the chat for you guys. So you can just click the link if you want to donate and leave a comment. All right, there's that one. And let me do the one for YouTube. I mean, not YouTube. Yeah, YouTube now. And then here's YouTube. All right, there's the link, by the way. It's in the chat, so if anybody wants to donate, you can. We'll read out the last of the Buy Me a Coffees here, and then we will say goodbye to all of you wonderful people. And like I said, I'm so happy that you guys all joined us. A lot of you I've seen here every single day this week. So I thank you for that. Like John Q. Public, you're one I've seen here multiple days. Denny the Mark, I've seen you here multiple days. Jennifer, I've seen you here multiple days. Serena Brown, seen you here multiple days. Not a Cat Lady, definitely I've seen you here multiple days. Medusa USI, seen you here a couple days. I'm sure there's a bunch more I'm missing, but definitely all you guys, I recognize your name and I've seen you here. I appreciate you coming in here. I appreciate you watching with us. I appreciate you guys liking the stream, sharing it out, and all that. The ones who have donated to us, I appreciate that as well. That definitely goes a long way. Because like I said, we're not, I'm not monetized, so we're just doing this because it's the right thing to do. We want the truth to get out there about Charlie. We want justice for Charlie. But these 10-hour streams are definitely grueling. So if you guys appreciate it, definitely throw us a few bucks. Outside of that, also, Kelvia, thank you to my wonderful co-host, Kelvia, down here. Kelvia Campbell, who
Glad to
goes
be
by,
here.
you can follow her on X at Conservative KFC. That is her handle on X. Let me go ahead and drop that in the chat real quick as well. All right, at conservative KFC, follow Kelvia right there. Yeah, so she's got a lot of good stuff she's putting out. She's really has put out a whole bunch of really funny memes, which are cool. Plus, her and I have been working together, and we have some pretty groundbreaking
Intense stuff.
intense stuff coming out on Turning Point coming soon that we've been working on behind the scenes here. In the next couple of weeks, we'll be putting that out. So she's definitely worth following. It's a good account to follow. Also, make sure you're following. If you're not following our other guest co-host that was here this morning, Ryan Matta. Another excellent guy. We all love Ryan Matta. Follow him. I think he's on YouTube also, XN YouTube. You can follow him. And then tomorrow we're going to have Convict to Conservative. I think is going to be back. The reason he wouldn't, I found out, by the way, why he wasn't here today. I think he got hacked or something, but he said he got locked out of his X account, so he hadn't had access to any of his. Actually, I think he even said he got locked out of his phone. To be honest with you, I think they hacked all his stuff. So that's pretty horrible. But yeah, but he's actually sent me an email. Because I was wondering what happened to him, because it's not like him to just like stand me up. I was like, what the hell, man? But I actually saw he sent me an email. Huh?
I'm glad you haven't been hacked like that.
Yeah, no, I'm very careful not to click on any links or anything because I know how it is. I know how they get you. But yeah, so no, he didn't stand me up. He actually sent me an email. The only way he could get a hold of me, since he didn't have access to his X, was he sent me an email early on. I just didn't see the email until about halfway through the stream. But he actually gave me, he wanted to come on anyway, but it just didn't work out today. But he'll be back tomorrow. So check him out. Also, Jesse on Fire is supposed to be on with us tomorrow as well. So that'll be fun as well. Jesse's a good guy. I like him. He's got a differing view than me, obviously. He thinks Charlie's still alive. I necessarily don't. Although I do agree that there is evidence to support a possibility that he's alive. I'm not really buying it. But regardless, he's a good guy. He's a friend of mine. He's been a friend of mine even before this stuff with Charlie happened. So he'll be on with us. And yeah. So I guess let me go ahead and read these last few buy me a coffees, and then we will get off for the night because it's been a long day, guys. All right, let me refresh the page here one more time. Make sure if any of you guys sent something, I don't miss it. All right. Okay, so we read that one earlier. Stop genocide, start where you live. We read that one. Pack Woman, we got one from Pack Woman. Said, I thought only in Australia we had kangaroo courts, but I am mistaken. This case is clearly 100% a kangaroo court. Absolutely, 100%. This is nothing. Pack Woman, this is nothing but a show trial, for sure. Kangaroo court, show trial, whatever you want to call it. They basically, this is mainly, they've already convicted him, and this is basically they're just going through the procedures, to put on a show for the audience to make it look like they're giving him a fair trial when they're really not. I mean, anybody who's watching the trial and paying attention, like me, you, all of us watching it. We can see that. We can see how biased this judge is towards Tyler and his defense. Even his own defense is doing a horrible job defending him. So, I mean, it's really sad. But, yeah, I mean, hopefully he will get off, because he, all the evidence, all they got to do is prove reasonable doubt. They got to show reasonable doubt to get him off, and there's plenty of reasonable doubt. So if he doesn't get off, the only reason he wouldn't get off, honestly, is like I said, because they're just so corrupt, or they kill him, one or the other. Which, God forbid, let's all pray that doesn't happen.
Yeah.
And then we got one from Social East Coast that says, "Go Project Constitution, go Max." Absolutely, we are going Max for Charlie, 100%. That's what it's about. Like I said from day one, this is all for Charlie, all about Charlie. Justice for Charlie. We want to hold all of those accountable that betrayed him and that participated in his death, which some of them I believe are one and the same. A lot of the people in his inner circle not only betrayed him, but I also believe that they had foreknowledge and participated in his murder. And they all need to pay legally. Obviously, I don't want street justice. I don't wish any harm or ill will to any of these people. But they definitely all need to pay legally in the courts. I want to see them all go to jail, go to prison for a long time for what they've done. And besides that, I also, even if we don't get that, I'm happy that at least enough people know what they did, that everywhere they go, they will be shamed for the rest of their life. Erica can't go to any kind of event now without getting shouted at and yelled down, being called a murderer, a PDF file, a PDF file protector or whatever. So I love it. I hope we get more of it. I don't want these people to even be able to go to dinner without people, reminding them of the evil that they did to Charlie. I want them to constantly have that burden on them, constantly have that reminder of what they did, and feel that guilt and feel the disdain that the public has for them. I want them to feel it in their gut. These people are sick, disgusting people, man.
We have to call our victories where we can, because that judge doesn't want justice for Charlie.
No, not at all. And neither does the Trump administration or Cash Patel or the DOJ or any of them. They're all colluding together, and that's the saddest part, man. That is the saddest part. But yeah, so thank you everybody who, like I said, thank you all who are watching us, who joined us. Thank you everyone who contributed, donated a couple bucks to us. We appreciate it. Thank you to everybody who liked the stream, shared the stream, commented. It all helps get us out into the algorithm so more people see it. So thank you very much for that. And yeah, that's basically all I got. Tomorrow the stream, I believe, starts the same time, 11 a.m. again. Let me just make sure real quick. Yep, 11 o'clock. Okay, so tomorrow is scheduled to be, whether it will be the last day of the preliminary hearing or not, it's another story. But tomorrow is scheduled to be the last day of the preliminary hearing, and it's scheduled to start the same time it did today, which is 11 a.m. Eastern time, or 9 a.m., Utah time. And for Calvia, it would be 8 a.m. I think, yeah, because it would be 8 a.m. again, your time. So yeah, so that's what we got. So everybody come back tomorrow. As we always do, We will probably start the stream early, probably around 8 a.m. Eastern time, my time, Eastern time. But we won't actually be live then. We will just be replaying today's hearing to let people catch up. Anybody that might have missed it or didn't get to see it, you know, we'll go ahead and play as much of it as we can from, you know, like 8 a.m. or 9 a.m. up until, you know, they come on at like 11 o'clock or whatever, like we've been doing. And yeah, so we'll see you guys all tomorrow. Thank you so much. And again, thank you for joining me, Kelvia. I appreciate it.
Yeah,
You're definitely
always.
a lifesaver. She wasn't, you know, she came in last minute and helped out because, like I said, I thought I was going to be by. Actually, Ryan Mata helped out too. He wasn't. I didn't think he was going to come on today. He was actually supposed to come on yesterday, and never did. And so I wasn't expecting him today. But it actually worked out good that he came on today because, like I said, Convict to Conservative had something come up. He couldn't do it. And then you came on to help me out early too. So that's cool. It's easier when you have somebody to talk to and somebody to help you fill the time. Trying to I mean, it's not that bad when it's only like an hour stream or 2 hour stream doing it by yourself. But when you got like a 10-hour long stream, you know, trying to fill an entire 10-hour long stream by yourself is really rough, man. Really rough. So I definitely appreciate the help. So I thank you for joining me.
Yep.
And she is definitely
We're on the same
taken
mission.
care of for doing
We're on
it.
the same mission here.
Yep, absolutely. So anyway, so that's all we got for you guys today. Thank you all. I love you all. I appreciate you all. See you on the next one.